Serial number. Serial number 16.
1 minute.
With your prior permission, may I mention item 1.2?
The batch you can submit whatever when the matter is called. Yes.
Serial number 18, my lords.
Serial number?
Serial number 18. Senior counsel is engaged. It may be posted on Monday, my lords. He's coming from Delhi.
Monday,
Kindly, he's coming from Delhi, my lords. On humble request. Serial number 16, my lords. We've engaged senior counsel any date after vacation, my lords. Serial number 16, my lords. I request for a date after vacation, my lords. We've engaged the senior counsel.
IDFC First Bank Limited.
My lords, in fact, in this matter, notice also has not been issued. Someone's filed wakalat, my lords. I only request we've engaged. I'm not even asking for
this petition is not maintainable. We can't have no after vacation. If you want anything next week, we'll grant.
All right, any day next week.
Yes, Wednesday. Yes.
Serial number 11.
My lords, I would like to make a small submission, my lords. The very maintainability, my lords, is to be checked, because my lords already serial number 1.72. I'm appearing on behalf of the State Bank.
No, please don't mention about that batch. Independent cases will be called. You have to make.
No, I'm only on maintainability, my lords. The writ petition.
That we will see. That we will see. 11. What do you want?
Objection. Please give time.
Have you informed the council for the party in person?
No.
Then how can you make a mention? Wait for your turn. Yes.
Page number 5, serial number 22. Page number 6, 23. Page number 7, 25. Page number 8, 26 to 31.
My lords, serial number 28, my lords. Senior is engaged in another matter. He's not available.
No further adjournments will be granted.
Date
is given. Please don't
he's
make a
engaged in Mysore today, my lords.
There
has to be a counter
wherever
affidavit.
court is not concerned. When it is coming up in the, you should you just think
we
twice
had requested
before
on
making a
Monday,
mention.
on the last occasion that filed the affidavit, we have to file the counter affidavit.
No,
for respondent, my lord.
On Monday,
you
my
can't
lords.
take the court so lightly and make these kind of mentions. Yes.
On Monday, my lords.
No.
Page number 9,
Serial number 29, my lords. Serial number 29, my lords, for petitioner, my lords, my senior has some inconvenience, my lords. There is a demise in his family.
Yes,
so he has gone to write.
Please. Look at it if inform what is there. Explain. Yes.
Please, great.
page number 9, 32. All other corporate matters.
Yes. Call the list.
1. Corporate matters, serial number 1, Rajesh P.
One submission, Milad, or withdraw the petition, Milad.
Yes, take it on Monday.
Monday.
Yes.
Lord, in this item number 1,
I request the advocates to be seated. Whenever the matter is called, that advocate will be representing. This will not go like this. All of you be seated. Only the matter, Rajesh P. Where is Rajesh P?
My lord, I am for the bank, respondent number 5.
Yes.
My lord, in this case, my lord, the matter has been settled.
Respondent number 6.
One second.
Yes, give that file.
Matter has been settled. Respondent number 6, sir.
1.2, sorry.
Serial number 1.
1.2.
We are only on 1, WP 2634 of 2022.
My lord, I filed a memo before the court reporting that the matter has been settled. They have taken the one-time settlement.
Where is
4
that?
rupees 70 lakhs. It is in the
Where is that?
memo is in the court.
Look at it. Where is
Case
the
5. In fact, previous date, my lord, the order was dictated. some confusion. That is the reason entire order has been recalled in the previous hearing date.
That's why this time also I'm saying.
Yes, my lord.
Not everyone at a
Yes,
time
my-
and
yes, my-
it will become a big mess. Ultimately, it will be adjourned. That's why each matter we will call and
ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು
take that memo he has. Yes. When is it filed? Settle the loan account under the one-time settlement.
Yes, my lord, for 70 lakhs.
One, there is no representation on behalf of the petitioner. A memo is filed on behalf of the respondent bank on 15/11/2025, stating that during the pendency of the writ petitioner, the petitioner borrower has settled the loan account under one-time settlement for an amount of rupees 70 lakhs. And in view of the settlement, the cause of action does not survive. Considering the memo is taken on record. In considering the memo, considering the fact that the dispute between the parties is settled, the writ petition is dismissed as infructuous. Yes, next.
Serial number 1.1.
My lord,
Srinivas.
1.1, I am for the respondent number 3 in this matter. My lord, in this matter, my lord, the loans are separate, the agreement are separate, my lord. As many as 15 respondents have joined and filed single petitions.
Give that.
My lord, I have a preliminary objection with regard to maintainability of the writ petition. They cannot club the matter, my lord. It is not a one law. The loans are different. Under the different heads, they have taken the law. Clubbing in the one writ petition, and writ petition has been filed before this honorable court.
Yes, what do you say, Mr. Counsel?
My lord, I do not have any objections in disposing of the matter if the liberty is granted
This will be
and
granted. Why not?
protection maybe until the.
Whatever is the protection till now, we'll grant them that protection for a period of 4 weeks, so that they'll be able to file the writ petition once the court reopens.
My lord, secondly, my lord, the writ itself is not maintainable.
Huh?
The writ.
Why
My lord,
is it not?
the writ petition itself is not maintainable. It is a contractual nature, my lord. They themselves have admitted a fraud has been committed by the bank. When the fraud has been committed by the banks, my lord, under the.
On that, no arguments are required in the light of the Supreme Court judgment in respect of these kind of tripartite agreements. So we'll not go into that aspect.
My lord, thirdly, my lord, thirdly, they are before the court challenging the, my lord, the notice issued under section 13(2) of the SARFAICI Act.
What the banks
No,
have
my
to-
My lord,
No,
once again.
cases, what the banks also have to understand is the manner in which the banks have proceeded in these matters, in whatever name to be given to it, along with the builder or the developer.
My lord, we have filed a detailed objection in this matter.
In a phase where
Yes,
the
well-
construction is not even completed, why did you disburse the amount?
I filed photographs in order to demonstrate that the construction is almost over. The firstly. The secondly, my lord, I have,
1 minute. When was the construction? When was the loan?
the loan is in the year 2016. Some of the loan is in the year 2017 and 18.
Yes, 2016. Now we are in 2026.
Yes,
That
my
is
lord.
after 10 years.
Yes, my
When
lord.
did you initiate the proceedings under the Surface Act?
My lord, in this matter, my lord, I am permitted to submit before that. My lord, the dispersal details have been placed before this court, which is at annexure R9. Their case is that contrary to the RBI circular, the bank dispersed the money in a one shot to the builder. That is their case before the court ultimately. My lord, my case is that it is not, it is incorrect. We have dispersed the sanctioned loan amount in a phase-wise manner.
Let us see.
In page number 95.
Yeah, let's see. You file your objection date.
Immediately, my lord, after filing the statement of the writ petitions,
I
the next.
want the date, Mr.
We'll tell.
Lord, may I make one submission, madam?
No, let him make it clear. We'll hear him. So that one argument in all the writ petitions.
ಯಾವ್ದು?
So one argument we'll hear.
No, it may.
Page number.
Page number 95.
First of all, we'll look at the tripartite agreement.
Yes, my lord.
Where is it?
Yes, tripartite agreement.
86 of the petition.
86.
Petition, madam.
Of the writ petition.
Yes, madam.
My lord, what is the obligation of the borrower and the builder under the tripartite agreement, my lord, in this matter?
Let's see.
Lord, if Sriram Builders matters, my lord, this court is very well aware. Even one party is also a stay. When the nature of the transaction is in a contractual in nature, the writ court does not have the jurisdiction to entertain the matter. My lord, they are telling that.
Aspect will go later.
Yes,
First, let's have the clarity on the factual aspect. Then
Yes.
we'll go to the legal submissions. So please come to this.
Tripartite agreement, my lord.
Is that page number 51?
Tripartite agreement, page number 51. There's, my lord, they themselves have
51.
enclosed. It is page number.
In petition 86, my lord, in the
86.
petition,
Yes.
86. Annexure D.
If I permitted to take my lord to page number 87.
This is dated.
In all the tripartite agreement,
6th
my
June
lord,
14.
dates are vary, but the terms and
We
conditions.
will take for this the first one, 26 June 2014.
Yes,
Yes, ma'am.
Hmm. Which clauses you are relying on? Which clauses?
My lord,
you are-
87.
No, before you start, which clauses of this agreement you're relying on?
Class number 1 and 6.
Counsel for the petitioner.
my lord. Para number 14, 16, 17.
My lord,
At
before
page number
referring the
94.
class, my lord.
14,
numbers.
15, 16, 17 at page number 94,
14,
my lord.
15, 16 and 17.
Yes, my lord.
At page number?
94.
Let's read that, please
My
read
lord,
that.
kindly, I am permitted to read the scope of the tripartite agreement in this matter before touching upon the classes, my lord. The page number 87. Last paragraph. Last paragraph. Whereas the borrower has represented that the sellers are his or choice and that he satisfied himself with regard to the integrity, capability of quality of construction of the seller and the seller's ability for timely completion of the timely delivery of the project. Next, my lord, I will take 88, last paragraph. And whereas the borrower and the sellers have entered into a separate arrangement and understanding between among themselves, wherein the seller has agreed to underwrite the obligation of the borrower insofar as it relates to interest payment of the obligation by assuming borrower's interest payment liability from the date of first disbursement plus fractional period of month in which disbursement made October 2016. It is expressly stated that the seller has no liability with relation to the loan other than making the aforesaid interest payment to the HDFC till October 2016. Save and accept interest payment for the aforesaid period. The due repayment of the entire loan amount along with the interest for the same would be sole obligation of the borrower. Next, and whereas the borrower has agreed in the eventuality of HDFC granting the said loan to the borrower, the repayment of the said loan shall be secured by creation of the security interest on the said residential apartment under the finance of all right title benefits that would accrue for the said residential apartment till the currency and the terms of the said loan to be advanced or advanced. The seller also agrees and confirms that they shall take note of the said security interest created by the borrower and undertake not to create any third party right of
Where are you
security interest.
reading? Where are you reading?
My lord, 89, second paragraph.
Yes.
Second paragraph. Permitted to read once again, my lord.
No.
In wherever of the said residential apartment without prior written consent of the HDFC. My lord, there is no dispute in this. My lord, the security interest is created in my favor by the borrower. Borrower are not disputing that there is no security interest created in favor of the bank. They are agreeing that the security interest is created in favor of the bank. That is the reasons, my lord, in the previous occasions, my lord has asked them whether you want to proceed with the flat or not. The
Council, let's start the day very calm and cool. So I'm here to listen to all of you.
Yes, ma'am.
You can make your submissions without any
Yes,
any
ma'am.
kind of aggression, emotion.
Yes, my lord.
So you please tell the facts. I'll hear it.
Yes, ma'am.
So
Next,
that's
my
what
lord.
you made it. I understood. Yes.
And whereas based on several representation made by the borrower and the same being acknowledged and consented by the seller, HDFC agrees to grant a loan of rupees 5280 to the borrower in terms of the loan agreement, so on. So I will take next 90, my lord.
Yes.
And whereas HDFC has considered the said request with a clear understanding and irrevocable undertaking by the borrower, and that the subsequent to the disbursement, if any, as requested by the borrower, there would be no repayment defaulted for any reasons whatsoever, including but not limited to any concerned issues by and between the borrower and the seller. And whereas the borrower has represented such representation continuing representation, my lord, very important, my lord, that the borrower obligation to repay the said loan shall be a distinct and independent obligation, more particularly independent of any issues, concern, dispute whatsoever nature between the borrower and the seller. Expressly they have agreed. My lord, I am permitted to skip and I will take my lord to next page.
Yes.
The said loan advanced to the borrower by the HDFC shall be subjected to the borrower repayment capacity as assessed by the HDFC.
Relevant, you please read.
Yes, my
Not
lord. I will take my
clauses
lord
don't
to.
have
I will
read.
skip 2 and 3. I will take my lord to para 4, which is very relevant to this
Yes.
case. The borrower has informed the HDFC of this key of arrangement between the borrower and the seller in terms whereof the seller hereby assumes the liability of the interest payment under the loan agreement as payable by the borrower to the HDFC till October 2016. The period referred to as the liability period, and the liability be referred to as assumed liability. It is, however, agreed during the liability period, the repayment liability is of the borrower. The assumption of interest servicing liability up to October 2016 by the seller in no manner whatsoever, my lord, very, very important, my lord, whatsoever releases, relinquishes, and or reduce the liability of the borrower, and the same shall not be affected in any way manner on account of any differences or dispute between the borrower and the seller under the arrangement between them. Para 4 is very German, my lord. They very clearly, this is a tripartite agreement. They have not disputed. They have agreed this tripartite
No,
agreement.
we'll allow him to argue if you were saying that before that you want to show something. We'll hear him.
Yes, ma'am.
Yes.
My lord, in this, the only petition in this we have come before the court is to shift the liability of the loan from the home buyer to the builder based on the tripartite contractual agreement. Now, my lord, my question here is, when the builder has come up stating that he is ready to take up the responsibility of the loan, my lord, for a bank, it doesn't matter from where the money comes. As long as the loan is repaid as per the schedule, he should be having no problem who pays the loan. My lord, now the issue.
No, either you pay or he pay, the secured asset is the
Same.
flat.
Same. Now, my lord, if the builder has stated that he has no liability and the bank says that there is no liability of the builder, yes, the matter requires.
So in case they fail to pay, how will you realize that amount?
My lord, that is there in the tripartite agreement.
What it says?
Agreement, I have to proceed against in any event, my lord, the tripartite agreement is
The secured asset.
secured asset.
You will proceed against the secured asset.
Secured asset, my lord, the what tripartite, in short, my lord, what tripartite agreement say, my lord, in any event, if the borrower wants to cancel, they have to cancel the agreement between the builder and the borrower. In any event of cancellation of the agreement.
I'm saying, assuming that he has failed to repay the loan.
Yes.
How will you
We have to
recover?
proceed against as per the agreement, my lord, as per the agreement, first we have the option to proceed against the secured asset, and also for the loss, my lord, I have to proceed against the borrower to recover the money. That is what the agreement says. My lord, in this case, my lord, they have not cancelled the sale agreement. They have not come before the court.
Ultimately, you will go against the secured asset. You will recover it from the secured asset.
As well, against the borrower for the loss. After selling the secured asset, my lord, any loss, that obviously I have to proceed against the borrower.
In some of the cases, there is no secured asset at all.
All the tripartite agreement covers with the flats only, secured assets only. The respective units.
Which is supposed to be constructed, which is not constructed.
Almost all constructed, my lord, 85%, 90%.
No,
work has been constructed in this manner.
Wherever the home buyer is not interested to proceed with the transaction, and the builder is ready to take because the asset is with them, then what is the difficulty to the bank?
No, that they have to make a submission. Previous,
my lord, let us not deviate from the point,
No,
my lord.
You can't have any. We'll ask the builder. That
Yes,
is
my
a
lord.
different aspect. You cannot have any objection. Ultimately, you want the money.
Yes, my
Whether
lord,
they
ultimately
pay,
bank wants their money back.
That's it.
Yes,
It's a
ma'am.
secured asset. As you say,
Yes,
if the construction is complete in everything, then the secured asset is available for you to recover the amount.
Yes, my lord.
You appear for
My
whom?
lords, I appear for the builder, my lord, R4 and R5. My undertaking with respect to my lord, that remains the same, my lord, that we will take over the liability. My lord, may I make one more submission, my lord? If this were to be the intention, they ought not to have gone before the Supreme Court, my lord, seeking transfer of these petitions. The petitions are pending. The notices are ordered. This very petitioner, my lord, is before the Supreme Court. There are several, my lord.
You're going to withdraw that petition or
With that,
before
my
the
lord,
Supreme Court, or
undertaking,
what are
my
you
lord.
going to do?
My lord,
With that undertaking, my lord.
No, there is no order.
There is no order of stay, my lord, but the notices are
Ah,
ordered. The petitions
yes,
are pending,
yes.
my lord.
few of the
But
petition.
anyhow will not stop the petitioner from having any release from this court.
Please.
Yes.
If this honorable court is ready to grant me that loan is to be shifted, there is nothing more for me to do in that petition. This cannot be the.
We'll record that.
Yes, my lord, loan is to be shifted means, my lord, we are proceeding against the secured asset. My lord, any losses I cannot see. Builder undertakes, my lord, as on date the liability is there.
Builder, no, if that includes the loan, the secured asset, whatever rights you have against the home buyer, you will have all the rights against the
builder under the
builder.
agreement.
Correct, madam. No,
that will observe.
Yes, my lord, if the observation of this honorable court, the entire liability is of the builder, I am entitled to proceed against the builder, my lord. We have no objection in this matter. The builder, in this matter, 2021
And
matters, my
where
lord,
is your-
we could
where
have
is your
recovered
undertaking?
some portion of the amount by.
Where is your undertaking?
My lords, orally we have given an undertaking.
What
my
is
lord.
orally
during
giving undertaking?
during the course
Is
of the
it the
day, my lord.
advocate is giving undertaking
My
or
lords,
what?
during the course of the day, my lord, I shall file an affidavit also, my lord, to that effect, my lord. My undertaking may be recorded on
It
the
should have
last
been on
occasion.
record.
Senior
that
counsel wants to say
you
something.
appear for in this matter. Who is the builder in this?
Ozone developer.
You are appearing for no. Oh, in this matter, Ozone is the only developer.
Yes.
In this first petition.
In several matters, Ozone is a responsible.
Yes.
Let me point out one thing. While I understand that certainly the liability can be fastened on the developer, the question ultimately will be from the secured assets, the developer. But at the end of the day, the borrower will also have a liability. The developer, suppose the developer goes into winding up or goes into CII, then what happens is going to be another question which will have to be answered. Because it is not just going to the developer may say, I'll take over all liabilities and then undergo CIRP mode and write off the entire liability. At that point in time, there will be a question as to what happens after the secured asset says so.
No, then we have to, then in that case, we have to examine the manner in which the bank has, bank or the builder, both of them have acted. And if required, like if the court finds is any collusion, fraud between the builder and the bank, then as in the other cases, how the Supreme Court has ordered, we have to order for a CBI inquiry into this.
My lords, may I be permitted to make a submission, my lords, at this stage? I am
My
appearing for State Bank of India.
Yes.
My lords will see that this is a matter where, my lords, similar petitions have been filed and dismissed. I have produced, my lords, at least 3 judgments where these very agreements were examined by this court and have been dismissed. The same respondents are there on the ground that these are disputed questions of fact and contractual issues are involved. I can show your lordships the latest order of the this court on 2nd of March 2026.
Yes, please show.
May I make one sub? Again, the matter is getting interconnected between many banks and everything, my lord.
When we are
My
dealing
lords,
with one matter, let the petitioner and respondent argue, because it is not going to go take anywhere. Now,
no,
whoever is the bank concerned,
I am saying a preliminary objection, my lords, is that the writ is not maintainable. That is what the
that we
court
will
is
decide.
already concluding.
No, that we will decide. That we will decide.
No, if
Whether
that
it's
is decided,
maintainable
my
or not,
lord,
we will decide.
if that is decided, my lords, then we need not go into the factual aspects, because already in similar matters involving the same respondents, including us,
Similar matters of this kind, Apex Court has entertained.
No, my lords, Ozone, same respondent I'm saying. This is very same respondent. I'm not talking of a different respondent.
No,
Same respondent, same bank.
if an order of a coordinate bench of this court is contrary to an order passed by the Supreme Court, then this court can always take a different view.
My lords, there are 3 orders of the court. I'm only making a
Might
humble
be,
submission.
might be. Tell
3
the court,
orders.
the
And
Supreme Court has also taken the same view?
my lords, I would say this, my lords. Apart from the maintainability, this builder who's trying to say that he will take over the liability, etc., let it be a precondition that he will put in the amounts as demanded by the banks on to the court or to us. Let him put money where his mouth is. Let him do that, my lords, and then we are very happy. We don't have any problem. Let him put money where his mouth is, my lord. Let him not say, I will sell the property later, I'll finish it, sell it, and then I will repay you. That is not acceptable to the State Bank of India, my lord.
No, let this bank respond. Let this bank respond.
Let him
Whoever
respond to
is
this also, my lords, because one
responding
order
in this matter.
No.
Yes.
Lord, let me just add, just to try and find a solution to the problem. If the main promoters who are behind each of these entities give an undertaking to the court, they'll be also personally liable for the entire liability, which they have to, because ultimately the company doesn't run by itself, the company runs through them. If they file an undertaking for your lords, we can possibly find a solution and put an end to this dispute. And at least then, Lord, the asset is there, as well as the undertakings to your lords.
So that's what they're saying. In the course of the day, they'll file.
There's one more.
Who's giving the undertaking? One is the company.
Please, my
giving
lords,
the
I shall file an
which of
affidavit,
course
my
will
lord.
go into the CIF or whatever. But the individuals giving the undertaking is going to be different.
Who individual?
Promoters.
Promoters of the company, because company may not today is in this state because of promoters. The various individuals, Lord, who run these entities have to give an undertaking to your lordships. Otherwise,
No. Who has to file according to you?
the managing director.
That's what he's a respondent. Whoever is the respondent has to file it. Represented by the managing director.
Sir, Mr. Vasudevan is a respondent. And so also
Well, I think if they also file it, at least there's some other security around it. The asset itself.
Lords, one more aspect, my lord. At their instance, the complaints have been filed, my lord. ED has initiated proceedings, and the ED has attached, my lord, most of the properties. Those proceedings are also pending before the coordinate bench, my lord, in which they have impleaded and they are also, my lord, participating in that. There are multiple litigations, my lord, touching the same subject. That's where, my lord, they have initiated several proceedings, my lord. If there is an order, my lord, to that effect, they shall, my lord, drop other proceedings which are initiated against.
my lord.
This is what is, my lord, the complaints, my lord, at least.
I remember on the last occasion, one of the clauses
My lord, it is
point
at
out
page
that the
94.
liability of the
94.
builder. Where is that? That the bank cannot proceed against the. Which clause is
94,
that?
my lord. Page number 94 of the petition, point number 14.
Let's read it.
My lord, if the borrower fails to pay the balance amount, representing the difference between the loan sanctioned by HDFC and the actual purchase price of the residential apartment, or my lord, in the event of death of the borrower, or in the event of cancellation of residential apartment for any reason whatsoever, the entire amount advanced by HDFC will have a charge on the said apartment, and the agreement of sale of undivided share and agreement to build both dated so and so, the borrower hereby subrogates all his right in respect to the said residential apartment in favor of HDFC.
Let him read 15 and 16, my lord, further. Further, let him read.
No, let
If
him.
I don't
let
read,
him.
sir, make a
There's
submission.
no hurry, Mr. Counsel. Let him submit. Every time this is what is happening. Yes.
So that is the first aspect.
Yes.
Second, further, if the borrower commits a breach of any of the terms of conditions of this tripartite agreement, it shall be treated as an event of default under the agreement of sale or allotment cum agreement for sale, or any such agreement or document signed by and between the borrower and the seller for the sale of the said residential apartment. So it will be treated about, it talks about the documents which has been executed by the builder and this one. 16. In the event of occurrence of default under loan agreement during liability period, which would result in cancellation of agreement as a consequence thereof. Allotment as a consequence thereof. Or for any other reason whatsoever, if the allotment is cancelled, any amount payable to the borrower on account of such cancellation shall be directly paid to HDFC. Yes. However, it is further agreed between the parties that such payment made by the seller directly to HDFC shall not absolve the borrower from his liability to pay the residual amount, if any, from the outstanding loan agreement.
Yes.
If the borrower, 17, my lord, if the borrower agrees that it unconditionally, irrevocably subrogates its right to receive an amount payable by the seller to the borrower in the event of cancellation of the agreement for sale of undivided share and agreement to build, both dated so and so, in favor of HDFC, and the act of payment made by the seller to HDFC under the cause shall amount to a valid discharge of the seller of its obligation to pay the borrower such cancellation amount, and all such right, title, and interest of undivided share and constructed area will vest with the seller. Now, my lord, these are all the clauses which says what happens in the event of default or cancellation, what will happen to the loan. First, the right action of the bank should be take the they have been subrogated with the rights, call for the amount which is paid to the borrower to repay the same, including if any amount which the builder has to pay to the seller, they have a right to collect. So basically, once there is a default or cancellation or anything, the bank gets a right to collect the money from the builder, who is the real beneficiary of the bank. That is the only thing what we are seeking from. Now, the bank has disbursed. See, my lord, if the builder had not taken the responsibility of the loan, it was for me to go further and prove how developer and banker is involved, how they have played it, how they have manipulated in development. If when the builder has given the undertaking that he is taking the loan, whatever the loan amount, my lord, whether they give discount or not, it is immaterial. Relieve me from the loan. Relieve me from the loan. Still, I have a battle, war against the developer for recovery of money what I have paid from my pocket. Whether I go to ED for that, whether I go to RERA for that, whether I go to consumer case for that, or even some other writ petition seeking mandamus or anything, there are series of litigation between me and the developer for recovery of my own contribution. That is the advance amount. That will always be there. But with respect to loan, based on a tripartite agreement, which has been disbursed by the bank in violation of some rules, and which, since I'm not pressing it because the matter is getting settled.
No, you please argue on that also. What is that?
What is
the violation from the bank?
Value, my lord, there is, my lord, a concept called pre-EMI in every home loan nowadays. That is, you book the apartment, we give you the loan, and we need 3 years or 2 years to put up construction. So in the meanwhile, whatever the pre-EMI, that is before you take the possession, whatever the interest is there, that will be paid by the developer. That will be reimbursed by the developer. So this is the first inducement on which, after a point of time, the bankers send notice to all the home buyers that you yourself is responsible for the interest as well. It is not the builder. If you want, you pay that amount and you reimburse it from him or not. This is the first. Second, my lord, every home loan, it has to be based on disbursed based on the construction level. So even before sanctioning the loan, there has to be a inquiry conducted as to what stage the construction has taken place, and this is the very notification which is issued by earlier NHB, later by RBI, because of noticing the favorism by the banks towards the developers, that today I file my application. Tomorrow 80 to 85% of the amount will be disbursed to them. In few cases, except 2 lakhs, everything have been disbursed. Only for a formality, the remaining amount will be taken. In few cases, it is 1 lakh. If the loan sanctioned is 87 lakhs, in few cases, they have disbursed 86 lakhs. In few of those wherein they have disbursed 86 lakhs, the construction is still not put up. The disbursement happened on one day, single transaction, way back in the year 2016-17. Till today, the construction is going on. This, why I am giving these example is, my lord, in these.
So coming to the facts of this case, what has happened?
Same thing, my lord. Same thing.
Go ahead.
That is the problem with this present petition, because it is a group petition. There are no exact, as last time this honorable court had concluded with the same aspect, we cannot decide without each individual's documents when it pertains to this. That is the reason where I'm asking is, permit me, I am, if this honorable court permits me to withdraw this and file a detailed petition individually, grants me the time till then, I can demonstrate even in this case what has happened when it has been disbursed. I'm seeking only permission because all the documents with respect to everyone is not forthcoming. And even now, few of them wants to withdraw it because they want to take the property. Few of them want to proceed with the petition. So in this matter alone, I may be permitted to refile individually so that I can demonstrate in each case what is the.
Please come. The present writ petition is filed on behalf, the writ petitioners are water. The petitioners are 16 in number. The writ petition is filed seeking the following for you. The land counsel appearing for at the time of hearing, land counsel appearing for the respondent has taken an objection that there are 16 petitioners and each of them are having 16 tripartite agreements, and on behalf of all these persons, one writ petition is not maintainable. Land counsel appearing for the petitioner submits that some of the petitioners want to pursue the matter and they want to have the secured asset, and some of them are not interested, and in these circumstances, if the liberty is given, he'll be filing independent petitions so that he'll be able to demonstrate before the court what are the agreements and what are the violation on behalf of the respondent bank. It is submitted that there is an interim order in favor of the petitioner operating from the year 2021, whereby the bank was directed not to take any coercive steps. Bank was directed not to take any coercive steps. It is submitted that the protection may be granted for till the court reopens, and immediately he'll be filing the writ petition. Considering the fact that the reliefs that are sought before this court on behalf of the 16 petitioners cannot be considered in one writ petition, everyone has their own as their case, and the relief now at this point of time what they are seeking is not one and the same. In that view of the matter, this court deems it appropriate to dismiss this writ petition with a liberty to the petitioner to file a fresh writ petition within a period of it is 40 days.
My lord, it may be made 50 days because including the time for bringing the matter before.
Within a period of 50 days. Accordingly, this court is passing following order. The writ petition is disposed of, giving liberty to the petitioner to file fresh petitions within a period of 50 days from today. From today, the interim order that is granted till such time, not the interim order, till such time, the bank shall not take any coercive steps.
Much obliged.
Yes, next.
Question number 1.3,
1.2.
1.2.
Yes.
Ladyship, before my learned friend starts, Ladyship, there's a memo that has been filed with respect to the Supreme Court cases that are already going on, wherein transfer has been sought of this particular case. Ladyships, the notice has been issued on 7th of November 2025. And with respect to that, Ladyships, the amicus has taken cognizance of it on the orders of the Honorable Supreme Court, and a report has been prepared and being submitted before the Honorable Supreme Court. The additional facts are such that certain few FIRs against this particular builder has been registered. 4 FIRs are there, and 1 FIR has been attached in the memo itself as Annexure A3. You should have a look at that. Those particular FIRs basically shows
No,
that.
you filed a writ petition on behalf of how many? 116 writ petitioners.
Leadership, I am the counsel on behalf of the petitioners, 9 petitioners in the Honorable Supreme Court. Leadership asked me to file a memo before leaderships indicating that there is a case that is already going on in Supreme Court with that transfer petition notice order. So leadership, that memo has been filed before leaderships to take cognizance of. So similar matter of a similar issue is already going on in Supreme Court, and similar matter is before leaderships. So leadership, the cognizance has been taken by the Supreme Court. Leadership may decide what can be the best solution for it, because there cannot be 2 contrary orders of the honorable constitutional courts. That is my humble submission, leaderships.
My lord, may I make one submission? The counsel on record, Mr. Rajesh P, is unable to get permission for video conference. I don't know. He just asked me to make the submission.
Who is he? The one who is submitted?
I am not sure. I've been informed by Mr. Rajesh Pandian himself that he's unable to get online. The permission is not. It says in the VC that you'll be added to the current court once your case is called. He's not been able to log in. His case is not coming up. Not active user is not there.
In this case also, my lord.
No, but who is he? That just so he is represented.
Not. I just he asked me to.
They're appearing for whom?
Ladies, we are the petitioners. We are representing the petitioners in the Supreme Court. The memo has been filed by petitioner in person.
Counsel on record. No, counsel on record also one represents the same. Like he has to submit before the court.
Please, he may submit. The leadership has asked me to file a memo. That is what I had filed, leaderships, with respect to
How
that.
can you file a memo?
No.
Because
Petitioner in person. Petitioner in person has filed it. On 9th of January, petitioner in person has filed it.
Where is that? You appear in that
Yes,
1.2.
One of the banks. Many of the banks have been included in this matter.
How can this writ petition, 116 petitioners and going before the Supreme Court and saying, even if this matter is transferred, what is available to the Supreme Court to decide when none of the documents, nothing is before the court?
That is my first objection, my lord. My lord, this is the reasons, my lord, the borrower, 2021, they filed the writ petition. Now they are telling that you take the money from the builder. Now, my lord, they want to withdraw again. They want to see the interim order could be extended till they file another applications. This is what it is going on, my. From 2021.
It will go on. If it is not done today, it will go on. So it's good for you. You don't have to feel bad about it. At least at this point of time.
My lord, 116 petitioners.
No, but this is Supreme Court has.
Only nine petitioner is referring it to.
That's what he's saying. That's what he has filed the memo, saying that the matter is now will be heard by the Supreme Court. What is the name of the petitioner? Delphina, Nonna, and others. Where is petitioner number?
That was the previous one, my lord. Delphina, Narona, my lord. That was 1.1.
Yes, Mr. Counsel.
The present one is Veer Raj.
Delphina Norona is by Delphina Norona, ladyships.
No, we don't understand from this. Who are the petitioners?
Ladyship, there are petitions. On the first line, ladyship may find petition number 20, 39, 70, 73, 79, 95,
A memo is filed, an order of the Supreme Court is placed before the court. From that
Yes.
order, this court is not able to understand what it is, who is the petitioner, what is the relief sought.
Ladyship, may please have the office report on annexure number A1 and thereafter annexure number A2. The notice has been issued on annexure number A1. The main para 1 says delay is condoned, issue notice returnable on 13th of January, 13th of November, tagged with SLP number 7649 of 2023, which is the main petition in the Honorable Supreme Court in subvention cases. Now, Ladyship, a dusty is permitted and a soft copy is to be handed over to the learned amicus curiae, Mr. Rajiv Jain, who is looking after these petitions in the Honorable Supreme Court. Now, Ladyship,
There are
annexure number.
116 petitioners. How many of them have gone to the Supreme Court?
Ladyship, in this particular petition, 9 have gone to the Supreme Court.
So what will happen to the others?
Leadership, they have to represent themselves in the Supreme Court because a notice has been issued to everyone.
Notice has been issued to whom? To the respondents, they might have.
To the performer respondents who are the petitioners.
Writ petition is filed on behalf of 116. No, 9 will go to the Supreme Court. Because 9 has gone to Supreme Court, the remaining also has to represent before the Supreme Court.
As a performer respondent.
They have
What they are
implemented
submitting, my lord,
themselves as
petitioner made them as a performer respondent. That's what, my lord, they want to keep this petition alive without paying the discharging the liability to the bank.
Where is the counsel on record?
He's unable to log in. That's what he's mentioned.
Is there Rajesh Pandya?
Rajesh Pandya.
Is there?
How is
Yes, Mr. Rajesh?
Hello, sir.
Yep, that name is reflecting.
Rajesh Pandyan is there. You only, Rajesh Pandyan.
Am I audible, Your Ladyship?
Hello, sir. Sir, Rajesh Pandyan, please.
Am I audible, my Ladyship?
Sir, you are audible, please, sir.
Please.
Yes.
Ladyship, my first submission would be that the petitioners, 9 of the petitioners in this particular matter have already preferred a transfer petition, which the Supreme Court, my Ladyship, is seized of at this point of time. The notices have been issued and it has been served on the other side as well. We would be arrayed as the pro forma respondents before the Supreme Court. Because, my lord, my Ladyship, like the Supreme Court is now seized of the entire scheme, that is the subvention scheme. In its entirety is now put up for consideration before the Honorable Supreme Court.
They say that much. 1 second, let me come. Yeah, you're representing before the Supreme Court the other performer respondents.
No, Your Ladyship. I appear only before this Honorable Court. I represent them before this Honorable.
No, I mean to say, have they filed the wakalat there? See, he is the one.
Millards, I don't think he is Mr. Rajesh Pandyan, my lord. I don't think he is Mr. Rajesh Pandyan, my lord.
Appear on behalf of Mr. Rajesh Pandyan.
Please, my lords.
So your name, please, sir.
Abhilesh.
Yes.
Abhilesh.
No. Let's see the Supreme Court order. Where the Supreme Court has seized of the matter. Where do you get that order?
Memo, in fact, has been filed.
Yes.
On 13/2/2026.
30?
13/2/2026.
Where is that? This is not the one, this is the old one.
Yes. Okay, High Court it is formed.
Oh, not this. 13.
Today I got the details. Respondent number 15.
So this SLP is pending from 2024.
Please. Now notices have also been served, Your Ladyship.
What do you say, Ms. Senior? You are not served with any notice
we have
in
not
the transfer petition?
Not yet been served and told.
No, in this petition, ozone is also.
Yes.
Ozone is also there. Several plans are also there.
No, latest order is on January, in the month of January.
Please, Lord, in these.
Only whatever this, what the order that is passed is not to take any coercive steps, which already they have in the writ petition.
And my lord, on these very petitions, my lord, the CBI inquiry is ordered, my lord, against this respondent, my lord, the ozone. And the FIR was registered, the charge sheet is filed, my lord, before the Supreme Court now, on this very subvention scheme issue, my lord, at the instance of these petitioners.
No,
I just wanted to bring it to the notice.
no, in majority of the matters, ozone is a respondent.
Yes, ma'am.
Please.
Then we may have to adjourn all these matters.
I think so.
Maybe.
Till
The Supreme Court is pending, it may not be appropriate to.
Not only this, the issue also with regard to the ozone and other all builders.
In fact, 4 FIRs have been filed, ma'am. 4 FIRs have been filed against Ozone and India Bulls and HDFC, my lords. This is with respect to the subvention scheme and how the money was disbursed, and the investigation is ongoing as you speak.
My lords, the matter is scheduled, my lord, on 14/5, my lords, before the Honorable Supreme. The matter is on 14/5, my lord, before the Honorable Supreme Court.
It's coming up on 14th.
14th May.
14th May.
Then we take
It's part of the, it's a part of the bigger, the entire, it's a nationwide issue the home buyers are facing, my lords. So most of the home buyers have filed a transfer petition.
Then we'll have these matters in the month of July. An interim order that is granted will extend.
In fact, in serial number 1.101, I'm seeking this very same relief directing investigation to this matter, my lords, for the other home buyers. I filed a petition 1.101, 22436.
There can't be multiple investigations, my lord. The one is already pending.
No, in all these, a common order in all this, the earlier order is extended until further orders. The interim order not to take any coercive steps extended until further orders. We submitted that in respect of the similar matters where the transfer petitions are filed along with the other petitions. The matter is coming up before the Honorable Apex Court on 14th of May.
My lord,
So matter also.
there are many matters. There are no transfer petitions at all, my lord. I may be permitted to close the cases then. There is no transfer petition. The builder is not come before the court. Unnecessary, it will be tagged along with it. It has no consequences of mine.
Then in that case, wherever the matters are pending before the Supreme Court, that we will adjourn.
My lords, if the investigation, my lord, reveals the larger details, my lord, if the action is taken against, my lord, the entire assets and, my lord, against the company and the individual, my lord, that might affect, my lord, largely.
Or otherwise. But I think the issue has to be answered somewhere. And now if the Supreme Court answers that issue, then we become binding on everything. So your lordships having to answer it first. And then you're asking, then the matter going to the Supreme Court may not be a very feasible option right now, because the question is pending anyway. And now, because of the transfer, I do not know, the court may also pass an order on the transfer petition. That all pending matters may go to the Supreme Court. That is also possible. It's not just that petition, but it could be an entire set because the entire country, all petitions may be there.
No, wherever, against all these builders, wherever the
Wherever
petitions
it
are
is,
pending.
it has to
But then if
ultimately,
they transfer to the
if they
Supreme
transfer
Court.
everything, then you'll not simply be hearing this matter.
May I make my submission? Everybody who has got.
Court has no objection to hear the matters.
No. With
Only
respect to the very
how
same.
is it? How is it?
With this very same issue, my lord, the reason why the builder, I mean the home buyers had to approach the Supreme Court was this matter is pending from 2021. Only 34 matters which was in the initially filed in the 2021, an order has been passed. Final order saying that the builder has to pay the liability. Now, the bank has gone in appeal in that petition, which is pending from 2022. And since there was no movement, and they've been protected with the interim order. My lord, if at all this honorable court comes to conclusion that either this petition is not maintainable or otherwise, the interest will be calculated even during the pendency of this petition for the home buyers if in the adverse order is passed. That is the reason when Supreme Court is handling the similar matters, all these cases, petitioners, some of the petitioners, we've been trying to club that matter. My lord, if at all, if this honorable court can pass any order for that matter, so it concludes the matter.
Any order.
No, my lord. After hearing.
That's what. No. Any order that can be passed.
No, final. After hearing on merits.
On your hearing your submissions that the builder is ready to take over all the liabilities. Now the question is, now we have to think about the banks also.
Yes, my lord.
Now the entire properties are seized. There are like attachments by the ED and all. How are they going to realize this money, and how are they going to pay to the banks?
My lord, ED is not selling off the property. They have attached the property.
Then will we realize the money?
My lord, it is if once the order is passed by the, it's for the bank to say release those, we'll sell the secured asset and we'll get the money.
ED has not even attached these particular apartments. The unsold inventory has been attached.
She's saying some.
No.
Only the unsold inventory has been attached, my lord.
Not the booked ones. And there are, what has happened in these cases in Ozone, my lord, there are double sales, even now, which has happened. My lord, now at least there is an attachment that property is there. And it is a clear admission by Ozone director that the money has been siphoned. I mean, let us not go into it.
But not see all that.
It's part of the record, man. I can produce it.
I took it back. My lord, my intention is not to keep this pending for years together. This is the problem which we are facing.
Lord, these petitions are nowhere affecting them, my lord. There is an order not to take coercive steps. For the refund, my lord, they have initiated other proceedings before the RERA, Consumer Forum, NCLT. They are before
Then, my lord, if the bank say, tomorrow if the order is passed, during the pendency of petition, we will not charge the interest, my lord. If this is the one thing, let this court take it up later. But the problem is, my lord.
Burden on the banks, my lord.
That is why that is the reason I'm making this.
On the one hand, they are approaching the consumer court. On the other hand, they are going before the RERA.
What is happening? There should be a quietness this kind of litigation. It can't be kept pending for years together. No, in the event, if they're not successful, then what will happen?
We have to recover.
That's true, but who will answer to all that? With all the delays and all. There can't be any order that bank shall not charge the interest.
In fact, you should look at the conduct of the bank also, where same apartment, the same bank has.
It is a simple issue which could have been decided long back without, making this a big batch of 106 matters.
Yes.
Instead of filing the objections, if the developer had taken the responsibility in the day one, when the notice was served, all these doesn't. Even now, my lord, it has been dragging along. Even when the builder says I'm ready to take up the responsibility.
In fact, few of the interim orders.
That's the reason why I'm coming before this.
Few of the interim orders, my lord. There's a direction.
Yes, Mr. Senior.
My lord, submission, my lord.
I will just place one judgment, my lords. I will just place one judgment where similar matters have been dismissed by this court. My lords may pursue it because it is same set to ocean, same people are involved in this. Same prayers have been made. And this court has taken a view that the petitions have to be dismissed. My lords will see, please see petition number
And the same way,
15117 of
34 petitions have been allowed, which is in appeal, my lord. And even in the appeal court, writ appeal which is pending,
Interim
the
order,
same interim order has been extended, saying that they should not be coercive action. And the final order has been passed after a detailed argument, not on the statement of the builder, on the detailed argument with respect to interpretation of tripartite agreement sections, which talks about
Appeal or yet to be decided?
Well,
It appeals or yet to be decided?
yet to be decided. And again, it is being kept pending. Only if it is there from past 4 years. My lord. What I am making a submission in these cases, at least where they are ready to take up the responsibility.
That is not the case. Senior counsel is appearing in that matter.
Please see, my lords, 15177 of 2025. I just make one submission, my lords. 15177 of 2025. The order is with my AOR. Kindly see that what they say, my lords, what the learned single judge says. Same respondents. I am a respondent. They are respondent number 5. You will place a memo before your lordships. Respondent 8 is Ozone Urbana Infra Developers. I hope your lordships have got that order.
Yes.
My lords will see, respondent 8 is Ozona Urbana Infra Developers. The lordship sees the prayers. It is almost the identical prayers which are there in this batch of petitions. Now, what does the learned single judge say, my lords? Having heard, please come to para 3. Having heard the learned counsels on both sides and perusal of the prayers extracted supra, this court is of the considered view that each of the reliefs sought by the petitioner falls within the domain of distinct statutory or adjudicatory fora and cannot be collectively or individually adjudicated in writ jurisdiction. The reliefs act clauses B, C, and E seeking directions to the respondent bank financial institutions to cease recovery of pre-EMI EMI, to refund amounts already paid, and to restrain action under SURFACE Act 2002 and NI 1881 arise out of contractual obligations flowing from loan agreements. Such disputes relating to enforcement of security interest or loan recovery are amenable to adjudication before the jurisdictional debt recovery tribunal under the SURFACE Act and allied statutes. Here, my lords, there are many petitions now pending before the DRT on this issue. The grievance at clause D relating to correction of CIBIL score is consequential to loan account status and necessarily depends upon adjudication of the underlying contractual dispute by the competent forum. The writ court cannot undertake such factual adjudication. Relief at clause 1 seeking direction to the RERA authority to dispose of complaints within stipulated time squarely falls within statutory mechanism under the RERA. The petitioner has already invoked the said remedy and must pursue the same before the competent authority in accordance with law. The prayers at so-and-so seeking directions against RBI, NHB to conduct inquiries, frame restructuring schemes, initiate regulatory action against bank, pertain to policy and supervisory functions of statutory regulators. Such omnibus directions cannot be issued at the instance of individual borrower in a private contractual dispute. The relief at clause J seeking restraint against directors, developers from leaving country, etc., etc. And after that, my lords, on para 4, on a careful consideration of the nature of relief sought, this court is satisfied that this dispute essentially emanates from contractual arrangements between the petitioners, developer, and financing institutions. The coordinate bench, while dealing with similar petitions filed by the petitioner on the very same cause of action, has already declined to entertain such reliefs under Article 226 of the Constitution. Court sees no reason to take a different view. In view of the availability of efficacious alternate remedies before the respective statutory fora, no indulgence is warranted in the present writ petition. My lords have to only dismiss this humble submission. My lords, is that these petitions have to be dismissed. If they have to take it to the division bench, let them take it to the division bench.
Simple contractual obligation between the petitioner and the developer, it would be altogether a different case.
Please see,
yes.
Please see para 5. My dear Mr.
Similar kind, by this kind of giving judgments, there can be n number of other judgments. But this does not mention about the pending writ appeal or the order which is passed by the coordinate bench. There is no mention of that. Without producing that.
My lords, if I may please intervene, just to assist the court. What my learned senior just produced before your lordships, on the same day, my lords, before the same bench, was able to procure an interim order. My lords, what my learned senior has given, that has got completely different set of prayer. There, the prayer is sought against the chairman RERA. There, the prayer is to recover the monies from the builder. There, the prayer is to make sure that there is no other investigation and other things which is happening. Whereas, my lords, the present petitioners before your lordships, we have not sought any reliefs as against RERA or recovery from any of the
There are few common
lords.
prayers. I'm sorry.
That is
I'm sorry,
totally
Mr.
different.
I'm sorry,
Therefore,
Mr.
in
Ravi.
fact, my
Please
lord,
see.
what my learned senior produced, that is the order dated 2/3/2020, 2026. On the same day, my lords, even we have also got the orders where an interim stay has been granted, protecting the interest of the petitioners, my lords.
Please see, my lords, para A of this.
My lord, it
order.
is
Till
not a
yesterday there
mere.
has been orders, my lords. Till yesterday there has
Very
been
clear.
orders.
Very clear on para A. Very clearly, they talk of recovery of banks. Same prayers are there in the petition which I have been engaged in, my lords. Same prayer: seize recovery of pre-EMI, EMI, refund amounts already paid, restrain action under SARFAIC, negotiable instruments. Same prayer is there. Please come to prayer D, my lords. Prayers at clause FC is seeking directions against RBI, NHB to conduct inquiries. So
The
therefore,
same
my lords,
petition, my lords, from which
I
has
don't
been filed,
find
my
this
lords.
petition maintainable. Our humble submission, my lords, is this petition is not
My lord,
maintainable.
if
They all
anybody
want to
is
go
want
into
to ask.
No, 1 minute, Mr. Senior Counsel.
Yes, yes.
What we'll do is,
My lord, the
now,
what the senior
without going into who is going to pay, what is the obligation of any of that, we'll decide the writ petition on the merits of it.
Much of it.
Wherever the matter is pending or transferred to the Supreme Court, those writ petitions will list it after vacation. And wherever the other petitions, wherever they are arguing, we'll look at only whatever their relief, whether that is maintainable or whether they are entitled for any relief before this court or not, without taking into consideration all this, whether the builder is ready, whoever is ready, that we will not go into. That's the way I think we can do it. This issue can attain to some extent. Now, whoever is agreed will go. Whoever is not, they're happy with that. They'll proceed because this keep on. It can't go on like this.
With respect to that, leadership, there is one humble submission. There are around 13 writ petitions that are pending before leadership. If I may mark the item number for today, then leadership may keep it pending after the vacations.
Yes.
All I'm saying is ultimately the interests of all the borrowers are identical. It is not
But
dissimilar.
the problem is, borrower, whatever their interest, they want to proceed with these writ petitions, and whatever is the order of the court.
Why
they
I'm
want to
saying
take
this is
it.
because my learned friend's concern of interest and on the offers, not that I can concede to anything, but I'm sure, my lord, when ultimately Supreme Court decides the question, it will be deciding it at the national level. Because it's not just that it is peculiar to Karnataka or anything of that kind. There are subvention schemes all across the country. And since the issue has been taken as such a large issue and has actually gone into an investigation by the CBI, a report by the CBI.
No, that the Honorable Apex
I
Court will
would
be
only
dealing
think
with what is the main issue that would be decided with the Apex Court is how the disbursement has taken place, what has transpired between this builder and the developer. The developer.
No, it's also
and all those issues will
no,
be
ultimately
gone.
also what benefit the borrower must get.
In the meantime, the individual buyers, home buyers, if they make out a point that the bank cannot proceed against them at this juncture, and if this court is convinced with that, we will pass an order on that. Then whatever consequences to flow, let that so that at least their rights are decided as far as their maintainability.
One of our client got a mail from Gozon now. Recently,
Back to square one. To recover the same by initiating the success act and other provisions of law. The issue here is if the builder is going to take the responsibility by finding any bidder, then it has to be clearly mentioned that the bank should not take any action.
That's a whole difficult. Now what they say is, no, they will file bank, no, like how the senior counsel is submitting, no, the whatever is the company, the developer and all, the issues and how will the bank will realize the amount from them, that we will not decide. That we can decide. That is precisely what I want the councils to argue. only on that point.
Also, my lord, the Supreme Court is also dealing with the maintainability of these petitions.
Maintainability of the?
Of the petitions. I mean, if the Supreme Court were to decide on the matter, obviously it means that all our petitions are maintained, because in each and every case the bank's contention is the writ petition is not maintained.
No, that's what in a usual, in a normal circumstances, when this is when the contract between the home buyer and the developer, court will not interfere. But this is a case where there are several, the rights of people.
There is a nexus between the bank and the builder.
And tripartite agreement is
And additional solicitor general was appointed to the administrator today, and he is being paid around 5 lakh rupees every month to assist the court. Because the judgment has a judgment to clarify all the doubts. Because in the judgment there are 1,200 odd buyers for us. And it is again super technical. And a similar kind of matter. And all the banks.
So then we'll do one thing. Whoever is ready to argue, please argue. The remaining matters, whoever is not ready, I'll adjourn the matters.
Yes, ma'am.
Yes. So.
I think the ones which are subject to the transfer petition.
That's what he is. Yes, Mr. Satish.
Ma'am.
Who are those?
Ma'am,
what are those numbers?
Please, ma'am. Item number 1.2.
Yes.
Writ petition number 18713 of 2021.
You please give the item, the number 1.2 is fine. You don't have to give the petition number.
1.2, 1.6, 1.7,
yes,
1.9.
Others in 1.9, I am the advocate on record. We have not received any notice, my lords, from this. In 1.9, I am the advocate on record. We have not received any notice with regard to this.
1.9, we will call that matter. Yes, next.
1.8. But leadership, in that particular 1.9, the notice has been issued. The same is mentioned in the office report of the Honorable Supreme Court for transfer.
We will see, because the council on record is disputing. We'll see. Next.
1.18.
1 minute. Yes.
1.50.
Yes.
1.53.
Here also, my lords.
Yes.
Notice.
And 1.61.
Yes. Yes. All these matters.
Your Lordship, there are few other matters.
Whether all of them are before the Supreme Court, that is the question again, my lord.
No, what they say is they're arrayed as respondents.
No, it's that case is pending.
When the notice is issued, whether these people also wants to go there and all. No, and partly, no. And even otherwise also, we can't say writ petition, so and so is dismissed and so. We can't say that, because filed by all of them.
I want to make one more submission, my lord. In every matter, there is no tripartite agreement. When it comes
That's
to
why we will be calling each matter. Whoever is ready to argue will argue. Or all these matters, it is submitted that on transfer petition, the Honorable Apex Court.
Sorry to interrupt.
As issued.
There are a few other matters wherein there are a few other transfer petitions. I'll point out the serial numbers.
What is that?
He says there are some other transfer petitions.
Which are pending.
The matters are pending before the Honorable Apex Court. And the matter is coming up on 14/5/2025. List all these matters in the month of July. Yes.
Your Lordship may also include 1.3. 1.3.
3. Yes, 1.3.
1.14. 1.29.
Yes.
1.46.
1.29.
Please.
1 minute. Yes, 29.
1.46.
Yes.
1.56.
Yes.
And 1.87.
8?
87. And one last submission would be that serial number 1.8 has been settled. So I may be permitted to withdraw the said matter.
1.8.
1.8.
8 is settled.
Please, settle.
1 point.
8.
That is one-time settlement.
Please, ma'am. Parties have settled it
Who
amongst them.
appears in 1.8?
0.8.
Rajashekar is for hour.
He's only appearing, Manoj. He is for the petitioner.
No, respondent.
Oh, respondent.
They say that it is settled.
Yes, it's
Only two accounts.
all.
That we will furnish to the court.
Well, he wants to withdraw the petition.
So they want to. They are saying
They
that
want
it's
to withdraw
settled.
it.
What is your problem? When counsel appearing for the petitioner submits that they settle the dispute. The dispute is amicably settled and nothing survives for consideration. Accordingly dismissed as infructuous. Yes.
Please.
Now 1.1, 2, 3 and 4 over 1.5. All 1.5.
0.5. 1.4.
1.4 is also included. Huh? He said 1.4.
0.14.
Oh.
Since the larger interest is involved, but
1 point?
I sincerely request to take up this matter in the month of May, my lord. By that time,
which one?
We'll also prepare
Which one?
all the matter. We'll also segregate and we'll argue the matter.
Why you were in the morning? You were ready for argument.
Yeah, we are ready for argument. Most of my matters are we have prepared list. Most of my matters are transferred now.
So whatever is remaining, you please
Yes, my
argue.
lord. Most of my matter, whatever they are telling, all the
No,
matters
no,
are
the others will argue. Yes, over is the respondent. Now 1.5.
1.5. Then number 1.5.
Who appears for the Rajashekar S?
I am for the 1.5 for the respondent
Ah,
number.
there you are there in 1.5.
Yes, respondent number.
Why there is no argument in 1.5?
1.5 there is an argument again. It is a tripartite agreement.
Let's see.
Put a notice on
The council is not here. Then with this also will after the same on the month of July 1.5. Yes.
1.6.
Transfer
1.6 is transfer. 1.7 also.
Again.
Then what about 1.8?
settled. Now withdrawn.
Withdrawn. Yes. Then 1.9.
And for the petitioner, my lords, here they say there will be one of the petitions been transferred is what they are saying, but we haven't received any notice as such.
My lord, 1 point.
It's the ozone matter, my lord. So all the ozone matters.
After vacation.
All ozone matters.
After vacation. Huh? Yes, in the month of July. Wherever it's adjourned, say in the month of July. Yes.
1.10.
Lord, seek for a short accommodation, lords. We will appear in the month of.
For the respondent in this matter.
This
HDFC
also,
Ozon's matter.
this also.
My lord, serial number 10, along with couple of more serial numbers, if your lordships permit me, my lords.
No, it will be called. It is difficult for the court.
Please.
Yes.
Please.
1.11. It must be 1.
This also you want time 1.11.
My lord, 1.11. I am appearing. That is another difference.
Yes.
1.11, 1.12, 1.13, my lord.
Mm.
It is with respect 1.16 and 17.
Mm.
These are all pertains to a builder called High Life.
Mm.
He is not come before the court. Notice is not served.
Notice is not served.
On the
Why it
previous,
is not served?
no, on the previous occasion, in last year, I have filed an application for paper publication,
Mm.
which was allowed,
Mm.
setting a date for publication of before that. But while this office, while issuing the draft paper publication, it was given later date than what is it. So it should be
Yes. 1 point.
1.11, 12, 13, 16.
1.6.
Yes, and 1.7.
You have noted down that number. It is 1.11, 11, 12, 13, and 15, 16.
16.
In all these matters, Land Council for the petition submits that.
It may be taken up, dealing from these petitions and taken up separately because it's
the dealing these matters first from the batch, then Land Council for the petition submits that. Earlier, they have filed an application for substitute service of notice on respondent number
3 and 4 separately is there, my lord. In few cases, it is
on the builder.
builder.
On the builder. I think it is in 11. In 11, he is third respondent.
In 11, his third, my lord.
Huh?
Yes, my lord. In 11,
11, third respondent.
third respondent.
12 also.
12 also respondent number 3.
3 in 13. R4. What is this in 1.13? It says memo for reporting settlement.
I have not received anything.
Who is R5? PNB
PNB.
Housing Finance Limited.
PNP.
Who appears for PNB?
1.13. Memo is there.
Look at it. Take out that bundle 1.13. No, I'll pass order in this independently so that it won't give 1.11. Take it in that. Take the give that order earlier order. Show that earlier order in 1. Yes. But there is no order in this 1.11.
My lord, it was all clubbed together in the main petition. The order has been passed, my lord.
Which is the no for substitute service.
Yeah, the orders which was taken individually and in the main case, even the substituted service.
Date of order.
Main case.
For substitute service of notice. What is
It's in 18713 order, my lord.
18?
18713 of 2021.
Which is that file?
Battery is not settled, my lord, in this matter.
It's a mistake.
By mistake, it has been done.
Huh?
We filed objection, statement of objection.
No, we will by mistake we'll take it for take on record and record it.
No, we have not filed any memo. We are searching. We filed statement of objection in this matter.
No, at least to say, as per the earlier order, we have to pass another order. I don't find that order.
I will give it, it may be passed over. These things, I'll give you the details of when it was passed. Order was passed.
Land counsel for the petitioner subject, sir. He has filed an application for substitute service of notice on. Look at it. That is a file, the respondent number, the builder, whichever is the respondent. And by the time he has received the order, the date that is mentioned to take out the substitute service, by the time is already elapsed. Considering the same, the petitioner is permitted to take out substitute service of notice. Mention the respondents also.
Yes, ma'am. I will.
Give it to the on respondent number so and so. On or before?
One submission I would like to verify.
1 minute. On or before so and so.
Before that, 15th May.
And mentioning the date of hearing as in the month of July.
July.
Hmm.
Because in 1.8, not only HDFC Bank, some of the banks are also there. They have to clarify that whether all the petitioners they have settled with the builder law, because I appeal for the Axis Bank.
Hmm.
1.8.
Anyhow, they have withdrawn. They are doing it at their risk. You have no problem. If you can proceed, you proceed. They said they have settled the dispute. We have recorded it and dismissed. Now you proceed if your debt is still. So the numbers is 11, 11, 12, 13, and 15. This order he will furnish the details. 16, not 15, 16, 17. Yes. Then what about 14?
1.14 is also, there is a petition before the Supreme Court.
Yes, 14 also petition. Then 1.15?
My lord, that is ozone matter, my lord. It may be taken up.
1.15 after vacation, the
Interim
month
order
of
to be.
July.
Interim order to be.
On all these matters, this has to be dealing from the one which I said to take substitute service. All these matters has to be dealing from this by.
Interim order to be extended.
In all these matters, because independently they'll not be writing it. It would be a common order.
Yes,
so and so, so and so. In all the matters, the interim order is extended. Yes.
1.8.
One point eight is again the Supreme Court matter. Yes.
1.8.
1.18.
Next 19.
1.18.
Ozone matter, my
1.19.
My lord, in this matter, direct them to serve the copy, my lord. 1.19 and 1.120.
1.19, 1.20, the petition shall serve the copies on the respondent bank. List these matters in the month of July. Then 1.21.
2-1 and 2-2, my lords, so kindly short accommodation, my lords.
Ozone matter.
And then-
Ozone.
Yes.
Ozone matter,
After,
please.
after, in the month of July. List these matters in the month of July. Yes, 1.22.
1.22.
22.
2-1 and 2-2,
This one-
same, my lords.
Yes, this also in the month of July.
1.23.
I am for the petitioner, my lord. I am ready to argue. If for all my cases, a date may be fixed, I will argue on that day and finish it. If this honorable court, if this court insists, I am ready for the argument. But
To the respondents in this.
my lord,
Who appears to the
I
respondents?
am for the respondent in this matter. Respondent
Ready
number 4.
1.23.
Respondent number 4. PNB matter. What they are telling, my lord, the matter is seized before the division
No,
bench.
no, this is not.
Similar.
yes, my lord, it is very similar. It's a very same, but not the same builder.
No, he says the matter is seized off by the apex court. This matter.
Not
No,
apex
my lord,
court,
no, my lord.
division bench.
Division bench.
How can that be? It is very similar matter, but it can be
Not
disposed
this
of.
matter. My lord, in a similar kind of matter, the coordinate bench has passed an order. My lord, that's what the senior counsel was submitting. That order has been stayed by the Supreme Court. Same builder, same project. My lord, if you want to argue, let him argue. I will also ready to argue this matter.
This is my lord. All these are belongs to belongs to monthly developers and with as against PNB. Coordinate bench has allowed the writ petition, which is challenged by which is pending before writ appeal now.
Stay is granted.
Stay is granted. The protection is also granted.
No, in the light of that order of
My lord,
all these writ petitions have to be allowed.
there is an order which says that
Monthly, all these matters where already a learned single judge has allowed it, let it be allowed. If you're agreed, go, all will be decided.
it will go and join the same.
Huh?
Take instruction from the client. Anyway, fix upon date in this matter.
Instructions on what?
From the client regarding.
Which are monthly developers
This is
matters?
1.23, my lord.
Write down 1.23.
And there are another 10-15 matters.
Here.
1.93, man. 1.93 as well.
1.93.
93.
1.23, 1.93. List these matters on 9th of June. 9th of June, these two matters.
If it is only about the instruction, if they have to take, it can be before vacations. If
time permits.
List these matters. Because there's no time, then that's why I fixed it only today.
I leave it to your lordship.
When do you get? When can you get instructions?
My lord, after the vacations, my lord, my instruction.
What instructions you want?
My lord, in this case, my lord, I will permitted to submit. My lord, the argument which were addressed before this court, before the coordinate bench, that not even a single bricks has been laid in the project.
That order?
That order. That was the argument, my lord.
Where
my lord,
is
my
that order by the
submission is that
single
most of the.
It has been
my lord,
placed in the common.
Towers are over.
Next occasion, I'll.
You have a copy of it.
I will place the copy next. And construction is completed in this matter. Construction is completed. Most of the units are ready for occupations.
We are ready for argument. A date may be fixed. I'll convince this court.
Yes, on the day. 8th of
It was 1.93. We entered in a settlement agreement with the developer.
1.93 also.
93.
1.93 and 1.23. List on the. Yes. Next 1.24.
Kadashiram AN.
This is ozone.
In the bank.
Huh?
1.25.
In the month of is 1.24 July 25.
25.
This is
Ozone matter, my lord.
ozone matter.
Yes, July.
1.26.
Ozone matter, my lord.
July.
1.27.
It may be fixed on the same day, 9/6 for argument.
1.2796.
1.28.
My lords, I appear for respondent number 4 bank in this matter. I seek for a short accommodation of time.
ICICI Bank, Lord. In this, I appear for respondent number 3, ICICI. And in this, my lord, there is no tripartite agreement.
Then we will delete it from let this come on 9th, 1.28 on 9th.
Cell number 1.29.
Transfer.
Rajesh.
They
Transfer
submitted that
petition.
the petition is
1.29 is already Supreme Court matter. Yes, the next 30.
For R1, my lord, if this is a different builder, my lord, Raffles. And this is PNB, my lord, I'm ready, my lord. So
You're ready?
my lord,
For R1, my lord.
I'm not.
I'm for R1 in this.
We'll take it on 9th. This matter, I'm segregating it. I'll take it on 9th. Wherever the councils are ready, that will take up on 9th. List this matter on 9th.
My lords, one submission in respect of this matter.
1.3.
1.3. The list shows that our respondent number 3 is unserved. So if they want to take service in respect.
No, and so far as the bank have already taken, given.
You have the time. Take out.
It's RBI, my lord. I've already served the council itself for RBI.
R3 is RBI.
RBI.
But it doesn't show the list.
That's my
The
submission.
name may kindly be shown.
To whom you have served?
Same council in all the matters.
To whom? What is the name?
King and Partridge.
So and so. Print the name of so and so.
King and Partridge.
Then 1.31.
1.31.
9th June, my lord. 9th June, my lord. 1.30.
9th June. In all the matters, it will be extended. Don't have to ask. 1.31.
I am for the bank, my lord. Direct them to serve the copy in this matter. 1.
Serve the copy on the council for the petition. Serve the copy on the respondent councils. This is also ozone.
Ozone.
Yes, this is July.
1.32.
My lord, for the petitioner, I'm filing a memo of withdrawal.
Take that. Memo is for seeking to withdraw the petition. Memo is taken on record and dismissed as ozone. Next.
1.3.
I appear for the petitioners. Well, in this particular petition, I filed an application.
This is ozone.
No,
this is not ozone.
Vivan's Vigicom.
Yes.
I filed an application on 17/12/2024 seeking to carry out paper publication.
Yes.
As against R7, 9 and 11.
The I number 1/24 is filed for paper publication. Respective service of notice to R7, R9 and R11. Same, the petition is permitted to take out the paper publication on or before so and so. Give the dates mentioning so and so. Yes. Date, give 9th. Yes. 3/4.
1.34.
Again, ozone, my lord. Direct them to serve.
Yes. Yes.
Direct them to serve the copy.
Ozone, my lord. 3.5 is ozone.
Yes.
My lord, 1.34, my lord.
1.34 papers to be served on the council for the respondents. Yes, 1.36.
Please, madam.
Appearing for petitioner, my lords, in this case, it's a GVG. I will file an application for serving a notice for the builder by paper publication.
Then we'll give it this side of the vacation or after vacation.
After vacation, my lords.
Then council for the petition shall file the appropriate application for seeking for substitute service of notice on the builder, that is respondent number
7.
7, list on 8th, on 9th. Yes.
Cell number 1.37.
38, 39 and
Up to 40.
40. Ozone.
Up to
Yes.
4.2.
4.2.
Up to 4.2 is ozone, but these people have never gone before the Supreme Court. So if it has to be heard, it may be posted along with the 9/6 matter.
No, but that is what is now agreed, that all the ozone matters, because ozone is before them, and instead of having so many orders, let ozone be decided by the honorable apex court. Wherever it is not there, we will. That's why the mother matters.
I would request. My
Yes,
lord, my concern is only this. See, I accept with respect to others, they want to go ahead with the CBI inquiry. They have to go ahead with the ED. They want to get justice, all that is. All these people who are ready to close their loans, they want to close their loans.
Again, it fall back to the same thing, that the builder has to give an undertaking. And how the builder's
But
undertaking
when they are
will
ready,
work
my
out.
lord, that is the reason why I'm convincing this
But I'm
honorable
telling you,
court.
if you're ready to argue, saying that as per the agreement so and so, they cannot proceed against me. They can only proceed against the builder. If that is the legal argument you want to make, then I will hear it. Not on the concession of the builder.
But once they have given an undertaking that they are ready to take, My lord, it may be taken up on 9/6. If
Yes,
the
ninth.
order has, otherwise
Yes.
I'll make a submission to tag it along.
9th. 40 and 40,
Up to
41,
42.
42.
From 37
Not
to
all.
42.
Only 40, 41, 42. He's asking.
No, my
Even
lord, from 37 to 42. All are
All are
ozone.
your matters
All are
only.
ozone, my matters.
From when? From which matter?
1.37.
37 to
1.42.
42. 37 to 42, 9.
1.43.
Ozone, my lord, after vacation.
Yes, after vacation. That's July. 1.40 July.
1.44.
Hey, my lords, ozone, my lords.
Ozone matter.
July.
My lords, in this, I appear for India Bulls, my lords. I'm not, notice is not issued to me and I'm not served a copy. The petitioner will be directed to serve a copy, my lords.
Your which, what is your arrayed as respondent number?
1.46. Just to
0.54. I don't have the petition, my lords.
1.
Chetan Chandrasekhar, who is, where is the advocate?
My lords. Okay.
No, India Bulls is not a party.
Party?
4 in the
1.44 July.
1.45.
45 Sharon ABT.
For petitioner in this case, previous state as per direction, I am filing a memo in respect to which is cases are pending on same.
Is that memo taken? No, that is the old story. Now it is not required.
Please,
Is it ozone?
Yes.
Yes.
July. Still no
July.
1.46. 46 is
4.6 transfer.
4.6 is transferred. Yes, 4.7.
4.7.
4.7, I appear for the petition.
Ozone again.
This matter is settled, my lord. This may be dealing. Whenever the parties sign the agreement, we will file it before the court.
When counsel for the petitioner submits that the matter is settled, they'll filing appropriate memo before this court. List this matter on 10th of June.
No, not on 10th of June. Last week of June.
On
Because
24th
parties
of
are
June.
not there in India. That's
24th of June?
Please.
Yes.
Still number 1.48.
4.8 is ozone, my lords.
Ozone, July.
July. 4.9 are
4.9 also ozone, my lords.
July. 51.
1.50.
50 is Supreme Court. 51.
My lord,
1.51.
I'm for the R6.
In which case?
In case of 1.51. So request short accommodation because we're preparing objections.
9/6, my lord.
9/6. Yes, 5-2.
Ozone again.
Ozone, July.
5.3 transfer.
Ozone.
Supreme Court. 5-4.
Ozone.
Ozone.
July.
It's on July. Yes, 5-5.
5.6 transfer, my.
5-5 ozone, July. 5-6 transferred. So that wherever transferred, you don't have to take. That she has already taken. 5-7.
Lords, I am for 5/7. 5/7, I appear for the petitioner, my lord.
I'm 5.7, I undertake to file.
File. The
5/7, I'm ready to argue the matter today itself. It's a different developer. It's Ghulam Mustafa.
There, sir.
I'm ready to argue. There, sir, man.
Who represents that response?
Lords, I am for R8 and R9.
In 57.
Please, my lords.
R7. What's your name?
Lords, he is R7.
R7. Write on a paper. R7. So, when counsel so and so submits that he has instructions to file wakalat. You?
Lords, I am Manu Kulkarni for R8 and R9.
R8 and R9. Write on a paper and give him.
Please.
So and so has instructions to file wakalat. Then?
Lords, R10 is no more. I'll file a memo, my lords.
R10?
Is no more. R10 is expired.
Yes. Then?
I'll file a memo.
What about any other respondents in this?
R5. We'll
1
file
minute. R5, who appears?
TP Muthan actually.
Already there's a name R5B and Tulsi Kumar is there.
Tulsi Kumar.
It's already there.
R5.
Ready?
Lords, I have filed objections. Lords, it's not maintainable vis-a-vis me. I'm ready, my lords. I'm ready, my lord.
I'll take up this matter. Keep 1.57 up.
The serial number 2 is entire of the same developer itself, my lord, Ghulam Mustafa. So I'm
We'll
ready
take
with
it
the
up
matter.
on, will this also along with his matters on 9th. It will be dealing from this. It will come up on 9th.
There are 3 matters where Ghulam Mustafa is there in the.
While we are calling you, please tell the dates.
Yes,
9th, this matter on 9th. 9th July.
1.58.
Ozone, my lord.
Ozone, my
Ozone.
Yes, this is, no, this is June matter, 9th June. This 158 July. The
59.
July matters don't give the date in the month of July. This 1.59,
Ozone, my lord.
yes,
My
July.
lord, they have to give the copy, my lord, in this matter.
Yes, my lord.
Counsel for the petitions.
This is the second time directed them to give the
Give him
copy.
today.
I'm proxy counsel, my lord. I'll inform the counsel.
Yes, 6-0.
My lord, it's an ozone matter. Can R4 RBI, the standing counsel, be directed to take notice, my lord? They're appearing in all these matters.
R4.
R4.
Who is appearing for R4?
Reserve Bank, my lord. King and Partridge was appearing. They were here in the morning.
So and so, write it on a paper and give for R4. So and so is directed to take notice. Is this pertaining to ozone? Yes, this is July. Yes, 1.61 not necessary. 6-2.
Ozone, my lord.
Ozone July. 6-3.
Ozone, my lord.
July.
4.
Lordship for the petitioner, 6.4 and 6.5 pertain to a different developer. In 1.64, I filed a memo with almost 6 cases which are connected to the same developer. They all have to be taken on a separate date.
No, this developer is served.
All parties are served in this.
Served. No, this is, no, whenever the matter comes, you can tell. Now we can't take up all that. No, they are not listed today, they are connected.
I filed a memo in
Where is that?
1.64. It's part of the file, Your Lordship.
Look at it. This, in which case you filed the memo 60?
Article 6.4, I have filed the memo.
6-4.
And I filed it on in the month of
In
September
6-4, in 6-4, just look at it. Council has filed the memo where there are some other connected matters. So along with 6-4 and 6-5, the other matters in that memo, they shall come up on 9th of June.
I request another date, Your Lordship. Only for me.
Or why you want a different date? Huh?
Certain factual matrix change in this.
Then those matters on 11th of June.
Please, great.
Yes. 66.
I'm appearing for petitioner in this case. Respondent number 5 is a builder.
Huh? No. Yes. 11-6. Yes.
0.65.
6-5.
Same
6-5,
matter,
they made a
6-6.
submission. Yes. I'm petitioner in 6-6. My lord, respondent number 5, I'll take a paper publication. The same. GVG and CMR are the one other the same builder, my lords. I'll take a paper publication for R5. And R2, it is National Housing Bank. My lords, in serial number 136 for the housing.
Don't confuse the court. Only 1.66. Whatever you want to tell, you please tell.
My lords, the 2 respondents' notice are not served. One is builder, that is respond number 5.
You will take out substitute service for him.
Yes, my lords.
Yes.
And for the respond number 2 is National Housing Bank, for which learned advocate Akash B. Rao is appearing.
In this case, that
He
is
may be
respond-
directed to take notice, my lords.
Respondent number in this case.
Respond number 2.
Mr. So and so, write a name and give to the court officer.
Yes,
So and so
my
is directed to take notice. Then council submits that as far as the builder is concerned, is our
Builder is respond number 5, my lords.
respondent number 5. They'll come up with an application for substitute service of notaries. This is matter on 4th of June.
Then number 1.6.
1.67.
That is ozone matter, my lord. July.
Ozone matter, July. Yes, 6-8.
Same, my lord. Ozone matter.
July, 6-9.
9.
Lords, 1.69 Lords, I seek some time to move fresh address of the respond number 7, the builder. I have recently found one. Lords, same for 1.70, same for 1.
July, 1.7 also, July.
1.71.
Lords, 1.71 also same. Lords,
72 also same.
1.72, Lords, 1.72 to 1.74 are ozone matters.
My lords, 1.73 copy not served.
Huh?
1.73. I appear for the respond number 5. The copy not served.
Serve the copies on the respondents.
Sir, we'll serve.
1.74 also, 1.75, 1.76, 77.
Lords, 1.75.
78.
In,
Yes.
Lords, in
next.
1.7.
1.7. Huh?
Lords, in 1.76, I am appearing for the petitioner. Lords, I am seeking some time to move for paper publication.
Yes, I've already adjourned. They'll come in the month of July. Yes, 1.79.
79.
Lords, 1.79, I am appearing. Lords, I am taking time for paper publication. Same for 1.81,
Yes, this
1.82.
also July. Yes, 1.80.
1.80.
Lord, 180, 183, 184, 1855. Lord, seeking time to move for fresh address of R7.
All
Where-
this.
Wherever the copy not served, my lord.
0.86. 0.86.
Yes, 1.86. Because.
My lord, sir, urgent, my lord. Ozone, 1.86. urgent.
Yes, July.
0.87.
87 transfer.
Answer transfer. 88.
88.
Hello, Ozone. My lords, in this case, the asset itself has been sold to some third party. Ozone has sold this particular apartment, someone else already.
Yeah,
my lord.
July. Yes, 89.
1.89.
Transfer.
Transfer.
No, it's not. He didn't give this number.
1.89.
87 only.
Transfer?
Transfer.
Yes, this also July.
July.
Yes.
1.90.
Ozone.
My lord, this is ozone.
1.89, whether she has taken or not, remind her. Tell her in the transfer thing. Tell her not his. Yes, 1.9.
1.9.
1.90 is ozone, my lord. Here again, if RBI can be requested, the standing counsel for RBI, my lord. R3.
For RBI, so and so is directed to take notice.
1.90. Yes.
This in the month of July. 1.91.
1.91, it's Ghulam Mustafa. It's on. My lord has directed it on.
So this 1.91 July 9th. Yes. Yes. Who? You offer R?
R7 and 8.
R7 and 8. Who is the council? Take that.
I may be.
You please mention and give it also. So and so takes notice.
I may be permitted to serve R3, the standing counsel for R3, RBI.
The in this 1.91.
1.91.
0.91. 7 and 8, so and so appears. It submits study as instructions to file wakalat. Petitioner is permitted to serve the copy on the counsel appearing for the RBI.
Interim
Yes.
order may be. Interim order may be kindly extended.
1.92.
1.92.
Yes, who appears in 1.92? Akash or
Yes, my lord.
Share 20.
Ozone, my lord.
Ozone.
1.92.
Yes, ozone, July.
And 1.93.
93 is
It has been
96,
given
my lord.
96.
Monthly case. Yeah.
Then it's on 9th, 9th of June. Yes, 1.94.
94.
Ozone, my lord.
Ozone, July. 1.95.
Ozone, my lord.
July. 1.96.
1.96.
My lord, they
Sadanand.
Sananti Shastri.
directed them to give the
Ozone, my
copies.
lord. In that's ozone. That's also ozone, my lord.
Ozone,
Sir,
July.
copy could be.
97.
Let them serve the copy, my lord, 1.96.
There will be a common order in all the matters.
Yes, well,
wherever no.
there will.
Yes.
9/7 I appear on behalf of petitioners. Ozone.
Is it ozone? Yes, July. 9/8.
Still 102.
It's all full.
Miss 101 is that investigation, not.
No, I'll call, you can tell. It's unnecessary confusion. 98 ozone, July. 99.
99 ozone, my lords.
100 July. July.
101.
No, it's not about Supreme Court. They say that the ozone matter now the Supreme Court is going to decide. So all, and there are several proceedings against them. So it can't be independently passed. That's why all ozone matters are taken off this. Then this 100 on 9th, 100 on 9th. 9th June.
101 is that investigation I'm seeking, my lords. It's nothing. It's the investigation seeking between the builder.
One also 9 June.
Petitioner, my lord, it's matter.
Sir, 101 copy could be.
102.
Pertaining to ozone, my lord.
Yes,
My lord, R6 copy has not been served. It is reflecting. For R7 is also ozone Urbana, my lord. Vandana PL has been represented, maybe directed to take notice. I'll serve the copy, my lord.
Yes.
Cell number 103.
I appear for the SBI bank. The notice is not served.
In 103, my lords, 103, my lords, I'm appearing for the petitioner. Notice has not been issued yet, my lords. Notice has not been
Notice
issued,
to
my
all the
lords.
respondents.
And my lords, also in serial number 103, my lords, interim order has not been granted, my lords. Kindly interim order may be granted.
103, notice to all the
103.
respondents.
R6 I am undertaking.
For R6, you have seen who is R6 in this?
R6 is.
Noted. R6, this is Xavier. R8. What is the full Francis Xavier?
Francis.
Is directed to take notice, and R8. Nandish Patil for R8. Remaining respondents issue notice.
My lords, interim
Yes,
order is to be
104.
granted, my lords. My lords, may I submit, my lords? In
What are you
103,
doing from 25?
interim
You're
order.
okay with that?
My lords, in 25 December, I have filed the petition, my lords, and after that, the matter was connected to these petitions, and your lordships solved.
Yes,
My
104.
lords, the interim order may be granted, my lords.
Yes, 104.
104. 104.
This matter pertains to, in this notice is not ordered, I think. Notice to the non-taking of hand summons in respect of
Well, for
R2.
HDFC, we are accepting.
Huh? Notice to all the respondents, petition shall take the steps. Yes, 105.
105 appearing for the petitioner. Ghulam Mustafa, it has to be taken up on 9th June.
105, June 9. You are appearing for which respondent?
Respondent number 7, my lord. The developer Ghulam. I've given it in.
AC 7?
Yes, ma'am.
No. In this writ petition, is for respondent number 7?
Yes, ma'am.
My lord, I've given that list where I've noted the serial number.
Just check that. So appears for
Ghulam
respondent
Mustafa
number-
is respondent number 8, ma'am.
That's what. For respondent number 8, Mr. So-and-so represents. Yes, this is on 9th. Whatever objections?
If a copy may be served.
I will pass an order that in all the matters, papers have to be served on the respondent.
Yes.
106.
I appear for the petitioner, my lord.
Petitioner, my lord, 106.
106 Mukunda.
Rachna.
Pradeep Hedges.
Pradeep HS 106.
Yes.
I appear for the petitioner, my lords. This is pertaining to ozone.
Yes, July.
Interim order is not granted, it may be granted, my lord. Interim order is not granted, it may be granted.
Yes, next.
Apologies, my lord. My lord, I represent for the petitioner in 104, my lords. There was a slight confusion. 104, I have already served the copies on the respective councils, my lords.
But there are no councils and
my,
where are
my
the-
lords.
how many respondents are there?
All the respondents, my lords. I have filed a memo for proof of service, my lords.
How many respondents are there in this case?
7, my lords.
It doesn't reflect so. Shanti Bhushan for R1.
My lord, I have served on Mr. Kushalappa, my lords.
For respondent number 1, I have.
For
I
respondent
have already
number
appeared. Respondent number 1.
104.
Only
104,
one.
my lords.
104, I appeared for respondent number 1 only.
He's already
Kushalappa,
appeared.
Already
R1 all, then what about the other respondents?
I have served on all the respondents, my lords.
Where is the memo?
My lords, I filed it on 15th of December, my lords.
In 104.
Yes.
When counsel for the petition submits that, they have served notice on all the respondents. A memo to that effect is filed. Registry is directed to put up the same. Yes,
Interim order may be extended, my lords.
yes, next.
My lords, 106, my lords.
Not 6.
Interim order is not granted. This case pertaining to ozone.
Serial number 2.
106 is July. Yes.
Serial number 2, my lord. Serial number 2, I appear for the entire serial number 2, my lord, from till 2.31. These are all same Ghulam Mustafa matters itself. my lord. And
So undertakes and we'll have it on
9th of June, my lord.
yes.
One submission there, ma'am. I have already served on the respondents. The office has to rectify the objections that have been raised.
It shows it's been served in some that haven't. If a copy may be served on all
It
matters.
is submitted that in all these matters 2 and 2 point so and so on the he has given his name and all. There is so and so submits that he has instructions to file wakalat on behalf of the respondents. Learned counsel for the petitioner shall serve the copies in all the petitions to the counsel for the respondents. They'll come up on 9th.
One submission, ma'am. I've already served it and I filed acknowledgement on 15th of December, my lord. For all of these petitions, I filed an acknowledgement.
Just verify.
I'll serve another copy to
It's for
them.
your
Yes,
benefit.
yes,
If you don't serve,
yes,
you can't come with
definitely.
instructions.
I'll serve.
Yes, it will
One-
all come up on 9th. I'll not grant any further time.
Yes, ma'am. One submission in that manner. On both the last occasions, it was directed by my lord that the interim orders would be extended in all these
Now,
32
what
matters.
will we do is, in all these matters,
Yes, ma'am.
there will be a note saying
Yes.
that interim order is, interim order, not, I will not even say extended.
Yes.
Not to take any coercive steps until further orders, I'll mention in that.
Yes, ma'am. It is just that in last 2 occasions, it has not been mentioned because of which the banks have been
Which will be
sending
mentioned,
emails
which
to us.
will be
ma'am.
mentioned.
That's
I
fine.
specifically say
Yes.
not to take any coercive steps.
Yes.
without even saying that interim order earlier granted extended. Yes.
Yes, much obliged.
Yes, call the list next.
List number 2.
List number 2.
List number 2, hearing on interlocutor application, CL number 1. Guru Prasad, Gurudev Prasad KT, for appellant.
Pass over.
CL number 2, Vyasa.
Only pass over, my lordship.
Pass over.
CL number 3,
Pass over.
CL number 4,
May it please.
Manoj K.
I beg to appeal on behalf of my lord, respond to this matter.
My lord,
Yes, Mr.
my lord, I am appealing, my lord, on behalf of the engaging council. My lord, I hope I am audible to the honorable court, my lord.
Yes, yes.
My lord, in this matter,
Take it. 3. Memo is filed seeking to withdraw the writ petition. Memo is taken on record and dismissed as withdrawn. Yes, 4. Yes, Mr. Manoj.
CL number 4,
my lord, in item number 4, my lord, I am appearing on behalf of the engaging council. I hope, my lord, my voice is able to reach the honorable court, my lord.
Yes, yes, you are audible.
Yes, my lord. This honorable court was pleased to pass an interim order on 18/3/2026, and also the same thing was once again repeated on 9/4/2026. There are two things, my lord. In this, we were expected to file a debt resolution proposal. That's my friend is carrying it. He can hand over to the honorable court about the reschedule of payments as to when he can pay the entire amount, by what time he can pay that whatever he is able to pay. He has indicated by way of a statement. That statement can be submitted to the honorable court, and it is ready with the engaging council. That's one aspect, my lord. And the second aspect is, we were on by an order dated 18/3/2026. We offered to pay an amount of rupees 50 lakhs within 4 weeks, and out of that 20 lakhs is already paid, and that is accepted by the bank also, and that was recorded on 9/4/2026. And out of the balance 30 lakhs, 10 lakhs we are able to pay today, my lord, and for the rest 20 lakhs we require some small accommodation of
Which we will not grant. Which will not be granted.
no, my lord. The 20 lakhs, if it is granted, the
No. Order,
No.
order dated 9/4/2026 is not complied with. No extension of time. Nothing else. I will not hear any other argument.
No, only one submission.
Court has shown already indulgence. That should have been. That is what the senior counsel who has appeared on the last occasion has submitted. And now this can't go on like this. Why should we show any indulgence?
No, only one submission, my lord. As far as the sale notice is concerned, it would appear this honorable court said that it should not be finalized. But what the bank is saying is they have received one bid, and as per information I got, even though one bid is submitted, they are expected to pay the 25% of the amount after the EMD is paid for participation within 24 hours.
Going to other merits of the matter, what about the complaints of the interim order?
Complaints,
not comply?
No, the balance 20 lakhs, some small accommodation.
No.
We have shown our bona fides.
No
We have already
I am
paid
not
20
going to-
lakhs and 10 lakhs today also.
I'm
That's
not going to go extend
10
this
lakhs
interim
is being carried, my lord. Today, my friend is there ready with the checks, my lord.
The court has
We'll
passed an
have-
interim order on 9/4/2026.
Lordship may grant whatever short time that is possible for payment of the balance 20
I'm not
lakhs.
granting. I will vacate this interim order on 18/3/2026.
May I make one submission?
Small
What was
accommodation.
granted on the ground, my lords, that the Pronage judgment is covered with. Whereas we agreed to pay 50 lakhs, my lords, on the ground that we have not paid any EMIs from 2023 until date. To cover that, my lords, we have agreed that we'll pay certain amount.
Why did you agree? Why did you not pay?
Because we have paid 20 lakhs, my lords.
You're not doing any favor. What you undertaken is 50
My
lakhs.
lords, in fact,
Even
my
on the last occasion when the matter came up, the same submission is made with
Please,
the senior
please.
counsel. Why should we grant any further time? What are your bona fides also?
My lords, it's wrong committed by the bank, my lords. The bank commit like.
What right you have
classif-
committed by violating by not honoring the submission that's made before the court?
I'll comply, my lords. Each time may be granted is a.
We are already granted enough time.
Because in fact, my lords, the objection raised with the bank was we have not produced the reply. I mean, the original copy, the original of the reply, which I'm placing today, which shows that, my lords,
Please understand.
I've given
It
reply
is-
to
it is-
13.2, my lords.
What is your case? What is bank's case? That is a different type. We will consider it. But what is the order of the court? What is the submission made? What is the undertaking made before the court? And where is the complaints? I will not proceed, not even one step further, without the 50,000 paid to the 50 lakhs paid to the bank.
May I submit one thing?
This is
No, no,
matter on Tuesday.
May I submit one thing? May I submit one thing?
Yes.
For the balance 20 lakhs also, your post-dated check will be given today itself, so that that may be.
Check the reading. This is matter on Tuesday. By the time, if the amount is not paid, by Tuesday, this court will not go into into the merits of the matter. Yes, list it on Tuesday.
The number 5.
My lord, I appeal for the respondent number two, my lords. So far, they have not solved the copies, my lord. It may take up after a vacation.
Now this issue is only there before the court that the interest was directed to be paid by the insurance company, and as per the policy, they are not liable to pay the interest, and the policy is also before the court. That's a simple issue.
Take instruction because of more than 4 years have passed by, my lord.
Wednesday, get instructed. Simple issue. It's a legal issue.
It is not at all available.
Because the court has directed them to pay the interest, and
Immediately after the first week of vacation, my lord, I'll say.
yes, this is matter. The first week of June. Yes, if you don't did it, don't have to do. Yes.
Number 6. Then number 6, Arini.
I appear for the review petitioner.
I lead to the honorable court, my lords, because there is no error apparent on the face of this one.
Lord,
Whatever lordship considers, I will. I can support the honorable
Examination in chief, my lord.
lordship judgment.
Cross examination of the doctor very clearly says.
Extensively discussed about the very point.
The petitioner can do his day-to-day activities with difficulty.
Oh, Andre, he's also says that there is remarkable improvement in
That's
the
true, but still there
condition
is a
of the
disability.
petitioner.
He will do, but he will do it with some difficulty. So it would have an impact on
Millard,
his
the
life.
head of stability and mobility component is marginal, he says, Millard.
Petition
But,
not sustain.
But he says that
disability to the
the
whole body and not
disability
consulted
assesses
Dr.
at
Price to-
30.4%,
not
Millard.
to such in order to help the patients. I have said.
And his salary is also increased. He's still working.
I'll consider these contentions and the judgments you are relying on.
Millard, the judgment which
That
has-
also I'll consider.
Millard,
Please
in the
come.
judgment that he has produced, there is amputation. And the one judgment in which it says is that his salary is decreased and he's left the job and he came to the other job. In the other judgment where the scrap
Another
dealer
judgment
is.
there, my lord. Here also, see, another.
Judgments that they're relying on. You're relying on this 2020 Supreme Court? also relying on some judgment?
2023 judgment, my lord, in the conclusion, they say that.
That is relied on by him.
By
Where
him.
is your
Another
judgment?
one more judgment, my lord.
Where is your judgment?
Rajkumar versus Ajay Kumar, my lord.
That's not there in the file.
That is discussed in that only, judgment which I relied, madam.
That's the only judgment you're relying on?
My lord, there are so many judgments
No,
of our.
today, now, what is the judgment you're relying on? Only Rajkumar.
Rajkumar versus Ajay Kumar.
Give that copy.
My lord had given last time.
This court by order dated 15 September 2025 has partly allowed the appeal filed with the claimant, enhancing the compensation from an amount of rupees 5,23,889 to rupees 17,64,389. The insurance company has filed this review petition before this court, stating that as per the evidence of the doctor, he has recovered, and in fact, as per the evidence, his salary has increased. Hence, he is not entitled for any amount under the head of future loss of income. But this court has granted the future loss of income. Hence, the insurance company is before this court taking review of the order. It is submitted that the order passed by this court is contrary to the law laid down by the apex court. You pass on your copy. Take that. Is contrary to the judgment of the apex court in Rajkumar versus Ajay Kumar and another, reported in 2011, 1 SCC 343. Paragraph number?
Lord had given.
Yes, I will. Paragraph number 12, 13, 14, 19. Relying on this judgment, it is submitted that the petitioner is not, there is no loss of future income, and petitioner is not entitled for any compensation under the said head. When counsel appearing for the respondent submits that the court has considered the fact that the claimant had sustained disability and had granted the future loss of income. He has relied on the judgment of the apex court in case of regional manager, the Mohammed Shabir alias Shabir Hussain versus regional manager UP State Road Transport Corporation.
My lord, one submission in that judgment, in the conclusion, we see that, my lord, we are of the opinion that the judgment which has, we are of the opinion at para 27. We are of the opinion that while awarding compensation in case of permanent disability cost to claimants, the courts must look at the case in totality and must consider the socio-economic background of the claimants. The appellant herein comes from an economically weaker section of the society. It is almost universally seen that persons from marginalized backgrounds often face an additional layer of discrimination due to bodily disabilities. This is because persons from marginalized sections of the society already face severe discrimination due to lack of social capital, and a new disability more often than not compounds to such discrimination. In such circumstances, to preserve the essence of justice, it becomes the duty of the court to, at the very least, restore the claimant as best as possible to the position he was in before the occurrence of the disability, and to not to do so must award compensation in a liberal manner. While no material compensation can completely negate the trauma and sufferings that the injured and his family faces, the law only knows the language of monetary compensation in such cases. Then it becomes the duty of the court to translate the provisions of monetary compensation into fabrication that helps the injured and his family in coping with the loss. On the basis of the above mentioned facts and analysis, this court is of the opinion that the just compensation to be awarded to the claimant appellant under different set ought to be as under.
The council has relied on paragraph, which paragraph in this?
Para
What she
27.
read?
And 16, my lord.
Para 16 has relied on paragraph number
Even another judgment is also straight to point.
No, para number 16. In the very same judgment, the learned counsel for the insurance company relies on paragraph number 27 extracted, basing 27, 28, and 29, and submits that basing on the facts and circumstances of the case, the court has granted the compensation. The learned counsel for the petitioner has also relied on, where is that? Take that.
One more. Para 10, my lord. He was leaving one job.
Relied on another judgment of the Supreme Court in Dinesh Singh versus Bajaj Allianz General Insurance Company Limited, reported in 2014 ARSCW 2535, paragraph.
Para 10, my lord. In that I will read the after fifth sign. Therefore, the reason of the High Court that the appellant has not suffered any financial loss because of permanent disability, having regarded to the fact that subsequently took up employment in the Industrial Development Bank as a Group B officer, cannot be sustained.
Paragraph number 10.
Please.
Paragraph number 10. Relying on that, it is submitted that as per the evidence of the doctor, he has sustained disability of
30.5%.
to the limb.
No. Whole body 72%.
60%.
Both whole body 30.5%.
Yeah, this court has also taken that.
Yes, please. 30.5%.
The evidence, the disability, the whole body disability is 30.5%.
No, not whole. Yes, whole body, please.
60%, my lord, it is. It is 60%. His leg is amputated. So he is in Dinesh Singh case.
We are not referring to that case. I am asking about the present case.
In
case, we submitted that he has suffered a whole body disability of 30.5.
30.5.
In those circumstances, it would have an impact on the future earning of the claimant. This aspect was rightly considered by this court and granted compensation. It is submitted that there is no error apparent on the face of the record, which calls for review of the order passed by this court. Next para. Having heard the counsels on either side, there is the material on record. As rightly submitted by the petitioner, this is not a ground which is available for the petitioner seeking review of the order. There is no error apparent on the face of the record. Both the judgments relied on by the petitioner as well as the respondent. It all depends upon the facts and circumstances of each case. In this case, the petitioner has suffered 30.5% disability to the whole body. If a person has
30.05, my lord.
30.05. 0.05% to the whole body. The disability that is sustained by the petitioner would have a whole body disability, would have an impact on the future life of the petitioner. Just because that is, and it is not a secured employment, is working with the chartered accountant. In those circumstances, considering the disability and the flight of the claimant, this court has granted future loss of income due to disability. In the considered opinion of the court and in the facts and circumstances of the case, the order, there are no grounds to made out seeking review of the order. Accordingly, RP so and so is dismissed.
Cell number 7. Lata Shetty for petitioner. Dinesh Shetty for respondent.
Lord, I beg to my Lord appear for this. Lord, on 10/12/2025, if your Lordship kindly see the order dated 10/12/2025. Your Lordships had passed the order directing the bank. The order dated 10/12/2025.
10/12/2025.
My Lord, your Lordship, my Lord, relying on the order passed on 24/9/2025.
1 minute. This is 11/11 or 10?
10, my Lord, 10/12/2025.
10/12.
Now, my Lord, your Lordship had directed the bank to place before the court the action taken by the bank pursuant to the order dated 24/9/2025.
Is it placed?
My Lord, now they have not placed it. They have just filed a memo saying that the due is so much. That is not what the court had directed.
No, I
From
beg to
last
appear
6-7 months.
I beg to appear on behalf of respondent. My Lord, pursuant to order made by this honorable court, my Lord, there are two writ petitions pending before this honorable court. The first writ petition is pertains to my Lord Section 14 order, and the first writ petition in respect of my Lord sale which I conducted way back in the year of 2021. And my Lord, the second writ petition is my Lord Section 14 order assailed before this honorable court. It is a right, my Lord. In fact, my Lord, this honorable court directed me, in fact, to consider the, my Lord, one-time settlement offer in a various reasons stated. My Lord, I place a memo before this, I filed a memo before this honorable court on, my Lord, 6/4/2026, my Lord, which is filed, my Lord, before this, my Lord, kindly, my Lord, placing, my Lord, my letter dated 20th March 2026, compliance to, my Lord, order made by this honorable court. My Lord, kindly see the, my Lord, memo which I filed before this honorable court. In that, my Lord, we stated, in fact, bank, my Lord, given a, my Lord, letter to the, my Lord, borrower, stating that this is with reference to, my Lord, I am reading the letter dated, my Lord, 20th March 2026. This is with reference to the above mentioned letter wherein you had requested statement of account. You would like to inform me that we did our mail dated so and so. The statement had already been provided to you. Further, again, we are providing the same attached. With regards to the one-time settlement amount, we wish to inform you that your present principal liability is rupees 58,16 lakhs, and to all outstanding liability as on my Lord, I'm so sorry. As on date is 1,44 lakh and 59 lakhs. Considering
What
the
is
liability
this
of
order dated? Let us go to the order dated 24/9/2025.
24/9/2025, my Lord. I'll just read, my Lord.
Yes.
But they had sold two properties.
Please, my Lord, one.
This court considered this as a fit case to direct the respondents to revisit the way the amounts recovered or applied and consider working out a one-time settlement of the dues as it existed on 26/6/2019 and pass appropriate orders in accordance with law.
Please, my
So,
Lord.
where is the compliance of this order?
My Lord, that is letter
dated,
dated, my Lord, letter dated 20th March 2026, which I placed along with a memo. My Lord, last two paragraph, my Lord. My Lord, my Lord, get it, my Lord, my memo along with, my Lord, the letter given by the bank, my Lord. Last two paragraphs. With regards to the one-time settlement OTS amount, we used to inform you that your present principal liability is 58.16 lakhs and to total outstanding liability so and so. Considering the liability of the security value in your account, you can submit your OTS proposal to take up with the competent authority. As per our earlier letter dated 3/11/2000, we again request you to submit a concrete OTS proposal in compliance with the order of the Honorable High Court and consider the same favorably. My Lord, what, my Lord, I said, in fact, my Lord, I may, my Lord, can't take a suo moto, my Lord, action in respect of, my Lord, one-time settlement offer. I said 58.16 lakh is a principal without, my Lord, adding any interest. At least, my Lord, on that effect, my Lord, let him give a one-time settlement offer in view of the order made by this honorable court. Will all fairness will consider.
I'm not able to understand, Mr. Vignesh Shetty. What is this order? What are you submitting? I'm not able to, there is no connection.
My Lord, I bowed on, my Lord, on 24/9/2025, this honorable court, my Lord, directed me to, my Lord, given one time.
Whatever the court has directed, you are supposed to do and tell the court.
Please, my lord, in fact, I'm not gone for an appeal. It is
And
matter of fact.
whatever memo you file, that will not be compliance of the order. What order says that you have to comply?
My lord, I understood, my lord, what my lord indicates, my lord. My only respectful
Not
submission
only
is.
understanding, you should do it. Let this matter. Finally, on 3rd of June, by the time, if the order dated, the order
24,
dated 24/9/2025 and the subsequent order reiterating the earlier order, that is, what is the date?
10/12/2025.
10/12/2025 shall be complied with, or else appropriate orders will be passed. This is
Grateful.
matter on that day. Yes.
Number
Grateful.
8. Mr. Nayak.
Lords, appearing for the fifth respondent.
Passover, my lords. Senior counsel is on his legs in another court.
Challenge, my lords, is to the execution and registration of a document. That's the prayer.
Let's see.
Page 42 is the prayer, my lords.
No, I think on this aspect, there are two views.
Lords, now, lords, there is, I would say this, my lords. ARCIL, that is asset reconstruction, distinguished Satyapal Anand, which is by a 3 judges bench, and this asset reconstruction is by 2 judges. Asset reconstruction said that wherever the mandatory provisions of the acts to be done during the course of the registration, if it is not done, 226 can be invoked. That means when the document is presented, that was a case where in asset reconstruction, the power of attorney on the basis of which the document was presented for registration did not contain a power to present the document for registration. Overlooking that, the registration was completed. Then the Supreme Court said that if this mandate is not adhered to, that is section 38, which says that who has to present the document, then you can interfere. While affirming the view which was taken by Satyapal Anand, which specifically said that the moment registration is done, then registrar becomes functus sub issue, and that's not an issue which is open for consideration under 226, because whatever civil rights that may arise on account of any act, including that of cancellation, is to be agitated only before the civil court. Writ jurisdiction is not the appropriate remedy. Now, by considering both these judgments, my lords, a coordinate bench of this honorable court has taken a view, particularly with reference to a power of attorney, my lords. That is the latest judgment of this honorable court, which said that this is an issue which under no circumstance has to be dealt with under 226, because 226 is concerned as to whether statutory aberration is there or not.
No.
If there is no statutory aberration, then
that is precisely the issue. No, there are certain, a particular document is presented where it requires the signature of both the parties.
True.
And if it is not done, is he not doing, is it an inaction on the part or dereliction of his duties?
Milords, wherever it is an inter vivos transaction, certainly, Milords, they will insist upon, because at the time of taking it for registration, your lordships, what your lordship said is perfectly right, because at the time of registration, they now have this checklist which is in the nature of a software.
Yes.
So unless both the parties are present, in relation to the documents which require the presence of both the parties, it doesn't process for registration at all. So these safeguards are already there.
No, but there are cases where these gift deeds are unilaterally, cancelled and all. There the courts
Now,
interfered in
yes,
the jurisdiction.
but Milords, that was happening earlier. Now, wherever it is an inter vivos transaction, what is happening is, now if let us assume, Milords, the property is in the name of A, gift is in the name of B. So if the khata is standing in the name of B, which as per the software which is there, Bhumi software, which is adopted by our state, unless B is a party to the document and she comes and executes, gives her thumb, document processing of registration doesn't happen at all. This is essentially how it happens. This is in relation to the book 1 entries, where it is affecting the interest in the property. So far as power of attorney is concerned, Milords, until and unless there is something to say that there is an interest involved in the property for which the agency is being created, then probably because under no circumstance it comes under section 17 or section 18 of the Registration Act. The power of attorney, even if it is coupled with interest, is not the document of the kind which comes within section 17 or section 18 of the Registration Act. Now, creation of an agency, it is revoked. That's all what is done in the present circumstance. I am the developer. I engage a contractor who is a building contractor. He doesn't commence the construction. I withdraw the agency. That's all what has happened in this case. Now, this is what is challenged before your lordships. If they want to say, no, it should not have been done, they will have to only rely upon the statutory provisions as to which stands aberrated for the purpose of enabling the registration. Beyond that, there is no scope under 226. That's essentially what Satyapal Anand said.
May I only show my lords 2 pages. Page 53, Annexure A. This is the document. Page 53 and 54 is what I want to show my lord.
Yes.
Annexure A is the cancellation, the document which I have challenged. The nomenclature of registered documents, the first 3 letters are the sub-registrar's office. On page 54 in the second line, addendum to general power of attorney dated so and so, document number VRT for so and so. That is the document which has been cancelled through this document. VRT, why I am showing my lords, is because it was registered in Vartur, where the property is situated. Now, where is this document registered is on page 53.
Section 28.
In the box ANK 4003. The seal, if my lords will see, it is the seal of the sub-registrar Baswangudi Anekal. My challenge is this sub-registrar did not have any jurisdiction. The property is not located within his jurisdiction at all, not even within his district. So this sub-registrar could never have registered this document. Neither is the executant within his jurisdiction, nor is the property within his jurisdiction. Irrespective of the fact of the GPA being coupled with interest and therefore not cancelable, in the first instance, he could not have registered this document, which is a fundamental wrong exercise of jurisdiction.
AGA.
Can I just, one sentence, Lords, this jurisdiction is fixed only in relation to documents which are book 1 entries.
No, that he has to say.
Section 28 deals with this. Section 28 says, save as in this part, otherwise provided every document mentioned in section 17 and its subclauses, which affects the immobile property, section clause 18 shall be presented for registration in the office of the sub-registrar within whose jurisdiction the whole or some portion of the property to which some of the document relates is situated. Power of attorney is a document which can be executed anywhere in the world. We execute the power of attorney in the United States before the consulate and get the power of attorney to be acted upon here. Power of creation of an agency is a document which can be executed and registered anywhere in this world. Since the process of registration is not there, that's what happens. But this is only a giving of an agency and withdrawing. Book 4 entries are concerned miscellaneous documents. Jurisdiction is never fixed under the statute. He has to point out under which provision of law for a book 4 entry. The
original, that GPA. The GPA which is cancelled.
That is page 54, what is referring to.
No, that is at page 60, Annexure B.
No, this is a cancellation.
But page 48 is cancellation. Page 60 is the original document, the addendum to the power of attorney, which is cancelled.
In fact, the cancellation Annexure A, my lords, is also
book 4 entry.
It is a book 4 entry on behalf of a dead person. The person on whose behalf the cancellation is executed was already deceased. On any count, that document could not have been registered. And again, request for a pass for senior counsel has been engaged. Grateful.
Still number 9. Still number 9. Bharat K for petitioner.
The present petition is filed. There is no representation on behalf of the petitioner. The present petition is filed against L&T Finance Limited. It's the same in the light of so and so. The petition is not maintainable. Disposed of. section 14 shall have the benefit of section 14. Yes, 10.
Till number 10.
For the petitioner's counsel. That's petitioner participates in an auction under the surface CP. Auction is conducted on 8/1/2026, my lords. I am the highest bidder. Then, my lords, the 25% is paid on the same
How the
day.
writ petition is, this is.
For a mandamus, they refund the entire amount without any cancellation, without notice.
This might be under the surface proceedings. How the sale that is conducted by not a nationalized bank,
Lords, by under the provisions of surfacing.
but still the Supreme Court says that if you
Lords, if
want
it's
any
a-
relief, you have to go
Lords,
to the DRT. but
That's,
not
my
before
lords,
the court.
that's right. When I challenge the auction here, my lords, it is, my lords, you are a bank and,
You are questioning, the proceedings will arise before this court under the Surface Act.
my lords,
Whatever are the proceedings that are initiated in the Surface Act, though they are under a particular
for the
enactment.
purpose of thing, my lords, they
Yes,
are a
but
scheduled
still-
bank.
But still, they are maybe a scheduled bank, but still not.
Lords, I am only saying this. If I was challenging the auction, I can understand that there is a, I participate, I am the
So
successful
if it is
bidder.
not a surface proceedings at all, then you cannot come before.
Then I can't, because it's a surfacey thing.
Then if it is a surface proceedings, then also you can't come in the light of that judgment.
My lords, what your lordships are referring to, I have understood if it is a ARC and private banks,
Finance company, not a nationalized bank.
not a national. But the problem then, my lords, here it is somebody I deposit, you return after 5 days. Lords, this can't be.
That is, you're questioning the steps that are taken by the bank under the surface proceeding. So why should you come to the court, this court? Anybody who is aggrieved by any action of the bank can go before the DRT under 17.
That is there, my lords. Only because, my lords, your lordships had considered this aspect in the recent judgment that you can't unilaterally cancel the.
So that is not in respect. That will be useful before the DRT, not here.
Lords, I am only saying this. I understand this is a
Because I've
cooperative.
taken, this is the consistent view of the court. Please come. The present writ petition is filed.
Lords, may I make this submission? If your lordships are, lords, asking me to avail the remedy under it, give me some time, I'll go there.
No, you'll have the benefit of section 14 of the limitation.
Not that, my lords, because,
No coercive steps, nothing.
no,
like that.
not coercive steps. I am the purchaser. They have returned my money back. I am only,
And when the writ petition is not maintainable, question of granting interim order would not have.
lords,
Present
at least if by the time I go there, if they,
That also you have to say, the present writ petition is filed. Saying the following prayer. The respondent is Surabhi Sohadra Credit Cooperative Society Limited. In the light of the law laid down by the apex court and so on, so the present writ petition is not maintainable. Accordingly, disposed of, giving liberty to the petitioner to avail the property relatively before the DRT. The petition shall approach the DRT within 30 days from the date of receipt of the copy of the order. He shall have the benefit of section 14 of the limitation act.
Till number 11. Till number 11.
I'm my lord, I'm the petitioner in person.
Yes.
My lord, the respondents have been directed to file the statement of objections. Still today, they have not filed the statement of
She's
objections.
seeking time. She sought time in the morning, but you are not there. That's why I didn't adjourn this matter.
Erika,
Please provide the time now.
We'll have it on the reopening day.
yes.
The counsel appearing for the bank seeks time to file objections. This is this matter on 2nd of June.
Thank you.
Till number 12. Till number 12. A.S. Harish.
Petitioners, my lord, are purchasers of properties under home loan agreements with various, my lord, each of them has different home loan agreement with a different financial institution, banking institution.
Is it on a tripartite agreement?
Ladyship, there's no tripartite agreement. These are not tripartite.
What are you questioning before this court?
Questioning, my lord, is the issue of the possession notice. My lord, for the simple reason, my lord, notice I am not a party. I have been in possession, my lord, since different dates, 2020.
Respondent is LIC Housing Finance Limited.
Yes, my lord, R1.
Go before the day.
Yes, no. I'll try to make my case, no. I'll try to make. R1 has issued notice initially in the month of January 20.
No, we'll accept that all the steps that are taken by the respondents are not proper, contrary to the act, contrary to law. In spite of that, you have to go to DRT. This is not a question of alternative committee. It is a case of the
yes,
writ petition not being maintainable.
But yes, I agree. But I agree that I stand on a very, very thin, wet ground. There's no doubt about it. But these petitioners are purchasers, not bona fide purchasers. Each of their encumbrance certificates are
It will
produced.
be decided by the DRT. Why not? That is what my question is.
This honorable court has granted interim orders to several other similarly situated persons.
I have already vacated all that and now nothing is pending. Please come.
Annexure even, may I take?
Please understand, that is the way.
Also
ultimately you will get the relief.
one
There's all this.
Just one other
Yes,
ground I'll.
Yes.
Annexure P is the notice initially issued. Annexure P. In
What
that
I'm
notice.
trying to make it very clear is.
Yes.
In spite of you pointing out any irregularity,
Yes.
illegality, in
Yes.
spite of that, I am not going into that.
Not
I
on
will
the
not
face
go
of it,
into
on the face of it, not Article
But
14.
I'm saying on the face of it, it is wrong. Why
Article-
should the High Court decide? Why not DRT can't decide?
Not DRT, not for the simple reason, not on the face of it, this petition is maintainable. On the face of it, Article 14. R1 LIC Housing Finance, not initially issues a notice, shows not these properties to be under negative lien, which is not a security interest in terms of SURFACE Act. They also, my lord, the villas, the properties which are also, my lord, given by LIC Housing Finance as loan. Subsequently, my lord, this notice is withdrawn. Another notice is issued where the loan given by LIC Housing Finance, those properties, my lord, are removed conveniently.
Please come. The present writ petition is filed.
But,
Seeking the following prayer.
Your lordship would permit me to, my lord, challenge before the 14 proceedings are initiated. Kindly permit me to challenge those, my lord, by participating in those 14 proceedings.
In which
Lord,
proceedings?
Proceedings are initiated under section 14 by R1.
No.
There I am not
you
a
will
party.
You will not be a party. If an order is passed, you will question it before the DRT, though you are not a party. Under
Yes, my lord.
17.
Before, my lord, the magistrate's court.
Now, anyhow, 13.4 is issued.
Yes.
13.4, you can question it before the DRT.
That
Once
also-
you get an interim order, 14 will not be proceeded.
But
If an order
yeah.
is passed under 14, that
also,
will-
yeah.
because your notice to the borrower itself is not necessary under 14.
Yes, my lord. But in this case, the learned magistrate has heard
You can go before them.
my lord, landowners, original earlier landowners. So kindly permit me to, my lord, participate there also. But because
Such a permission we can't give you. That's for the magistrate to decide whether you can be, whether he
I would
wants to
not
hear
say
you or-
permission, I would request my lord's liberty. That if your lordship.
If it is, if you are entitled to, that's what I will observe. Please. The present writ petition is filed seeking the following prayer. The respondent is LIC Housing Finance Limited and the second respondent is Mrs. Global Developers. When counsel appearing for the petitioner has argued on the merits of the matter and how the actions of the respondents are arbitrary, illegal and discriminatory. This court is not recording the submissions in detail for the reason the respondent is LIC Housing Finance Limited and the light of the law laid down by the apex court in so and so. A writ petition is not maintainable. The petitioner has to go before the DRT. It is submitted that the petitioner may be permitted to participate in the proceedings that are pending before the magistrate under section 14 of the SURFACE Act. If the petitioner wants to participate in those proceedings and if he is legally entitled to, he can make, that's for the petitioner and this court cannot pass any such order. Accordingly, this writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy before the DRT. He shall approach the DRT within 30 days from the date of receipt of the copy of the order. He shall have the benefit of section 14 of the Limitation Act.
Section.
Great.
Serial number 13.
After lunch.
My lord, I
30.
But one request, my lord, I'm sorry. Serial number 15, my lord, after vacation. Serial number 15, I got some personal inconvenience after.
When do you want?
But after vacation, reopening.
What about the other side? And please don't make any mention. That's what
Well,
I don't.
it is a fresh matter, my
to-
lord, fresh
if
matter.
you start,
Nobody,
everybody will start.
pardon me?
If you start mentioning, everybody will start.
I'm sorry, my lord. I have to-
So and so after vacation.
I can't.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀಲ್ ನಂಬರ್ 26 ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇದು ಏನ್ ಗೊತ್ತಾ ವಿಕೇನ್, ಗ್ರೂಪಿಂಗ್ ಮಾಡ್ಬೇಕಿದ್ನ ಈಗ ಫೈಲ್ಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು.
ಮೇಡಮ್ ಸೀಲ್ ನಂಬರ್ 26 ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ ಮೇಡಮ್ ಲಿಸ್ಟ್ 2? ಏನು ಉತ್ತರ ಕೊಡೋದಿಲ್ಲ, ಏನಿಲ್ಲ.
பார்த்து பண்ணி பண்ணணும். சரிங்களா? இப்போதைக்கு I just கேட் பண்றேன்.
எதை பண்ணாலும் யோசிச்சு பண்ணாங்களா நான் சொல்லுவேன்.
யோசிச்சு தான் பண்ணிட்டு இருக்கேன் சார். நான் யோசிச்சு
மத்தவங்க மாதிரி நீ கிடையாது, சரியா? புரிஞ்சுக்காது முதல்ல.
யார்
Continue the list.
Continue. Serial number 13, list number 2, serial number 13.
My lord, I appear for the respondent bank in the matter, my lord.
Yes.
Pray for some time, my lord, for
Yes,
filing
yes.
of objections to the main writ petition.
Yes. Hmm?
It's a pending DRT proceedings, my lord, and two applications had been filed by them. So there are two separate orders. And they have filed two different writ petitions.
Where was the order directing the matter to be listed along with the other?
No, he's
petition?
seeking it now.
No, what is that number? List along with that on Wednesday.
May I request my lord to kindly have it after vacation? I need to pray.
He must be having some urgency for the matter to hear. It's coming up for it.
Coming up first time, my lord. This matter is coming up for the first time now.
That's what.
The DRT matter is on 2nd of June, my lord. 2nd of June. It's on the main matter.
This can be taken up on the day.
Yes, my lord. Certainly.
You have filed an application? Hmm. Anyhow, after vacation, whatever you want to do, you do. Yes.
Both the matters
This
together, my
matter
lord.
along with so and so after vacation.
Please.
1st June. Yes.
Serial number 14,
Seek a password.
Nagaraj Shetty.
Seek a password. 14 password.
According to you, at what time it should be called? Password. No, that's what I'm asking you. At what time it should be called?
Yes, I'll take notice in this matter.
Wait. Give him serve him the papers. Yes. Password.
Serial number 15, urgent. Serial number 16, urgent. 17. Serial number 17.
Taking notice, sir.
One minute. June letter dated. What is this letter?
Representation to the bank. Representation to the bank to
No,
consider.
no. Please come to that letter. Impugned letter dated 7/4/2026. Page number?
29.
Hmm?
29.
No.
29.
They have stated that they will not accept the OTS last amount which has been delayed.
Let's read. What is it?
Reply now for your letter dated 3/3/2026 with nil reference number regarding to fresh OTS offer for rupees 50 lakh. This has reference to
So what is wrong with this letter?
given the representation of to consider my OTS payment now. It was the delayed payment now.
No. Letter at 9/3 at page number 29 says that your whatever is your offer is not acceptable to them. Then at page number 30, what is this? Though OTS was sanctioned for rupees 69 lakhs by the sanction letter dated so and so, you have not made the repayment. Where is the letter dated 7/8/2024?
Page number 32, madam. Annexure B. In that not page number 33. Page number 33, any delay beyond 90 days from the date of acknowledgement, OTS shall be attract some interest. That has also been paid, madam.
So this letter is dated 7/8/2024. When is the amount paid?
Amount is paid and they have deposited in there.
Date. Tuesday? Tuesday, I'll have it Tuesday. Prepare and come.
I shall take notice in this matter.
Huh? Password. Yes.
Serial number 18, urgent. 19. Cell number 19.
I appear for the petitioners, my lord.
Mahadevi Ramat.
My lord, in this matter, the petitioners are the legal age of the guarantor, deceased guarantor. Plus, along with his brothers, respondent number 7 and 8. Third respondent is the borrower, purchaser, my lord. And in this matter, my lord, what has happened was, there was a sale notice issued.
Is it a nationalized bank, South India Bank? Is it a nationalized bank?
South Indian Bank?
It is not.
Yes.
It is not. Where from you get that it's a nationalized bank? Sure.
Because matter is already pending in the DRT, my lord, so this on the.
No, even if it is not, it will be pending before the DRT. So it is not a nationalized bank. Who appears for the bank? Any advocates appearing for the bank? Not South India, any bank. It is. It's not a nationalized bank.
Only case is.
First of all, you have to pass through that. Monday?
It is not nationalized bank, my lord. I may make submission on that.
It is not?
Nationalized bank. It is not a nationalized bank. It's a scheduled bank.
Once it is not a nationalized bank, we'll not look into it.
That's my request is, my lord, it is, I'm not on the substantial part of now, only procedural aspect where ERT has said that on the next stage we have to amend the cost rating, bringing the LR something up. That part, my lord, because this honorable court has already given the direction. That the stay order was granted and the ERT was directed to consider the application for stay. Before doing that, my lord, I may be permitted, my lord, page number, order of this honorable court, my lord.
So you're questioning an order passed by the DRT?
Yes, my lord.
That we'll see. I was under the impression that you have come before the court.
My lord, the only thing is, it is not, we are not on the.
Come to the impugned order.
Impugned order is at annexure, N, my lord, survey number 141.
141.
Despite granting sufficient adjournment opportunity, no amendment was carried out. This is not correct, my lord.
1 minute, let me look at it. Yes.
This is the order. Kindly come to previous page, my lord.
Oh. I'm looking at page 140.
140 is M, annexure M. That is the date when we were permitted to bring the LRs on record.
What is the date? What is this date?
This date is, my lords, 2/3. 2/3.
2/3/26.
Next page, my lords, is the Intunda. Only one, that was the only date, my lords.
When it has come up again? What is?
8/4.
8/4.
And that day, the amended.
That is already a month. By that time, it is already more than a month.
My lords, but we have explained, my lords, because the concept for the petitioners, applicants were not well.
Please come.
And my lords.
The present petition is filed, questioning the order passed and questioning the dismissal of SA 13 of 2024 by order dated 8/4/2026, as the petitioner has failed to carry out the necessary amendment to the essay. And comes for the petition submits that initially an order was passed on 2/3/2026. Thereafter, the matter has come up before the court only once, that is on 8/4/2026. On that day, the said order is passed with the. Then what is the interim order you're seeking now?
Yeah, my lords, may kindly see, it is a demolition.
Considering the same, the respondent bank shall not take any coercive steps. Petitioner shall take out hand summons on the respondent.
Back end auction purchaser both.
On the both the respondents and summons. We shall file a memo to that effect by 4th of June. This is matter on 8th of June. Yes.
Cell number 20. Narayan Swami D for petitioner. 20.
This representation is filed trying to give a direction to the DRT to dispose the matter as a list. This is the loan transaction of 20
SA is filed in the year 2026.
Yes, ma'am.
And there shall be a direction to them to dispose of it in 30 days.
Yes.
Why?
Because from 2025 onwards, 2005 onwards, till date, one and the other petition they are filing and they are prolonging the recovery measures.
It's an SA of 2026.
Yes. And
How
my
can, how, why
pleadings
should
also-
we grant a direction?
I have already filed my objections also, madam.
Huh?
My objections also already filed, madam. And only the thing is, from past 20 years, I am not able to recover the dues. That is the reason, madam. Initially, she is the co-borrower. She files a case against her own husband and I impleaded me. And that was the stay was granted before impleading me. And it was ended up to 2010. Thereafter, I filed RA. Then it was closed in 2015. And I issued notice on 2024. That has been challenged before dishonorable court. That writ petition taken almost 1 year. And 28th January 2026, this honorable court dismissed the writ petition directing them to approach the DRT for appropriate measures. And wherein on 18th February 2026, essay filed. 20th February, the matter came before the DRT, and I undertaken that within short span of time, I will file my objection. My objection filed on 24th March 2026. And now the matter is adjourned to 3rd June 2026. Only my prayer is
We can't direct the DRT to dispose of the matter of 2026. The present writ petition is filed, seeking a mandamus, directing the tribunal to pass final orders and dispose SA number 87 of 2026. Land counsel appearing for the petitioner submits that the petitioner is not able to recover the dues from the last 20 years. And hence there may be a direction, considering the fact that this is an essay of 2026 and several matters are pending before the DRT. There cannot be a direction to the DRT to dispose of the matter of 2026 in priority. Hence, this court finds no reason to pass any order dismissed.
Cell number 21 for admission matter. Sanjeev BL for appellant. A. Ravishankar.
Admit. Post of final hearing.
Cell number 22 for further hearing. A. Mahesh Chaudhary.
I appear for respondent number 3 in this case.
Respondent number 1.
Prayer page. The prayer, what is being challenged is the very initiation of the OA proceedings under section 17. Well, I had asked 2 questions on the last petition after I finished my part. That can I not go before DRT to question the same? Secondly, how is it even maintainable? That would be a consequential question. First, before that, can I go answer the legal question? It is my logs to 2 or 3 paragraphs of the DRT petition, whether it's the OA petition, which whether is at page number 33.
Where is the prayer in WP 18351?
My prayer in WP whether is at page number 24.
DRT proceeding as petitioner hearing. You are arrayed as? You are arrayed as?
I am arrayed as the dependent delegates, which my log should find it at page number 29. That's my particulars of the dependents. Yes. That's in the same, now that that's the OA, I request my logs to turn to page number 33, paragraph number 7. That's paragraph number 7 minutes. Paragraph number 7, 8, and 9 are the crucial factors to say that according to the bank as well, there is no debt which they sought to or they can recover from me.
What did the DRT do?
Well, the DRT is now issued notice to us. That they could not have done.
Why?
That's what happens is under section 17. Let's look at section 17 of the article. That's the jurisdiction of the tribunal is mentioned there. That's what it can do. Is that
No, DRT has issued notice. Why don't you go to the DRT and tell the DRT that it is not maintainable?
I cannot seek for application on the issue of maintainability methods because it is deemed to be maintainable under section 17. Let's say look at the wordings of section 17, break with section 18. Now, Millets, I have no other choice but to knock the doors of the High Court under 226 and 227. May I request Millets to look at section 17 for a moment. The words which I used are very important, which would claim Millets an active role in why it came before this court seeking an interim order, seeking the quashment of the entire proceedings. May I, Millets? Jurisdiction, powers, authority of tribunal. A tribunal shall exercise on and from the appointed date the jurisdiction, powers, and authority.
You're reading?
Section 17 minutes of the RTB Act of 1992.
RDB Act.
Minutes, the facts are important in this case. What happens is, that's why minutes, I was pointing at paragraph number 7 to my
Let's see
lords.
section 17.
Yes.
Yes.
The tribunal shall exercise on and from the appointed date the jurisdiction, powers, and authority to entertain and decide applications from the banks and financial institutions for recovery of debts due to such banks and financial institutions. That's the word is entertain. That's the issue of maintainability. I can't even question because that's my respect to understanding and my submission.
Bank, the DRT under section 17 will decide whether the application filed by the the bank and financial institution is maintainable or not.
Hey, it can't. Now, I would say it in this manner. Now, the issue whether debt is there or not, apart from section 17.
No, section 17. I don't think it is so complicatedly worded that you can't.
I'm only saying that
No, it says a tribunal shall exercise on and from the appointed day the jurisdiction, powers, and authority to entertain and decide an application from the banks and financial institutions for recovery of debts due to such banks and financial institutions. Now the bank has filed an OA before the DRT. You are read as defendant number 2. Now, when you go before the tribunal, you say the DRT has no the bank cannot initiate the proceedings against me, and according to you, the DRT cannot decide that.
Which is, DRT would not have the jurisdiction to even interfere with us or issue notice is my fundamental point here. In this particular facts of the case, whereby
No. You just don't slip forward from one submission to the other. I'm asking you on section 17 first.
Yes, but section
So that you please argue.
Section 17 says that if there's any due which is recoverable from any person, banks can go before the DRT.
So what will be decided by section 17?
Yes, but what will they
read it.
Yes, but from the banks and financial institutions.
A tribunal shall exercise on and from the jurisdictions, powers, and authority to entertain and decide application from the banks and institutions. Yes.
For recovery of debts due to such banks and financial institutions. Now, my respectful submission is here in this case, or even on the point of law, DRT could not have issued notice because it could not have jurisdiction to even entertain this petition vis-a-vis maintain alerts insofar as the word debt, and I owe nothing to the bank. According to them, in their own pleadings.
Who will tell the DRT all this?
They've only told that DRT alerts ought to have, while before issuing notice alerts, should have taken into consideration if there's any debt which they're claiming from the petitioner. Let's see one paragraph in mind. Paragraph 32 of my 34, paragraph number 9 of 5 of the paper book alerts. It clearly goes on to say that bank goes on to say that the petitioner owes nothing to us, but we can't recover from another bidder.
And for this purpose, when is this OA filed?
Yes.
Yes.
OA was filed in the year 2021.
From then it is stayed by the order of this court.
It is stayed for 2 reasons. It's been stayed, not only because of this. The way they have gone about. Let's look at paragraph number 9. Page 34. Page 34, paragraph number 9. It is also the case of the defendants that banks should recover the loans from the developer in terms of NOC. However, in the.
So now, because on your application, conveniently, first respondent is also, proceedings against the first respondents also stayed. Entire proceedings before the DRT is stayed.
There's only two respondents.
That's what you're one respondent.
Yes, sir, both are.
You represent on behalf of both or one?
Both.
The petitioner is?
The petition, it's Vishal NH.
Second one also.
Second one. No,
Yes.
second one is.
Hmm.
Oh,
Yes.
I'm sorry, the second one is also there. Let's return to my cost letter. I'm sorry, my eyes stand for it. At page number 3, both petitioners are there. Both petitioners are there, both are various defendants.
So the second respondent has also the benefit of the order.
So when second respondent, there's no proceedings initiated against them.
Then why did you make him a party to
I
this?
made as a respondent is because my prayer minutes can have a look at. I wanted them to take action against the bank for wrongfully invoking the proceedings of the 1993 Act against me when they, in their own minutes on affidavit OA which is being filed, say that A is not liable to pay. Because A is not liable to pay, I'm going to get it from B. That's another including aspect here. My lords, my lords are 34. My lords may turn to page number 33, paragraph number 7. There's a loan recall notice which they have dated it as 1/7/2019. Prior to, they even recalled my loan, which they've granted to me.
Read para 7.
Yes, para 7. The applicant bank submits that contrary to the terms and conditions of the credit facility, borrowers had defaulted in payments of dues in spite of several reminders and demands. It was alleged by the borrowers that builders have not acted as per the terms of agreement of sale and construction, and hence they are not liable to pay the loan amount. As such, the applicant bank, invoking the terms of loan facility, had recalled the facility sanctioned to the borrowers and demanded outstanding amount through loan recall notice dated 1/7/2019. This date bears some significance. Prior to this date,
read complete. Let's complete reading at least
the
that.
copy of the loan recall notice dated 1/7/2019 is produced here with us annexure A. In spite of being aware of the notice, the defendants have failed to comply with the mandate of the above notice. Full stop. 8. It is submitted that flat purchasers from the developer have formed their association and initiated corporate resolution insolvency process as contemplated in section 7 of the IBC 2016 for effecting change in management of the builder in order to protect, recover the investment, including loan amount advanced by the applicant bank. The application was initiated white number so and so before NCLT, Bangalore, by its order dated 7/2/2020, had appointed so and so as interim resolution professional. The copy of the order dated 23/4/2020 is produced here with us and it's The IRP has effected public notice in leading newspaper and inviting claims against the developer had to be present before him in stipulated time. As per CIRP, all creditors, including the defendants, have to file their claim, which includes their own contribution and outstanding due payable to this.
What is the agreement between you and the bank? What is the agreement between you and the bank?
The entire scheme signed.
You're a home buyer.
I'm a home buyer. So I have to pay my loan. But what had happened is there was an undertaking by the developer, though there is no tripartite agreement in this case. There's no tripartite agreement, but my pre-EMI used to be paid by the builder to the bank. There was a default with regard to the pre-EMI. I moved to the real estate regulatory authority. I got an order saying that I'm exiting the project, for which ICICI Bank was not a party to, admittedly. Thereafter, I initiated a civil suit seeking a declaration that I am not liable to pay any amount whatsoever. It is the builder who has to be paying, because I, by virtue of the order passed by the real estate regulatory authority.
No, at paragraph number 9, it says that the loan amount was disbursed by the bank to the builder at the instance of the defendant.
Yes, that's correct. There's no dispute. Well, that's the way, there was no agreement. That's why that's what they call it as subvention scheme. I mean, that's,
So,
you heard that pattern.
so,
Yeah.
when they have whatever their case is, they went before the DRT. Now, even with the moment the DRT issues a notice, you come to the High
No,
Court.
there's a difficulty here. The difficulty here is the don't recall notices 1st July 2019. Prior to which, perhaps I was narrating one incident.
No,
I
there
have a
is
stay.
absolutely, there is no dispute about the fact that you are the borrower.
Yes.
There is no dispute
There's
about
no
it.
dispute. There's no dispute on that aspect of it. There's no dispute that I have an order in my favor by the real estate regulatory authority saying that the agreement stands cancelled and the builder shall take over the entire property.
When was that?
Yes. That was, is dated 4/7/2018, Annexure E, page number 150.
Page number?
150. 150.
Bank was a party.
The bank is not a party. That's what I told you. Bank is not a party. But subsequent to which what happened is important. I initiate the civil suit, making bank as a party. And whether the trial court has issued an interim order not to deduct my account with any of the EMIs. And whether that order, is, my lords will find it at Annexure H, page 165.
Yes.
This suit, is initiated on 27th of April 2019. Perhaps you'll see it on the top date of registration. And the interim order is on the next page, page number 166.
What happened to the suit?
It's pending. What happened is, as what they mentioned, there's a moratorium against the builder.
No, anyway, the suit is the suit is pending.
Suit is pending. It's a stage of evidence.
Stays there.
Stays there. It continues. They are not sought for.
This was when 27/6/2019.
That's correct.
When is the OA filed?
The OA is being filed, 2021, so the date might.
Yes, who appears?
24.
Lord, I appear for the
2021. That's the date.
Lord, in this matter, my lord, they are relying upon the orders passed by the court below and the RERA authority. Admittedly, for RERA authority, before the RERA, we are not the parties. And my lord, the moment they exit, whatever the loan has been taken by the builder,
The court order is not binding on you.
no, it is not. For the reason, my lord, it has been given, your lordship may kindly see the interim order given by at page 183. For what reason it has been given, the interim order?
Yes.
My lord, hence, it starts from hence there is no, my lord, I'll read it. The suit for mandatory and permanent injunction under IE number 1.
Are you reading it 184?
183, my lord, here.
I don't know which file you are looking at.
Here, ink page 183, my lord. It is their own pagination.
That was 166.
160?
166. Which petition? What's the petition?
The first, Hemal.
166 is the order.
No.
Vishal is the
Vishal one only. I am reading in Vishal. First one only.
166.
Sir, here 183 it is mentioned, my lord, in my
Suit is for mandatory injunction. That is what it is. That's how it starts.
Yeah, yes, my lord. No, my lord, it is, I'm reading at the page 183, my lord. In this.
No, interim order is here.
Interim order. Yes, my lord. Here it is 183 page number for me. The suit is for a mandatory and permanent injunction. Under IE number 1, injunction is sought only against the defendant number 2. The plaintiff herein had filed a complaint before the adjudicating officer RERA Bangalore against defendant number 1 herein. By its order dated 4/7/2018, the adjudicating officer directed defendant number 1 herein to refund the entire amount received from the plaintiffs along with the interest at the
defendant number 2 is you.
Yes, defendant number 2 is me. Of 10.25 per annum, and other amount also per use the exit MOU dated 26/3/2006 between the defendant number 1 and the plaintiff, Hence, there is no sale agreement between the plaintiff and defendant number one. As such, it is necessary to pass ex parte order against the defendant number two. If at all, if there is no agreement between them, my lord, what I'm supposed to do, my lord? I have to recover my money.
That all these questions you can't ask the court. You have to ask the trial court where the
Please, my
injunction.
lord, that we are.
And if the injunction has to be vacated, if it is not vacated, you should have taken steps.
My lord, for that already we have filed an application.
So when there is an order restraining you from recovering the money and being a party to it, how can you initiate the proceedings before another forum? You cannot.
My lord, we have filed already, the application is filed under section 34 of the SURFACE Act. But that civil court has no jurisdiction in such matters. It has to go before the DRT only. We have filed it, my lord, since there is a stay in all the matters. The trial court is not.
2019 is the stay. Before this court, this is 2022. From 19 to 22, this court has not granted any stay of the civil court proceedings.
Lord, when we have entered appearance, that also. When we have entered appearance in that matter, we have to see, my lord. But the reason this, my lord, why the OA we have filed, he is a necessary party there. He can't just waive off his liability and go, my lord.
Appearance on 25/7/2019, page number 167.
My lord, for the reason that we have, he is a necessary party there, my lord. Unless he is there, we can't go against the builder. He has to be there to prove all these facts before the DRT also.
Proving is one aspect. What is the relief you have sought against him?
My lord, that my lord.
What is the relief that is sought? You have not sought relief against the builder. You have sought the relief against him.
My lord, we can't directly like builder, my lord. Builder will make a party to take the secured asset, my lord, because he'll be like we can
come
take.
Come to your application. Page number.
87 it starts.
I don't know here the jumbled up everything.
Look at it. Who are the respondents, defendants? Page number 29. You saw?
Yes, my lord.
Company is not, the developer is not a party. You have initiated the proceedings only against them.
My lord, for the reason that we don't have tripartite agreement in this matter.
I'm only asking you a question.
Yes,
from
my
your
lord, against the
submissions.
builder.
No, you said along with the builder, he has to be there
Generally,
in
we
the
do that, my
publication.
lord. In this, my lord, you might kindly have it on Monday. I'll just come back on this, my lord. Why in this particular matter? Why we have not made?
On two counts. One is this. Number two, the order of a civil court after an injunction restraining you from doing it, you have filed this petition. How can you do it? On these two questions you answer, I'll pass orders on the day. Let's take on Tuesday.
Injunction is only against not to collect the EMIs, my lord. The injunction order specifically says
What
not
are you doing it by virtue of this? EMI is the recovery of the loan.
EMI, there was a restriction on collecting the EMIs. Anyways, they had stopped paying EMIs long before, my lord.
No, whatever
That reason we have now
whatever you're
terminated the
collecting
loan.
is that is part of the EMI, that is the loan.
Yes, my lord, we have recalled the entire loan now by initiating this proceedings, my lord. I'll answer that, my lord.
Yes.
Cell number 28 B group, number 23.
Tomorrow, look at it. Earlier granted is extended. Yes.
23. Ravi Raghavan.
Petitioner.
Objections here. Respondent has filed objections here. And will make submissions here.
Let him submit his petition.
Yes, yes, my lord.
This is the case where property and major property belongs to
company by name. The petitioner is the owner of the property.
You're questioning the
What
order
happened?
passed for the DRT.
That's
Whether the applicant is at liberty to record the same from different number 2 to 3 property shown in the OA schedule. Come to the order in the OA. Who are the parties there?
Please, may I just draw that to the court's attention? Please be kind enough to take. Page 15 is the beginning of that annexure, annexure A. OA applicant is the Jammu and Kashmir Bank, respondent number 2 before the court.
You are?
I was not a party, that's my whole submission. I am the owner of the property, I was not made a party. What I'm aggrieved by is, and may I just draw the court's attention to few parts of
Is it the case that the leasehold rights are?
That's exactly where the controversy is. The question is, leasehold rights were surrendered.
Give the dates.
I'm just taking the court. 1992 July, 23rd July. May I just tender this to the court?
Exactly.
Yes. This is office copy. I'll pass it.
Yes.
Please come to the list of dates that begins on the 5th page. 1992 July. There's a lease deed executed between a company by name BPL Engineering and the vendors of the petitioner. 38 years registered lease.
1 minute. Vendor registered.
That's correct.
For 30?
38 years.
No, for how many years?
38 years. It expires in 2029. Another 2-3 years to go.
30.
Organically, the lease expires in another 2 or 3 years. In the year 2000, Jammu and Kashmir Bank sanctioned some loan in favor of BPL Engineering. I have no quarrel with that. Term loan agreement, nothing to do with me. Hypothecation of goods is there. That is apparently registered. There is no registered charge in respect of this property. The court, in fact, on 3 occasions has asked pointed questions by orders passed by this court to the respondent number 2 to place a registered document showing that they have a registration. They have not been able to place it. After the passage of 8 years, they have now filed a statement of objections, even though they're not produced. So there is no such document. We have to safely conclude. Now, please be kind enough to take this.
What has been mortgaged according to them?
Yes, according to them, they say that the leasehold rights were mortgaged because BPL only held that. But the submission is this, and this is what is important. In 2005, there is a registered surrender of lease by BPL Engineering in favor of my vendors, and I immediately purchased from the vendor. Because I noticed, obviously, there is a registered encumbrance. I said, I don't want this encumbrance, you get the lease released. So the lease.
When was it cancelled?
I'm sorry?
When was it surrendered?
This is on 16/5/2005. On the same day, the sale deed is executed in my favor. Because I told my vendor, I don't want any encumbrance, I want it encumbrance free and clear possession. They did that. Now the question is, prior to 2005, the date of my sale deed and the same date is the date.
According to them, when is the registered mortgage?
There is no such date.
Even for the mortgage.
Yes, I'm grateful. I'll answer. The date of the loan, they say, is 4/1/2001. According to them, the charge, if any, took place on that day only, nothing else. But there is no such document, and I may point out 2-3 other aspects here which are very relevant. The same content, no, I'm sorry, there is one other important aspect that happens. In 2005, there is also a winding up petition that's filed, independent of me, independent of them, nothing to do with either of us, against BPL Engineering. That results, and in 2009, they initiate DRT proceedings. In 2012, BPL Engineering is directed to be wound up by learned signature of this. In that, the petition is advertised, and there is an application filed Please be kind enough to come to the last page of the list of dates. The date is 34/2016. Of course, the date on which they filed is may not be relevant. They file an application in CA, that is respondent to Jammu and Kashmir Bank, files an application in CA 233 of 2016, seeking recognition of the charge and direction to the OL to consider their claim on par with the respondent banks. This court rejects it by a speaking order saying that there is no registered charge in their favor, therefore that can't be registered, therefore it can't be recognized. My submission is this: that order, ultimately the official liquidator has stepped into the shoes of BPL Engineering. Official liquidator takes a stance saying there is no registered charge. This court has accepted it. They made an application in respect of this property and that has been rejected. Today for them, thereafter to try and bring this very property to sale is completely wrong. And my respectful submission is only this. You may have other recourses against BPL engineering. You did not challenge this order of the learned single judge where your application was rejected. In fact, you kept everybody in the dark, including this court. I am not a party to that application. They should have disclosed it to the court, but they did. Irrespective, ultimately this, if the lease deed surrender has effectively been affirmed by this honorable court, the alleged charge that is claimed by them has not been accepted by this court. In an application between them and BPL engineering, now represented by the official liquidator, my respectful submission is that's the end of the road for them as far as that charge is concerned, or the claim for the charge is concerned. But it doesn't end there, in that in this writ petition, this court has repeatedly put to them the same question. Please show me the document, which is effectively what this learned single judge of this court said 10 years ago. And till date, they've not been able to place it. This is the short submission that I wanted to advance, and that's
where are the objections filed with them?
Please, I may just take the court through the objections they filed. They essentially say, no, you should go back to the DRT, you should do this, you should do that. But they don't answer this. In fact, there is no answer on mortgage registration. In fact, that is the pointed question this court put to them by virtue of 3 orders of this court. Over 1.5 years.
15.
The coordinate bench had earlier put this question. 15. This court has put the same question to them. The last instance being 26/3/26, on 15/9/25, and even earlier than that.
Objections. When did you file your objections?
Yeah. 21st April.
21st December.
April.
No, 3-4 days.
3-4 days back.
21/4.
21st.
Yes, what is your stand? Yes.
Yes. You on this case, you are married. Now kindly go to the petition filed by this petitioner. Page number 34.
Before going into that, we are on the point where there is a registered mortgage.
Yes.
If it is, where is the document?
Yeah, I'll make submission. That's what. I'll make. Yeah, kindly go through the sale deed made by their vendor. You want. This point is pointed out regarding this lease agreement. You want. Kindly go to the page number 34 filed by the petition by this petitioner. You want. Whereas the seller are not deriving tangible income from the scheduled property, and the rent is now paid to them is very low.
Days before this court now.
The
registered mortgage deed.
That's I'll come to that's.
We don't have to go here and there straight away come to that point. You answer it, then we'll go to the other issues.
Yes. In this case, you are lease with the bank. You are that is with the file before the DRT. That is in DRT because of shifting, unable to find out in the DRT. One more thing, you are. This petitioner and the vendor and BPL company involved to make fraud to us. You are. How can I say the before sport? You are. Lease is surrendered 16/5/2005. I think 16/5/2005. On same day they purchased the property. They also aware of regarding the leasehold property. Lease.
No, it is not 2005. It is 2001.
2005.
The lease is of the year 2000.
1992.
1999. The surrender of lease and the sale in my favor are both on the same. Because I insisted on that condition.
Yes, you know. If it is so, suppose the bona fide purchasers of suppose they are aware of regarding this, they should ask all these things. Where is the lease agreement? You know? They never ask on this. They are involved. You are. They also involved regarding just to make fraud to bank. You are. That's what I'll kindly go through the page number 34. There is physically highlighted sale itself. You know. Kindly go to the page.
Has he filed the registered mortgage deed?
No.
They
Not filing it, why are you
No, no,
arguing?
Your Lordship, they are aware of this. They are also aware of this, really.
This is not the
No,
submission
I'll make-
expected.
no, I'll make-
I
I'll read-
don't want any other
My lordship.
submissions. Please show to the court the registered mortgage gives you right to put this property to
Yes,
auction.
yes, this copy is there, all at least filed before court. You want, there's already copies before this court. That is.
Where is it?
Yes, I filed long back.
Where is that? Has he served you a copy of it?
Yes, sir. Yes, sir. The copy, sir. That is there.
Oh,
Yes.
yeah, this.
No, yes, where is it? Page number?
Start page number, my lordship. Page number, my lordship. 24, man.
Yes.
Yes, this lease agreement, lordship, for 30 years, my lord, 38 years.
Have you not seen this?
I've seen this. This is the lease deed, not the mortgage deed. Please see page 24 is the lease deed. I know about the lease deed.
This agreement to lease.
Yes, that is the lease deed which is registered. I got it surrendered before my sale deed. That is not the mortgage deed. May I just show one more document from this compilation? Unfortunately, it's not got a covering index or anything, but I'm sorry to trouble the court, but this is what my learned friend gave us. Please be kind enough to come to page 108 as is shown in my bundle. I'm sorry if the numbers don't tally, but it appears to be page 108 written in blue ink. The letter is on the letterhead of ICICI. Oh, sorry, it's ICICI Limited. I stand corrected. It's ICICI Limited.
Yes.
This is dated. On the right hand side top, the court would notice the date is 18th March 2022. ICICI Bank writes a letter to, among others, Jammu and Kashmir Bank. And please see the content of it. It says creation of mortgage by deposit of title deeds. We write to confirm that on 15th March.
You're reading it page number?
I'm sorry, this is 108. Please see what they say. We write to confirm that on 15th March 2002, company created a mortgage by deposit of title deeds on the immovable properties of the company situated at so and so Medak in Andhra Pradesh. It actually doesn't refer to my property, but
Even,
please be kind enough to take the next.
No, I don't find what
I'm
you're
so
reading.
sorry.
108, it says first schedule, list of documents of title, evidence, deed and writing. There are two numbers, sir, on all the pages.
There is the alternate number that I can point out is page 57. I'm so sorry to trouble the court, but unfortunately I have the same visibility of the court. What was given to us?
So 108 is what, this is a document at 108.
May I just pull it out in fast? Because the court master, I'm sorry, I'll put a.
Show it to them.
Go to 57. This one. This one.
This is the letter I'm referring to. I'm so sorry. I just request the court master to use a poster of a different color for TV.
Yes.
This is 18th March. ICICI writes to, among others, Jammu and Kashmir Bank R2, relation to the creation of mortgage and deposit of title deeds The text of that letter does not refer to my property, just pointing that out, but nonetheless, I'm just pointing out that they're conscious what they need to do. Please come to the next page, the second page of that letter, the last paragraph.
Yes.
You may arrange to file the statutory forms required for registration or modification of charge with registrar of companies within the time prescribed by law. So they're fully conscious that it needs registration. Not that a bank needs to be conscious, but the fact is there is no registration document placed. And this is noticed by this honorable court. May I just show the court that order? There is a memo dated 6/8/25 filed by us.
Page 16 is the order of. Page 16.
6/8/25. Please be kind enough to take that memo, page 16 of that memo. I had pointed this out from the list of dates. I'm just showing the court that order.
Yes. Are you referring to 6/8/2025, the judgments or filed?
6th December 2019.
Judgment and
December.
No, so there is
one more.
there is a memo with for production of documents.
Same.
Please, I'm so grateful. May I request the court's attention to page 16 of this compilation? It's an order dated 6th December 19. I'm grateful. In company application 233, filed by respondent number 2 against the company in liquidation. Please be kind enough to see the prayer at the bottom of the page.
No such registration is made under section 125 of that.
I'm so grateful. I just wanted to point out the prayer. They say to consider the charge created. It has been requested of this court and this court has rejected it.
Yes.
They can't even be heard arguing this before this court is messed up. And there are 3
Without creating
orders.
a charge or the property, how can you proceed? Unless and until you show to the court that there is a registered mortgage. Unless and until you show that there is a registered mortgage, this repetition has to be allowed. We have given you enough opportunities. And now you come before the court and you can't even make a submission that whether it is registered or not. It is not registered in the light of the order passed by in a company application.
This case, on the submissions you are. I filed the inquiry petition with the OA before it, DRT 2009. Still there, I don't know aware of regarding whether the surrender lease or not. They keep it blind you are. They are not informed to us regarding whether lease surrender or not. Intentionally to fraud us, you are the surrender lease to the owner you are. Again, the same purchase basis one. That's what my submission. The intention to fraud everybody.
Hearing cannot go like that. You have to answer to the court's query, then you can make your submission. Unless and until the mortgage is registered, you cannot proceed against the property. You have to show to the court whether the property is mortgaged with you or not.
Yes,
you have not filed any document to show.
Yes, I filed before. Finally, it's there, you know.
If that
not registered, my submission is not registered, but it is unregistered.
Unregistered. Yes, that ends the case there. Please.
No, in this case, no. At least you know.
Yes.
What is the fate of bankers you are? If it is 100 crores of power.
Fate you should have thought about before granting money, basing on these kind of documents.
This 100 crores of power.
Let it be. Whoever has granted the loan, they should pay from their pocket.
What is the fate of the other bankers? You know? They also
We can't help it. Whatever is the fate. There's other matters. I can't pass order now. Reserved.
So,
Number 24. Till number 24.
Yes.
Come back to trouble your lordships again on this recovery matter. I'll be very brief. Just 4 or 5 days.
Yes.
I'll then maybe seek recovery. There are your lordships 3 petitions. I'm requesting that your lordships may take the petition which is at point 2 as the main matter.
Yes, 335, sir.
This is my lord petitioner Daljit Mahal.
Yes. Yes.
My lord, please double your lordships for a minute, my lords, on the prayer. Please see, my lords, the prayer I seek at page number 46.
Yes.
My lords, before I read the prayer, my lords, two words in dilation. The reason, my lords, I'm dropping your lordship to look at the prayer, my lords, is that my friends at the other end of the bar, my lords, are vociferously arguing on three counts. My lords. One, that this gentleman who is Vijay Mallya, who is one of the petitioners in the second petition, he is today a fugitive economic offender outside the country, therefore he should get no indulgence from this honorable court. Second, that these are, and that is not the bank's statement and solemn statement. And in fact, on the lighter side, if somebody has left the country to hell with them, we will once one girl. But the official liquidator, and interestingly enough, in the DRT proceedings, my lord is fighting the banks, saying that the banks are not disclosing this. But in these proceedings, my lord, they joined the banks in fighting me. The OL statement indicating, my lord, is that because the petitioner who your lordships are considering now, this lady Daljit Mahal, she was one of the directors, erstwhile directors in the company. She has been issued notices in the winding up proceedings. She has not responded to notices in the winding up proceedings. Therefore, let her go before the company.
No, in 3357, Vijay Mallya is the petitioner.
That is point 1. I'm sorry.
No, in 24.2 is.
It's totally my error. I should have requested my lord to take point 1, Daljit Mahal.
Yes. 3356.
Yes, my lord. I'm so sorry, my lord.
3356. Second matter, 24.1.
On this point 1, my lord, the allegation is that she was one of the erstwhile directors. The company court proceedings are going on because the company is now under liquidation. She has to respond to notices there. Therefore, please don't hear her on a writ petition and please relegate her to the company.
Let's see the prayer in.
In that light, my lord, please see the prayer. My lord. This is not a prayer that my lord, the company court can give. An order direction, I'm reading my lord say, an order direction in the nature of a mandamus to respondent number 2 to 12, they are the banks, to provide a statement of accounts for the amounts owed by United Breweries Holdings Limited by taking into account the interest accrued periodically and giving due credit to all recoveries made from time to time since the amended recovery certificate of 2017 in OA number so and so. Plus, all that I seek is, I am not seeking a waiver, I am not seeking, my lords, a haircut that the banks must take. There is, my lords, a recovery certificate issued, my lords, in the original proceedings for 6,203 crores, which your lordships will find at page 198. That 6,203 crores carries, my lords, an interest of 11.5%. Monies, my lords, have been recovered from me on various dates, my lords, from the recovery certificate, that is 2017 is a recovery certificate. Fortunately for me, my lords, in 2024, a statement is made by the finance minister, one of the solemn statement of the house which I have produced, and subsequently finance ministry issues a report that 14,131 crores have been recovered and made over to the banks. If that is the case, there can be one of two things. Either based on the principal and interest, I have discharged my liabilities, that is as a company, my lords, not as Vijay Mallya, not as Daljit Mahal. This is liability of United Breweries Holdings Limited, which was not a debtor, but unfortunately stood guarantee for the debt which Kingfisher Airlines took. Therefore, my lords, as a guarantor, either there must be a statement saying that we have recovered the following, we are giving a accord and satisfaction saying that you have satisfied the recovery certificate, or alternatively, this is the statement of accounts, I have recovered X, you are still liable to pay me Y, because the interest has accrued, it is X plus Y, you have to pay me Y. But for both those, the reason why I am filing a writ petition for, in fact, seeking an account statement is, the conduct, my lords, of the banks before the recovery officer. Please permit me, my lords, to place those orders straight away. And those orders, my lords, were not a part of the paper book. I have not applied and now received, my lords, copies of the orders of the recovery officer. Please see, my lords, what the recovery officer says. The lordships will find in this convenience compilation Please ignore all of it for completeness. I put the whole thing. These straight away mallards come to the recovery officer's order at page number 371. If my lots have 371, I am troubling my lot mallards to the very top of 371. Your lordship should find Debt Recovery Tribunal 1 Chennai. Mallards, the reason why it went to Chennai, although it's Bangalore mallards, is because by a notification, any recovery above a particular quantum mallards went to Chennai, and therefore mallards, the Chennai recovery officer is in charge. Mallards, please see certificate holder State Bank of India. State Bank of India, I think, was the lead bank mallards in the consortium, subject to me. That's why it's State Bank. It's actually not only State Bank mallards, it's those 12 banks. Certificate debtor, Kingfisher Airlines Limited. Your lordship will say I am not the debtor, although I am the guarantor. Therefore, my liability. Just kindly see in this Roman Arabic 2. Please come to mallards Roman 1. I read 2. On 17/4/2024, it has been directed to CHP mallards, certificate holder banks, to file a detailed affidavit from the date of demand notice. The certificate holder bank have not filed a detailed affidavit so far. Hence, the certificate holder bank has been directed to file a detailed affidavit before the next hearing, along with the following details. 1. The amount recovered so far by the certificate holder bank as per the recovery certificate. 2. Amount outstanding to be recovered. And 3. Details of the secured and unsecured properties sold out and the amount recovered from it. 4. Details of the secured and unsecured properties available for auction. Then mallards, details of shares attached, details of shares sold, details of shares to be sold, and pending legal cases, etc. This was sought, my lords, as my lords, this date is on 23/12/2015. The recovery certificate, my lords, having been issued, my lords, as early as the recovery certificate, my lords, is dated on 10/4/2017.
Yes.
Well, that's 23/12/2025, not 2015.
Yes.
Now, please permit me, my lord, to come to the next document, which is at 372. This is 28/1/2026.
Yes.
And please see the recovery officer's order, my lord. This is document 19372. I'll very quickly take your lordship to it, my lord. The official liquidator has been informed to file status report. Number 3. Certificate holder counsel has appeared and appeal, etc. has been filed. Now, please see 4 and 5. Certificate holder bank failed to file an affidavit as per repeated directions. Certificate holder bank is again directed to file a detailed affidavit as per order of 23/12/2025. That is the order in which saying, please tell me how much you recover. Now, please turn over to page number 373 for 1 minute. Now, 373 is 3/2/2026.
Yes.
Now, again, para number 3. Certificate holder bank. So 2. Certificate holder has not filed an affidavit. Certificate holder bank is once again directed to file detailed affidavit, failing the authorized officer dealing with the account to appear before the recovery officer and explain the reason for not filing affidavit. Now, please turn over to 374. This is number 12/2/2026. This is number the 4th order now. Para 2. Certificate holder bank has not filed affidavit today. Counsel has informed that the draft affidavit sent to the certificate for approval. Therefore, the lawyer makes the draft and sends it to the bank. CHB is once again directed to file a detailed affidavit before the next date, failing with the authorized officer dealing with the account to appear before the RO. Now let's now turn over to 18/2/2026. That is 375. Now I come to 375, paragraph number 3, 2 and 3 now. CHB has not filed affidavit today. Counsel informed that the draft affidavit is sent to CHB. CHB once again directed to file detailed affidavit as per order of 23/12/2025, failing which authorized officer dealing with. Now, just 2 other orders. Please come to 25/2/2026. Similar order, that is at 376. Now, kindly see, there is a detailed order at 378. At 378, is 25/3/2026.
77 says affidavit is filed.
Well, at 377, CHP has not filed affidavit today. I'm sorry, 376. 377, kindly see, is not.
CHP has filed affidavit.
Correct, the next line, CHP has filed affidavit today. CHP has filed combined affidavit both for transfer so and so, so and so. Further, affidavit filed by certificate holder bank is not as per order dated 23/12/2025. That is, how much have you recovered and how much should I owe? Can I not, as a debtor, ask them, how much do I owe you? Please see, 4. CHB is directed to file separate affidavits for the TRCs. 5. CHB is once again directed to file detailed affidavit as per order dated 23/12/2025 before the next date of hearing, failing which, now they name, my lords, of course, an honorable lady, the name, failing which Srimati so-and-so AGM to appear before RO and explain the reason for not filing the affidavit. Now please turn over leave to 378.
Yes.
Please come to in 378. This is 25/3/2026. I read my lords 2 onwards. As per the order of 4/3/2026, certificate holder bank has not filed a separate affidavit for so-and-so. And Srimati so-and-so has not appeared today before recovery officer to explain the reason for not filing affidavit. The certificate holder bank is directed to file detailed affidavit as per order of 23/12/2025 before next date. Otherwise, Srimati so-and-so should appear before RO and explain the reason for not filing the affidavit. Now, my lords, kindly see the last order at 6/4/2026, page number, my lords, 379. So I'll just read this, my lords, in 1 minute. My lords, I am at para 2, my lords, at page number 379. As per the order of 25/3/2026, today, Srimati so-and-so has appeared before the recovery officer and explained the reason for not filing the affidavit as per 23/12/2025. Now, the certificate holder bank is directed to file a detailed affidavit as per the order of 23/12/2025 before the next date of hearing. OL is directed to issue status report that's irrelevant. 144 crores went to the OL for salaries, etc. My lords, now this lady, my lords, Mrs. So-and-so, he's the signatory, my lords, in the statement of objections. In the first writ petition, which is, my lords, the interest challenge writ petition. Therefore, I am only, my lords, limiting therefore my prayer before your lordship. I am conscious, my lords, that when I invoke my lord's jurisdiction as a writ court, as a constitutional court, it is not for me to bring, my lords, the interstate dispute of how much, whether the certificate is right, whether, my lords, that interest computation is right. I may have to go, my lords, before the cognizant authorities in terms of that computation. But for which the genesis would be, my lords, to indicate that there is a recovery certificate. Under the recovery certificate, Mr. Puvaya, you owe me 6,000 crores plus interest, which according to them may be 17,000 crores. I don't know, maybe 14,000 crores. We have recovered from you so many thousand crores over a period of time. Therefore, those recoveries then carry interest, my lords, because money has gone there. At least to the extent of recovery, the interest which is sticking on the original number must come down. And therefore, my lords, in the seriatim order, the account must be put up to say, we have recovered X, you owe us X plus Y, or we have recovered X, therefore you have paid us the entire money. I can then apply, my lords, for a certificate of discharge, at least for the guarantor company. Dr. Malya here, or my lord, Diljit Mahal is anyway not, my lords, a debtor. Vijay Malya may or may not get relief, my lords, in terms of getting a clean sheet saying he owes no money. But this writ petition is not for that. This writ petition is only to say, United Breweries Holdings Limited was the country's largest, my lords, brewery company. It still has, my lords, substantial assets available for which for it can, my lords, revive the company. If I have discharged my liabilities here, I am free to conduct my business. If I have not discharged my liabilities here, I will have to make sure that those liabilities are discharged. The genesis for that is account. I don't get account. I file a writ before your lordships, praying my lordship's indulgence, saying that there should be a direction. The bank stand up and objects to me, my lord, to say your writ is not maintainable, one, because you are a fugitive economic. Please ignore that writ, my lord. Therefore, I indicated, please ignore that writ of 24.2 of Vijay Malya, because they say he is a fugitive economic offender. Respectfully, my lord, it makes no difference. Even if I am the biggest offender in this country, I still have a constitutional right to invoke my lord's jurisdiction. Ultimately, whether my lord will give me relief or not is my lord's prerogative and discretion, not the bank's objection to say my writ is not maintainable. Second submission. What has Diljit Mahal done? She has done nothing. She is not a party to any of these proceedings. She was simply a director on the board. Your lordships have held, and Supreme Court, my lords, has repeatedly indicated, my lords, that a director in a former company which is under liquidation continues to have the right to seek accounts so that if the discharge has occurred, to revive the company and bring it back onto the books of the company. That is Rishabh Agro. I'll place Rishabh Agro, my lord, towards the end of quoted, my lord. Rishabh Agro indicates. Therefore, my lord, Diljit Mahal's writ petition, that is 3356, has no, my lord, clause, so to speak, in terms of maintainability, etc. And the banks, my lords, hiding to say that no, we will not give an account. Now, why do I say, my lord, therefore the official liquidator right through before the DRP, that is the DRP recovery officer, stood in line with us telling the banks that you please tell us how much you have recovered, because it is the OL's case that if the banks have been discharged, then the OL will see whether there is any other liability that is to be paid. so that those liabilities can be paid. And if all liabilities are paid, OM will, my lords, issue a certificate saying that liabilities are discharged. The liabilities are discharged, I will invoke, my lords, the Company Act and come to the company's court, my lords, for reviving the company. It is at that stage, my lord. Kindly see, my lord, the OL submissions before the Karnataka High Court. I'll just show one page. Please permit me to come to my lord in this on 17/1/2024. OL, my lord, files a statement before this court, and there is an order, my lord, of this honorable court. Your lordship will find it at page number volume 3, 1172.
Volume 3. Yes.
Lord, please permit me to come to my lord 1171. Your lordship will find an order of this honorable court. This is, my lord, in International Aero Engines versus United Breweries. International Aero Engines, my lords, are also, my lord, stood in line, saying United Breweries Holdings as guarantor for Kingfisher Airlines owes money to the aviation engine company. In turn, my lords, Kingfisher Airlines sued them, saying that because their engines didn't work, the airlines went down. That's a different dispute altogether. My lords, kindly see the order, my lord, on 17/1/2024. Your lordships will come to the bottom of that page, my lord. Order heard so and so, learned senior counsel for the official liquidator. And Mr. So and so, senior counsel appearing for respondent 1, Mr. So and so, senior counsel appearing for respondent number 2, and Mr. So and so for respondent number 3. Now, kindly turn over. During the course of the submission, learned senior counsel appearing for the official liquidator submits that the consortium of banks has already recovered the amount due in excess of what is adjudicated. My lords, please juxtapose this sentence to, my lords, one other page in your lordship's paper book. Please come to, my lords, 291.
That is first volume.
My lords, that is 291, my lords, is volume number 1. 17/12/2024.
Yes. Page number?
My lords, page number 291, my lords. It says annexure E1.
No, this is not the one volume. This is a convenience compilation.
Where is it? My lords, in the convenience compilation also I put it. My lords, please see it in the convenience compilation. First, my lords, document number 16 in the convenience compilation.
Page number. Three 316.
My lords, I'll give us 316, my lords, open it.
Yes.
My lords, 348, my lords, is the relevant portion. On the very top, your lordships will find, my lords. There are restored properties worth 22,280 crores in major cases. My lord has that. But this is the statement of the Honorable Finance Minister, my lords, to the floor of the House. Thereafter published, my lords, as a corrected version as records of the House. These are there are restored properties of 22,280 crores in major cases. And I would like to list the number of cases. In Vijay Mallya case, the attached properties worth 14,131.6 crores have been restored. Kindly note the word, my lords, have been restored to the public sector banks. So there is no way in which I can go on to listen to the very many members who without facts are going on saying that no haircut has happened. That no haircut has happened. That language is correct. It should be no comma haircut has happened. The comma should be removed. No haircut has happened. Because I can do innumerable number. I do work on the banking side. Innumerable number of cases starting, my lords, from Reed and Taylor downwards. That 45,000 crores due, my lords, is settled at 3,000 crores by the banks. I am not saying they should take a haircut, but that is perfectly legal. In my case, my lord, there is a 6,000 crore due. 14,000 crores is restored. The bank's answer is, you have a case. That is, Dr. Vijay Mallya and others have a case with the Enforcement Directorate. Enforcement Directorate had attached the shares of these companies and assets. They have now restored those assets to the bank. Banks have sold it and money has come to the bank. But because ED proceedings are pending, and if I'm convicted in the ED proceedings, then it will go by escape to the central government. Therefore, we will not give you benefit of the credit that we have received. I come from a village, I studied in a village to understand it. This is the money lender of the village, who takes the money from the father, then indicates that takes the money from the son, then indicates that I do not know whether your father will come tomorrow and ask for the money. Therefore, I have taken your money, but I will not give you accord and satisfaction in an account. Your interest will continue to run. In that light, I am not even seeking at my Lord's hands an order that interest should or should not continue to run at this stage, my lords. I will keep that powder dry for another fight. I am only praying for an order from your Lordship and saying that let them at least disclose or affidavit what is recovered. Please see the enormity, and I'll end with that. The OL believes, now OL may be right or not, the OL believes and makes a solemn statement before your Lordship that the banks have recovered more than what is due to them. Therefore, OL says, give me the rest because I have other creditors. The government of India, through the finance minister on the floor of the house, believes that the banks have recovered and 14,000 crores is restored to the banks. But the banks still do not want to file an affidavit before either the recovery officer or even for that matter in this writ petition before your Lordship, indicating that these are the amounts that I have recovered. But it is in that light, I pray, and of course, I should have asked them. Before asking them, I can't come in the writ. Please see two communications, which are issued. My lawyers issued a letter to the banks. Doesn't matter. The banks write, please see the petition. For a minute, I will now request your Lordship. That document is in 3357 of 2025. Please see, one document. I also put it in the convenience compilation. Your Lordship may look at the convenience compilation 274. In 274 in the convenience compilation, please see, my lords, the letter of 13th July 2021. The Lordship will find on the very top, my lords, DLT.
Yes.
My lord, this is the lawyer, my lords, for the consortium of banks, writing based on, my lords, my letter. 13th July 2021. State Bank of India versus other so and so, claim number so and so. We refer to our letter yesterday and your present application of court in respect to disclosure. The disclosure application, my lords, is now considered threatening. But given I am here also, my lords, for disclosure. Given the information set below and our previous confirmation that we will be updating the court by way of witness evidence, etc., there is no legal basis for you to proceed. Please ignore. Please see the next slide. Whilst we are still in the process of obtaining instructions to finalize the witness evidence given the complexity surrounding the recent case, we set out below a high-level details of the position as we currently understand it to be. Debt due as of 30th June 2021, 11,102 crores, and ignoring the decimals. Sale of assets released by the Prevention of Money Laundering Appellate Tribunal, 5,766 crores. Therefore, notional balance 5,366 crores. This was, my lords, the lawyers of the banks indicating in 2024. Followed, my lords, by the statement of the finance minister saying that after these 14,000 crores have gone in. In that light, my prayer, my lords, is that your Lordship, my lords, on the first writ petition, which is 24, I had sought multiple prayers. The first prayer there was, my lords, that once they have attached my asset, I have to pay. If I have to pay, I have to sell my asset. If the government of India attach my asset,
no. Now you're pressing on this. You're not pressing on this 24 and 24.2.
Yes, for 24, I don't press only with the prayer that please permit me, my lords, to keep that powder dry, only to urge the point on interest, etc. After I have received a disclosure, I seek no relief at this stage because I don't even know what is recovered.
Then 24.2.
Well, 24.2, my lords, I do not press because 24.2 and 24.1, my lords, are identical petitions by two different parties. I am, my lords, pressing the relief in 24.1 only to, my lords, unnecessarily not get in and join issues on whether, my lords, a person who is declared as a fugitive economic offender cannot maintain a research. In 24.1, my lords, I am limiting my prayers today, my lords, only to the fact that your lordships may direct them, subject, of course, to my lord's consideration.
So let's again look at the prayer.
Prayer, please permit me, my lords, to straight away come to the prayer.
46.
My lords, your lordships will find the prayer in 46. I'll read the prayer, my lords, slowly. your Lordship name, issue a writ order direction in the nature of a mandamus to respondent 2 to 12, where the bank, to provide a statement of accounts for the amounts owed by United Breweries Holdings Limited in liquidation by taking into account the interest accrued periodically and giving due credit to all recoveries made from time to time since the amended recovery certificate dated 10/4/2017 in OA number so and so was issued by the Honorable DRT. B. Issue a writ order direction, etc. to provide a statement of amounts realized by or in their favor and the details of the original owners of the assets utilized for realizing the amount following the amended recovery certificate dated so and so, and a statement of assets owned by United Breweries Limited or third parties and available with respondent number 2 to 12, only what's with them, but not yet utilized for the purposes of satisfying the alleged debt owed under the amended recovery certificate. Issue an order, etc. in the nature of a mandamus to respondent number 1 to apply the recoveries made by the sale of all assets restored to respondent number 2 to 12 under the order dated so and so passed by the special judge CBI Greater Bombay in PMLA case, etc. without treating them as conditional recoveries. This prayer C, is actually, I must candidly indicate, is possibly not a prayer that your lordships will grant me, not that I can't pray. Your lordships will not grant me now, relegating me to that court saying you please go. But this prayer number A and B is a prayer only a constitutional court, a writ court can give to the banks, because the banks are not subject to PMLA jurisdiction. It's not that the PMLA court will take, that's not the criminal court I am fighting. Now, as regards the recovery officer, banks are of course subject to the recovery officer's jurisdiction, but respectfully, the recovery officer is.
So banks are not there before the company court?
Banks will go before the company court. No, in the company court, banks would have been issued notice subsequent to liquidation. But in the company court, the banks went initially for liquidation. Once liquidation happened, they stand as creditors. Therefore, either the OL gets the account or the OA, the recovery officer, gets the account. The recovery officer, your lordship, passes 6 orders saying, give me an affidavit, affidavit is not forthcoming. The OL before the court, indicates that they believe that the banks have received more than what is due. May be correct, may not be correct. The only way that is buttressed, either with the banks filing an affidavit before the recovery officer in the original proceedings, or at the least, filing an affidavit before your lordship. Therefore, I limit my prayer, to A and B, in my respective submission. I'm very, very grateful, I am not placing Rishabh Agro as such, I've left a copy, which says, that the erstwhile director at least has the right and continues to have the responsibility to get the company revived, provided there's an accord on satisfaction of it. I'm grateful.
Yes.
So I assume, my lords, I'm required to address only 24.1. So I will not trouble my lords regarding, and frankly, my lords, I was not, although Mr. Puvaya said that as regards
last occasion, the arguments were advanced in respect of, more in respect of this
that's
24.
No, there also, I just, of course, I'm grateful to my learned friend for having, saved some of your lordship's time as well as my time. I'm sure his time is more valuable.
So we
won't go into that. We won't go into that aspect at all. Now, insofar as the other writ petition also, I think the 2020 writ petition also, my lords, possibly there's nothing that needs to be addressed because they're largely the same.
May I make one prayer subject to my friend?
Yes.
No, I was hinting at that. In fact, you're saying he's busy.
I had to seek one.
Yes.
Grateful.
Yes.
So therefore, I'll restrict myself to only prayers A and B in the writ petition. Now, in fact, if your lordships were to see, I'm not sure why exactly much hue and cry is made about the fact that there are no disclosures. And I'll also address, my lords, why there is a certain element of possibly ignorance / mischief in those documents placed before your lordships today. Because I am personally aware of those proceedings, my lords. I'll also address that. Now, if your lordships were to kindly take our statement of objections in 3357, although, my lords, 3357 is not being pressed, the objections are common for both. So if I may request, my lords, to kindly take 1568. Or I'm sorry, my lords, 1568.
No, even before the recovery officer also, what is the difficulty to
I'll explain that. No, that is actually, that's why I said it's bordering on mischief. All of that emanated from, and I'm grateful, in fact, my lords, that I could. what happened was, and in fact that supports, in fact buttresses my theory that these recoveries, which rather the assets that are restored by the enforcement directorate to me cannot be shown as recoveries in my books. And this in fact is buttressed. I'm sorry, the copy is not very clear, but those proceedings, those proceedings actually emanated from a letter. I'll just read that letter out, my lords. I have the other file, so I'll just refer to that. This is a letter dated 9/7/2025. Now kindly see how all of it started. The enforcement directorate writes to me saying, this office has been apprised of the outstanding dues payable to the employees of Kingfisher Airlines. As you are aware, the Directorate of Enforcement has successfully restituted assets amounting to excess of so and so crores to the SBI-led consortium. It is well established through multiple rulings of the Honorable Courts that employees are to be treated as priority claimants over the assets of a defaulting entity. Pursuant to the discussions held with representatives of your esteemed office, it has been conveyed that a minimum of 200 crores from the restituted assets is presently lying with the recovery officer DRT in addition to funds held by the OL. In this context, it is further understood that the OL is the competent authority to adjudicate employees' claims, effect disbursement in accordance with the directions of this Honorable Court. It has been reliably gathered that the employee dues adjudicated thus far amount to approximately rupees 300 crores, which may be sufficiently met, kindly mark this, from the assets restituted by the ED to the consortium. This itself, my lords, underlines the fact that those assets restored to me are completely subject to what the ED tells me. In fact, your lordships may also recollect, your lordships may have made notes. Of course, I'll assist my lords. These assets are restored to me provisionally, subject to a bond undertaking that I will restore the assets as and when the ED calls upon me to do so. It is pursuant to Section 8, subsection 8 of the PMLA and Rule 3.2 of the rules issued thereunder. So therefore, my lords, those assets are not my recoveries. And in fact, this buttresses my theory. In fact, those assets are restored. Now, tomorrow, if they say, I find that there are 3,000 crores payable to employees. We have restored 14,000 crores to you, pay 3,000 crores. I can't possibly turn around and tell the ED, no, these are my recoveries. Please go find another source to get. In fact, all of that, my lords, is provisionally released to me. I am dictated to by the enforcement directorate. This, my lords, in this case, 300 crores. After that, what I did was I initiated those proceedings. In fact, I went to the recovery officer, those proceedings which Mr. Povaya read. I went to the recovery officer and said, see, the ED has said, I'll just read that entire letter, paragraph 3. Accordingly, you are requested to liaise directly with the OL, extend full cooperation by providing all requisite details and ensure adherence to necessary procedural formalities to facilitate the timely disbursement of dues to eligible employees. Thereafter, my lords, I went to the recovery officer. I presented this letter along with an that IA 1 of 25, your lordships may recollect, in the IA 1 of 25, my lords were to see, I think page 370 odd was what they were reading. My lords will find.
These are proceedings before the recovery.
Correct, proceedings. That IA was in fact filed by me. Now the bone of contention, I'm not in a position to answer why those.
C-71 it is there.
Correct, my lords. Now it is, if my lords were to see that there was subsequently an order passed. I'll just come to that, my lords. There was subsequently an order passed by the recovery officer.
Take that.
In fact, this may not have been necessary, but since it was pointed out, that order was dated 12th of December 25. After that, all of this, my lords may recollect, 12th of December was the first order. Now, kindly see what is held by the recovery officer. IA 1 of 25, filed by me, in TRC number 39 of 22, in OA 766 of 2013. I'll just read it out, it's a short order. The SBI has filed IA number 1 of 25, dated 18/9/25, before the recovery officer in connection with the workman dues for Kingfisher Airlines claimed by official liquidator for an amount of rupees 311 crores so and so, and represented on so and so dates. OL has filed counter on 29/9/25 to release the amount towards ex-employees due to Kingfisher Airlines to the account of OL. However, in the counter, it has not been specified the details of the amount held with the OL. During the hearing, the certificate holder bank has accepted to pay the amount from the sale of shares kept as FDs with the recovery officer. During the hearing on 3/12/25, advocate on behalf of CD3 has informed that they have no objection to release the amount to workman dues for Kingfisher Airlines from the shares. PMLA court has directed the official liquidator to approach DRT via its order dated 10/10/22. However, there is no specific order to release the workman dues. In the circumstances, the CHB recognized the rights of the workmen and their preferential claim, had approached the authority to release the amount held with the recovery officer. The claim of certificate holder bank is satisfied. OL and CD have no objection. So everyone's on the same page. Now kindly see on the next page the order, Malad. The present IA filed by the certificate holder bank is allowed for the release of workman dues since the workman dues have priority. Then Malad, there was some FD in Canara Bank. They're directed to close the FD and release that amount. Then paragraph 10, OL is directed to pay the balance amount to the workman dues of Messrs. Kingfisher Airlines. So all of this, the genesis of those proceedings, since my learned friend brought it up, was all because the ED asked me to pay certain amounts to employees of Kingfisher Airlines who still remain unpaid. Then, my lords, what I did was I approached, because your lordships in fact asked a pertinent question. Am I a party before the company court? Of course I'm a party, my lords. In fact, I filed an application, though both Kingfisher Airlines winding up proceedings, the company petition, as well as United Breweries are still pending. There are various company applications. My learned friend for the OL will also vouch for it. Every week, there are several applications filed, some for release of certain payments, some for collection of rents for of erstwhile properties held by UB. Various applications are being filed on a weekly basis. Now, I filed an application, and in fact, coincidentally, on 27th of March, just about 2-3 weeks ago, this Honorable Court disposed of that application. It was in the interregnum, I think all those orders came to be passed. I'll just read out that order, my lord. All of it may not be relevant. This is, my lords will note, 27th of March. Kindly see who initiated it, the consortium of banks. The OL was the respondent. And I can also vouch for the fact, my lords, that this was not really contested. We were all working in the interests of the unpaid employees of Kingfisher Airlines. So kindly see the prayer, my lords, company application. Therefore, it is humbly prayed that this Honorable Court may kindly be pleased to direct the respondent to declare the amounts held by him and consequently direct the respondent to settle the workman dues in the interest of justice and equity. This application is filed by the consortium of banks and so on. So then, my lords, the learned single judge, the coordinate bench, the company courts rather, deals with the narration of events, extracts the order which I just read to my lords. Then kindly see paragraph 8 onwards, my lords. This order, my lord has it, paragraph 8. This order is the order I just read, 1225. This order has attained finality. It is submitted that rupees 311 crores is the amount due to the workmen of Kingfisher Airlines. It is further submitted that 144 crores is credited to the account of the official liquidator. So we've already transferred 144 crores attached to the company, and the application is filed with a prayer to furnish the details of the amount released to the workmen. Learned senior counsel for the applicant, that's the banks, would submit that since the order dated 12/12/25 has attained finality, the order is to be given effect to settle workmen. Learned counsel for OL would submit that this application should have been filed. This was a technicality which he raised, should have been filed in a winding up proceeding concerning Kingfisher Airlines, and the application could not have been filed in this company petition. It is submitted that in case the amount is to be paid to Kingfisher Airlines, to the workmen of Kingfisher Airlines, then the bank has to release the balance amount which is realized by the consortium of banks. Then at paragraph 12, the learned single judge deals with it. The court is of the view that the applicant banks have to furnish the details as to how much amount is recovered from the sale of assets of UBHL and the sale of assets of Kingfisher Airlines in respect of the properties attached and subsequently released by the enforcement directorate before the consortium of banks. Once the details are furnished, the OL shall disburse the amounts to the workmen of Kingfisher Airlines. Now, my lords will see all of those orders from pages 371 to 378. I can't possibly answer for why those details were not furnished at that point in time, but possibly, my lords, because this application was pending before this Honorable Court. Now there's a clear direction to release the balance amounts, and in fact, I can also submit, my lords, because I myself had appeared. We in fact made a submission that we are ready. In fact, we can't, it's not as if it's a matter of fairness. We are bound by what the ED tells us. If the ED tells us pay 300 crores, we have to pay 300 crores, which is why I've submitted, my lords, these amounts.
Why can't there be a clarity
on how much
amount?
No,
So
kindly
whether
see,
it amounts
it's
to,
there,
it
my
is-
lords.
whether it amounts to recovery to the bank or it is with the ED,
Now,
or
can I
whether
just-
you can do it or not is a different aspect.
Absolutely.
But you know, you
Could I
can
request
always
my lords
ask
to
it-
kindly see then the objections filed in 3357? It's there. It is repeatedly there. In fact, my lords,
You
there are.
said so.
It is there. Kindly see, my lords.
You thought?
It possibly, my lords, this is not to their satisfaction, so which is why they still continue. In fact, I can also point out there's another matter, my lords, which Diageo India has initiated. Even in that, my lords, in 2022, a division bench directed me to file an affidavit. That affidavit also have produced. So only to show that as early as in 2022, I declared how much. My lords, it may be subject to dispute. I may say X, they may say Y, but that's not the point. I have disclosed it.
He's also not arguing on
No,
that.
now kindly see, if my lords has
Page
the
number?
objections in 3357 Kotidira.
I'm looking at it.
3357. Now, before I come to my objections, can I just point out that I had declared it as early as in 2022. Kindly see page 260.
200.
260. The affidavit starts at page.
Objections of your objections.
Yes, ma'am. In 3357. I don't have. It's the same objection, ma'am. 259. This was pursuant to a direction in WP number 1450695 of 18. I was directed even there to disclose how much I've recovered. Kindly see on the next page, 260, paragraph 3. I state that in pursuance to issuance of the recovery certificates, State Bank of India and consortium member of banks are entitled to recover the following amount. OA number so and so. These are the entitlements. Then I state that under the said circumstances, following amounts have been temporarily recovered / restored temporarily to the consortium of banks by the recovery officer DRT. Particulars of recovery restoration by PMLA code so and so amount, balance amount to be recovered so and so. Then, my lords, I go on to explain. This was, in fact, I've even pointed out that may not be relevant in this case, the amount of shares of UBL and so on. Then, my lords, may kindly see in this petition, kindly come to the objections at page number 32.
No. By this statement.
Yes, my lords.
How much is recovered?
10,814. Yes, my lords. That is what is the recovery. I'm a little apprehensive to use the word recovery, but yes, loosely I can use the word recovery. Yes, because it's a temporary. Because these are all accounting terms. Because what I say and what but yes, that is now
that
with the
vary,
banks.
But
yes,
the
yes.
fact remains it is 10,000.
Absolutely. Now that has been disclosed.
Then what is this balance amount to be recovered?
That interest clock is still running. That is what eventually, my lords. All of this is to stop the interest clock at some point, which is why, my lords, now while it's easy to wish away that I will not press Dr. Malya's petition. Your lordships may recollect, but I'll still repeat for your lordships' benefit since it was quite some months ago. All of this started, my lords, when initially there was something called a master debt recast agreement, where Kingfisher Airlines had borrowed vast sums of money. Dr. Vijay Mallya, UBHL, various others stood as guarantors. Default started, everyone defaulted. 2013, we filed an OA. The OA came to be decreed sometime in 2016 or 17 for 6,203 crores plus interest. In the meantime, what happened, Manoj, was the enforcement directorate stepped in. All of the assets, while the OA was going on, all of the assets of Dr. Mallya, UBHL, various Kingfisher Airlines, all of it came to be attached. So therefore, Manoj, that decree could not really be enforced unless certain of those properties could be released to us. But legally, Manoj, they cannot be completely released to us at this stage. Now, there is one provision under the PMLA which states that even while the matter is still going on, of course, after trial, if he is acquitted, there's no question. All those properties have to be restored to whoever it was. If he is convicted, it stands in the name of the central government. I can then approach the central government to have those properties released to me if I can show that I have bona fidely incurred a loss due to the activities of the accused therein. But there's also a provision which was inserted which said even during the trial, I can have those assets temporarily restored because the central government, the legislature was conscious of the fact that trial may take a long time. There may be, of course, this is a big, there may be certain people, well, let's say a small property owner who has incurred a loss. He or she cannot wait till the trial is over. So therefore, I can have that property released to me temporarily by giving a bond undertaking. In fact, the rule requires a bond undertaking stating that I will restore those assets as and when called upon to do so by the central government. So therefore, there are two phases to it. One during the trial, one after trial. We have not reached the after trial stage. Why I'm submitting this is simply this. Now, these temporary, so this attachment has been temporarily, attached properties have been temporarily restored to me. The only way, my lords, this can be restored to United Breweries or Kingfisher or Mallya, whoever it may be, is if the accused eventually come and stand for trial. Otherwise, the status quo will continue. The status quo being that the trial is still pending, that case is not closed. Since the accused present cannot be secured, it is being consistently adjourned. Now, therefore, those provision, I'm not happy with the situation either. I would like to show these recoveries as my permanent recoveries. I am only showing it in my books as provisional because I am bound by what this is why I pointed out, Malad. Those 300 crores is a classic example.
No, that amount will be just lying with the banks.
It'll just be absolutely, Malad. Now, tomorrow, for instance, for whatever reason, the enforcement directorate
Not utilize that money.
cannot, Malad. There has to be a provision made for it in the books of accounts. In the books of accounts, there has to be, and it is a case that a provision is made for it. Because tomorrow, for instance, this case, Malus, 300 crores, let us say, I can't turn around and tell the enforcement director, no, I'm sorry, you restored those assets. I've spent those 300 crores, I don't have it. Even if I don't have it, I have to, I'm bound by what the ED tells me. Because that's what the law requires. So which is why, Malus, now,
whether the interest accrues on that amount or not.
That interest
but
will
whatever, but
because
whatever
no, that is where
recovered with you, and
yes.
What is that? It can be quantified. There
yes,
cannot
no,
be any
which is
difficulty
now
on that.
now that is where really the issue. I can understand, Malad. As a layman, I can sympathize with the petitioners to a limited extent. That it looks as if you have recovered the entire amount. Why is your interest clock still running? The interest clock is simply running because those are provisional recoveries. Now, again, it's an accounting, not problem, but it's an accounting situation. If if eventually the enforcement directorate says, fine, they may even one day say, this man is never coming back. He will never stand for trial. Those provisional, the provisional release of those assets are now made permanent. Immediately, the interest clock will stop. But for that, the ED, who is not a party here, will have to answer. I can't answer for the ED. In fact, if my lords, instead of me, if my lords were to kindly take the PML.
What is the reply or response to this?
They have not filed, not to this.
Now, you want the particulars. According to them, these are the particulars.
The only issue is that there is a contradiction between the particulars disclosure and the statements made by the
as far as the dispute with regard to these particulars, this court cannot decide. What was the senior counsel submitting, saying that we want these particulars? We just want to know whether the interest is accrues on that or not, whether they are entitled or not is a different question. Then they have already answered your question.
Plus, watching your post for orders, file a short note. Plus, we have no further submission. Watching your post for orders will.
No, you have not filed any reply to this.
No.
To this, because these objections are pertaining to all the 3 writ petitions, isn't it?
Yes, same. I mean, as I was submitting,
this is their answer. This is their answer. What is recovered is this, and the balance to be recovered is 6,656 crores.
Just liberty may be granted to file a short note from us. Your lordship may post.
And then I have heard it. Whatever is that would be like your written submissions or your written.
We'll also file
to that.
We'll file. Great.
And what about you?
Please, my lords. I had only 2 objections to make. If my lords would recall, on the first occasion, I said the writ is not maintainable because this is a matter that comes within the exclusive supervisory jurisdiction of the company court. Second, I also told your lordships that there is a company application pending that I have filed against the State Bank of India led consortium for an identical disclosure.
And now the relief that he is seeking is in that in the writ petition where the director is a petitioner, and this director is a party before the company court.
Yes, my lords, please. And this director, including all the directors on the former board of CHL, they're answerable to the company court under various proceedings. As I mentioned earlier, they remain silent. They do not assist me. They do not cooperate with me. They do not appear before court. They do not enable me to further recoveries in the interest of other body of creditors. The bank is not my only creditor today. There are several other creditors unsecured. The bank also is unsecured in the case of UBHL. Now I have to treat all of them equally. The only persons who possess knowledge and information on these aspects are the ex-directors. Today it is strange that they file a writ petition saying, ask the banks to give me information. And if my lords would just have page...
You sought for this information from the bank?
Please, my lords, I have filed for this disclosure.
In the company?
In the company court.
Oh.
My lords may just kindly take a look at the order dated 30th...
Other order, just now, Justice, the senior counsel is
yes,
reading
that
about
bank
what
has filed it against
Justice
me.
Hegde has passed. He says that it is... Know that the details have to be given.
My lords, there are 2 companies under liquidation. What the learned senior counsel was referring to was in respect of Kingfisher Airlines. This application I have filed with respect to UBHL. Kingfisher was the principal borrower, UBHL was the corporate guarantor. So they're treated also slightly different in terms of their liquidation liabilities. So if my lords would kindly have serial number 7, my lords, in the daily orders that I have passed, it's an order dated 30th January 2026. It says oral order in CA number 287 of 2025. That is a connected application filed by another interested party. Learned Counsel for the applicants has filed an affidavit of the Assistant General Manager, State Bank of India, indicating the amount said to be temporarily held by the consortium of banks, in terms of which the total amount is stated to be 10,814.55 crores. The said affidavit is taken on record. When this matter was first argued before your lordships,
Before this court, 1 lakh is reduced.
that my learned friend would have to answer that, my lords.
I wish I had. Sometimes the numbers are so vast, they're mind-boggling.
Yes.
My lords, my submission is this. Along with the disclosure, I have sought various other prayers against the bank. It is not that I'm sailing with the directors or with the bank. I'm looking at the interest of the larger body of creditors, which is not only these banks. There are several other persons, and the claims amount to 17,000 crores.
The court passes an order. They disclose the information, directing them to disclose the information. What is the difficulty to the OL?
My lords, if it's mere disclosure of information, I have no difficulties. It's the other prayers that I am concerned about. If my lords would kindly see prayer C and also
C in
prayer
which,
B.
which case? The one which is only one writ petition, he is restricting his prayer.
Very well. If that, then their submission may be recorded that they're not pressing for
That's what
prayer
they
C.
said. That
If
you
my
can,
lords,
in your written submissions also, you please mention that also, that first writ petition, second writ petition, you are not pressing. And even in the that point 2 also, only those prayer A and B you said, that only you are restricting your prayer to that.
my lords, then prayer B,
Then
I
you
have.
cannot, then in that prayer, I think what you want is also what they want.
My lord, that as regards prayer A. Prayer B, I have a slight concern. My lords may
What is
also
that?
qualify.
Let's see.
Please, if my lords would just have prayer B.
Petition number.
My lords, this is Mr. Daljit Mahal's petition, which is
Yes, Daljit.
356. I'm told the prayers are identical.
3356.
Please. Issue a writ order or direction in the nature of mandamus to respondent numbers 2 to 12 to provide a statement of amounts realized by or in their favor and details of original owners of assets utilized for realizing the amounts following the amended recovery certificate dated so and so. Statement of assets owned by UBHL or third parties and available with respondent numbers 2 to 12 but not yet utilized for the purpose of satisfying the alleged debt owed under the amended recovery certificate. Now, if my lords may just come to section 454 of the Companies Act 1956. It's an elaborate provision which casts a duty on all the KMP, including the ex-directors, to make available to the OL an entire statement of affairs as on that date, including whatever recoveries are pending. And that would enable me to pursue those recoveries. Now, my only apprehension, my lords, is if they utilize this prayer granted by your lordships in prayer B to circumvent the proceedings. They're saying, I filed a writ petition over there. I argued before the court there that I did not have the information. It was the bank. And therefore, I'm not liable
You're
to.
arrayed as which respondent?
I'm 13, my lords.
But they're not asking any relief against you.
There's no relief against me. But what I am trying to submit is there is a statutory duty cast upon them under the Companies Act, not only to give me books and records, to enable me to discharge my duty.
But that you will be taking action.
No,
or,
but I don't want them taking shelter under this prayer over there, my lords. If this were to be allowed in their favor, they must not say that I did not have the benefit of this information. Therefore, I'm not in violation of section 454 and 468. If they're willing to give an undertaking that this prayer won't be utilized over there, in the proceedings under 454, 543 and 468, then I do not have any issues with any disclosures being
because the relief is restricted to respondents 2 to 12. You are 13.
It's 2 to 12, but what they're trying to say is they do not have that information. That information has to be demanded from the banks. And what is this?
If they don't have the information, either they say here or there, they don't have.
My lords, I'll just give my lords one example, my lords. For instance, They have created multiple documentation, multiple third-party agreements with various related parties, and all those agreements are now being set aside by the company court in various proceedings. These are fraudulent preferences, as we would call under the Companies Act. Now, if one of those assets was, say,
No, this precise prayer is, even if the court considers to grant these prayers, I don't think it is going to have any kind of
my lord,
effect
then they may
on
just
the company proceedings that are pending. For the reason, here the court is not saying that whether it is in their custody, whether it is there or not. A particular information they are seeking. No, it is for you to say, no, that's there in their knowledge.
if my lords were to just record that somewhere in the findings, if these writs were to be allowed, then I would not have many objections to make on that aspect.
Yes. So you file your written submissions by Tuesday.
Yes, my lords may, I'm sorry, my lords may also note that I had raised a jurisdictional objection under 446, stating that they could
File your objections.
Very well. My lords, I'll file a brief written submission objections. I mean,
If you want, you can.
Very well.
By Tuesday.
Very well.
All the petitioners shall file the objections by Tuesday, and the respondents, if they choose to file, it shall be filed by Tuesday. Heard, reserved.
Grateful.
Lord, with respect to respondent number 1, as they have withdrawn the prayer C, they will not have much to say.
Respondent number 1, Union.
I am respondent 1. So my burden of any response to that particular prayer would not survive.
But what I feel that it's a kind of situation where whether he's coming to India or not coming to India, but the basic details, particulars, he is entitled to have.
No, he's entitled, but now those details are
And
what are.
no, he is not submitting himself to the jurisdiction of the court. And that's why very cleverly senior has said that all 1 and 3 they are not pressing, only 2 they have pressed.
No, insofar as that also, my lords, those 2 submissions on those fronts. One is, my lords, these are the details that, barring those few numbers here and there, consistently the banks have said this is the stand of the banks. It has not been controverted in other proceedings also, my lords, for instance, where the ED also is a party. In this, ED happens to not be a party. That is the stated position. In fact, even the speech of the Honorable Finance Minister used the words restored, which admits that those were properties that were attached by the central government and restored to the banks. And more, in fact, taking one step back, now, when they come before this honorable court, invoking Article 226, specifically asking for a writ of mandamus, your lordships knows very well, I don't need to place any judgments on record. They will first have to show that there is a public duty on a statutory officer or a public officer which required a particular act to be done. It need not be statutory, it could be under rule or even under contract. And if that officer is failing in his duty, then this honorable court can certainly step in and direct someone to do so. Now, for instance, there is an order that needs to be passed within 30 days. Nobody does it. Certainly, this honorable court can direct the officer to do it. But the question that begs itself is, what is the right? Now, this should not be, and in fact, your lordships may reclaim. In fact, my learned friend got a little upset with me when I made that submission right at the outset. This seems to be a bit of an RTI sort of fishing expedition. Get information, use that for another, which is in fact exactly what my learned friend was apprehending. Some information comes out, use it against the OL. In fact, as she was submitting, these directors now are possibly open to misfeasance proceedings, various. So now, if there is something, it need not be any damning disclosure, but that could be used in some collateral proceeding. That is what our apprehension seems to be. So, which is, your lordships may have to first answer whether there is a public duty which they can now. Of course, now the question as to whether Mr. Malya can knock on the doors of this court, I won't address, since Mr. Povaya very fairly submitted that he will not press. But even for the ex-director, this is the ex-director of United Breweries. Now, what right does he or she have at this stage, 10 years or almost 10 years after the company has been ordered to be liquidated? Much water thrown under the bridge. If the OL asks me, every right she has, every right. Now, if I don't answer her, of course, she may have an issue with that. She does have an issue with me in the company code. But not an ex-director. Then my lords is opening the doors to various people. I may be an ex-shareholder. Ex-director is the person who's knocked on the doors of this court. I may be an ex-shareholder. I may be an ex-chief financial officer. Where does the buck stop then? OL is in charge of the company. OL has every right to ask the creditors or the banks for certain details, but not at their behest. Mr. Malyan on a separate footing, but even this ex-director, even if she is not a, and again, I just one last submission. Although it was said that my submissions were limited only to fugitive economic offender, it's not really. I will be the last one to say that fugitive economic offenders don't have constitutional rights. I'm saying, one, there is no constitutional right. Two, these people cannot pick and choose their fora. In fact, your lordships may recollect, there are contempt proceedings where even the Honorable Supreme Court has expressed its helplessness, saying that we can't secure this person. So at least let us punish him in the manner in which we can, which is to sort of restore the status quo ante because some shares were sold in violation of undertaking. In fact, an honorable division bench just last year, when the matter was pending, it was ordered to be, charges were ordered to be framed back in 2016. 10 years later, finally, this honorable court said, well, there's no point waiting for him. Liberty to revive, we will close the contempt. So therefore, what I was submitting was, they can't pick and choose. Fine, I have a right, I will knock on the doors of this court. I have made a mistake, I have to answer for contempt, I will not show up. That's what I was trying to submit, not economic offender. Grateful.
Cell number 25. Deshpande, Amit Deshpande.
After vacation. Tomorrow only granted is extended.
Cell number 26. Cell number 26. Hussain.
My lord, I'm appearing for respondent number 5 in this case. There is a pending writ petition, my lord, and another petition is to be tagged along with this.
No interim order in this.
No, ma'am.
This is matter after vacation. Huh? See after vacation. This after vacation.
Cell number 27. Nagarajas. P. Krishna.
Yes. Huh?
Exercising the power exercising the power under section 23 of the Act of CH-17. Order has been passed.
He wants to. You don't want to engage an advocate?
No, he's not the.
Then who is he?
No, I'm the father, head of the family, the owner of the property. Then my wife and my son have been just, misguided by these people. They are the third parties. They want to sell my property, which is meant for my daughters.
He is not a party before this court. You can't come before the court when you're not a party.
No, madam, kindly give me data. I will engage an advocate in the present. They are the original documents.
This is
and
not
these
after
people have
vacation.
cheated me.
Granted
They have taken all my original documents.
Number 28.
I appear for respond, my lord. After vacation, my lord.
Yes, this is matter after vacation. Interim order only granted is extended. 31.
30. Cell number 30.
Yes.
They were supposed to file rejoinder. It was his last chance.
This is matter after vacation. 31.
51.
I am for the Union of India, formal party, my lord.
For the respondent.
Submissions can be heard after vacation.
There's no interim order as well.
Huh? This is matter on Wednesday. Yes, 32.
Cell number 32.
I pray for my lord respondent. My lord, may request this habit matter on this Tuesday, my lord. I'll take a necessary instruction and I'll make submissions, my lord, on this matter.
Tuesday.
Cell number 33.
At the request of counsel, respondent bank.
Great.
Yes, 33.
33.
Some other time, it's already 4:47. This is matters. All part third MFAs after vacation.
Let's see.
Serial number 34, my lord. Any particular date kindly be given? Serial number 34, part third matter. Any particular date, my lord?
After vacation on all MFAs, on
5th of June, my lord.
11th June.
11th. Great.
What about 36?
36. Cell number 36.
Filing?
This question does not arise. Only two questions. One is jurisdiction. Whether DRT has been dismissed on limitation ground. As your lordship has been earlier passed the order, delay cannot be condoned by the DRT.
But the two division benches have taken two different views. Now the matter is pending before the.
If so, your lordship, if so, this court, appellate authority is there, jurisdiction. It's a final order passed by the DRT. Within time they have.
2023 matter, we can, the issue is with regard to the limitation. And as the two division benches of this court have taken counter views, now the matter is placed before the full court. List this matter along with so and so.
R3 140.
Yes. Next.
Date fix.
I can't give the date. It will go along with the full bench matter. Yes.
Cell number dismissal 37.
37 LCR is required.
Which year?
2013 matter.
Yes, ma'am.
2013 matter.
Yes, records are
Why
not
is it pending from 2013 without calling for the records? Your appeal. The registry is directed to call for the TCR immediately list after the vacation. That is on 4th of June.
Telephone.
Delete from caption dismissal. Yes, 38.
38.
My lord, I appear for the appellant, my lord. It may be posted after vacation, my lord. Any
Delete from the caption dismissal. Yes, 39.
Cell number 39.
It's the
39
same
lords.
matter. It's the same matter where your lordship had
Which one? 39.
39 for dismissal. It's
Lords, this is a matter that pertains to
You
release
don't
of
even.
subsidy. Lords,
The
I have
matter
been.
is posted for
Lords,
dismissed.
I have
You
been.
come and mention.
Lords, I did
Then,
not.
No, please understand. Then after that, the court will recall.
Lords, I have been interested with the matter now, my lords. I was not on record until yesterday.
We are not concerned with.
Lords,
when
I'll
we are-
argue the matter, my lords, on merits.
Tomorrow. Not
Monday,
tomorrow,
my lords.
that's on Tuesday. This is matter on Tuesday, 39.
Grateful.
It's 40. 40 post.
For responding, my lords. It may be dismissed, my lords. The account is settled, my lords.
Account is settled. Then counsel appearing for the respondent submits that the account is closed and nothing suffices for consideration in this petition. The said submission is taken on record and dismissed as instructed. Yes, 41.
41.
This is matter after vacation. Interim order earlier granted is extended.
Final hearing cell number 42.
This matters also. Give a date.
That is 11.
Yes.
11.
Any other matter?
My lord, serial number 44.
Which?
Serial number 44, my lord.
How many passwords?
4 to 5 hours.
Call that. Call that.
Password matters in list number 1. Cell number. List number 2. In list number 2 only password. List number
Yes.
2 serial number 1.
Yes.
List number 2 serial number 1 password.
This number 2.
Number 1. That is
MFA. IFR. This posted again on Tuesday. Next.
serial number 2.
For the respondent.
Yes. Wednesday.
29. Serial number 8. Serial number 8. Kashyap and Nayak.
Madam, it taken up in June. It takes some time for arguments.
My lords had heard it. According to us, it's a short point, my lords. Whether section 28. Oh, that time. Sorry, then I'm not aware. Then I'm not aware. Very well. They have spoken.
After vacation.
Yes.
Please.
This matter after vacation. Yes.
My lords, may fix a date, my lords. I'm suffering an
This is
interim order.
matter on 10th of June.
So great.
Next.
Number 14. Serial number 14.
Bajaj Finance. How many times this matter will get it be adjourned? This matter on Monday. 14 Monday.
Serial
Yes.
number, serial number 17.
I appear for the petitioner. Short question. There was a OTS settlement, page number 32, may kindly.
Which is the bank? You take
Union
notice?
Bank of India.
You take notice, 17.
I shall take notice.
So and so. It submitted that so and so has instructions to take notice on behalf of the respondents. Yes.
Interim order, not to proceed. We have paid entire amount as per the OTS. Even extra because there was a delay.
Yes. What are your instructions?
50 lakhs.
I shall take the, I shall take instructions. here.
Monday I'll have it. Monday. Yes, next.
Monday, Tuesday.
Tuesday?
Because Monday I'll have to take the instructions.
Yes, Tuesday.
Tuesday.
Serial number 44, Your Lordship. Serial number 44. List
happened to
2.
that?
After vacation, my lord.
It's already adjourned. What happened? 42?
Kindly mention a date, my lord.
Huh?
For a date. Mention any date, my lord. 11. 11/6. Much obliged.
ಇನ್ನೊಂದಾಗಿದೆ ಎರಡು ಒಟ್ಟಿಗೆ ಕಳಿಸ್ತೀನಿ.
Four six.
39, 28. 41, 11, 42, 42 to 44, 11. ನಾಳೆ ಮೊನ್ನೆ
143 of 25. ಅಲ್ಲಿದೆ ನೋಡಿ. ಅಂದ್ರೆ ಅದೆಲ್ಲ ಅದಕ್ಕೆ ಲಿಂಕ್ ಆಗಿದೆ. 5144 ಅದ್ರ ಜೊತೆ ಆಲ್ರೆಡಿ ಲಿಂಕ್ ಆಗಿದೆ. ಅವತ್ತು ಅದೊಂದು ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿದೆ ನೋಡಿ ತೊಳಿ ಅಲ್ಲಿ ಹೈಲೈಟ್ ಇದೆ. ಎರಡಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 14 and 17 ಎರಡೂ ಮಂಡೆ. ಟ್ಯೂಸ್ಡೇ ಇದು 17 ಟ್ಯೂಸ್ಡೇಗಿದೆ.
ಏನ್ ನಂಬರ್ ಸರ್?
ಅದು ಇಲ್ಲಿದೆ ಸಪ್ರೇಟ್ ಆಗಿದೆ. ಇದೇನು ಗೊತ್ತಾ ಸರ್, ಇದು ಇದಿಷ್ಟು ಸಪ್ರೇಟ್ ಇದ್ರೊಳಗೆ ರಾಪದಲ್ಲಿ
ಒಂದು ಮಿಸ್ಟೇಕ್ ಮೇಲಾಗಿ
ನೀವಾ
ಡೇಟ್ ಸೀರಿಯಲ್ ನಂಬರ್
14
ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಾ ಸರ್ ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಾ ಸರ್ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ
ಮುಗ್ದಿದೆ ಸರ್ ಈಗ ಮುಗ್ದಿದೆ
ಇವಾಗ
ಮುಗ್ದಿದೆ ಈಗ
ಇವಾಗ
ಇವತ್ತೊಂದು ಫುಲ್ ಮುಗ್ದಿದೆ.
ಓಕೆ ಓಕೆ ಮೇಡಮ್.